Honourable members, the Deputy Speaker.
I acknowledge the Ngunnawal and Ngambri peoples who are the traditional custodians of the Canberra area and pay respects to elders past and present of all Australia's Indigenous peoples. Almighty God, we humbly beseech Thee to vouchsafe Thy blessing upon this Parliament. Direct and prosper our deliberations to the advancement of Thy glory and the true welfare of the people of Australia. Our Father, which art in heaven, hallowed be Thy name. Thy kingdom come, Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses as we forgive them who trespass against us. And lead us not into temptation, but deliver us from evil. For Thine is the kingdom, the power and the glory, forever and ever. Amen. I present report number 7 of the Selection Committee relating to consideration of committee and delegation business and private members' business on Monday the 2nd of March. The report will be printed in Hansard for today and the committee's deliberations will appear on tomorrow's notice paper. Copies of the report have been placed on the table. Give the call to the Treasurer.
Thanks very much, Deputy Speaker. I present the Treasury Laws Amendment, Building a Stronger and Fairer Super System Bill 2026 and the explanatory memorandum to this bill, and the Superannuation Building a Stronger and Fairer Super System Imposition Bill 2026.
Clerk.
First reading, a bill for an act to amend the law relating to taxation and superannuation and for related purposes.
Treasurer.
Thank you, Deputy Speaker. I move that the bill be now read a second time. Today, we are really proud to be introducing the Treasury Laws Amendment, Building a Stronger and Fairer Super System Bill 2026 to the House. This is all about making Australia's super system stronger and more sustainable. We are making superannuation fairer from top to bottom to help disability and aged care workers, retail and hospitality staff and early childhood educators and nurses get the secure retirement that they need and deserve. So, Deputy Speaker, this bill does two key things. Firstly, it boosts the low-income superannuation tax offset, or LISTO. This will make sure low-income workers receive a fairer tax concession on their super contributions. It's another important part of our government's plan to help low-income workers earn more, keep more of what they earn and retire with more as well. Now, secondly, the legislation will reform super tax concessions so that they are better targeted for large balances. Deputy Speaker, from July next year we will increase the maximum LISTO payment by $310 to $810 and raise the eligibility threshold from $37,000 to $45,000. These reforms will help deliver a more secure retirement for 1.3 million Australians, the majority of them women. It will mean the total number of Australians eligible for the LISTO will increase to 3.1 million people. Our changes will benefit all workers with incomes between $28,000 and $45,000, with an average increase in LISTO payments of $410. These workers could receive a benefit at retirement of around $15,000, depending on an individual's income over their career. The LISTO eligibility threshold and maximum payment amount will also automatically adjust in line with any future changes to income tax thresholds and the superannuation guarantee rate. This will ensure low-income workers receive a fairer tax concession on their super contributions to align with the government's third round of tax cuts taking effect in 2027. Deputy Speaker, the other part of this bill reduces tax concessions available to individuals with total superannuation balances above $3 million. This measure will affect less than 0.5% of all Australians and will take effect from July this year. It will mean the concessional tax rate applying to future earnings on balances between $3 million and $10 million will be a combined headline rate of 30%. Earnings corresponding to balances below $3 million will continue to be taxed at 15% in the accumulation phase, and earnings will remain tax-free in the retirement phase. The concessional rate applying to future earnings on balances above $10 million will be 40%. Now, both the $3 million and the $10 million thresholds will be indexed. These reforms maintain the concessional treatment of superannuation, but ensure it is provided in a more equitable and a more sustainable way. And here I want to thank the superannuation industry and the broader community for their engagement and feedback on this legislation. And I want to thank my colleagues in the Treasury Ministers here and behind me in our team for all of the work that has gone into these important changes. Now, Deputy Speaker, together these changes will maintain concessional tax treatment for super across the board, but they make the system more sustainable by better targeting concessions for the biggest balances to help fund more super for people with the smallest balances. Voting against this bill would be a vote against a fairer super system. It would be a vote against more super for Australians on the lowest incomes. And it would be a vote for bigger tax breaks for those who already have millions in their super. Deputy Speaker, the Australian Labor Party built our superannuation system. And this bill is another important part of our agenda to make it stronger and fairer and more sustainable. It's why we've legislated the objective of super, to provide income for a secure retirement. We've increased the superannuation guarantee so it's finally reached 12%. We're paying super on government-paid parental leave to help close the gender gap in retirement savings. We've legislated payday superannuation starting from July this year. We've expanded the coverage of the superannuation performance test from around 80 products to more than 800. We've legislated to align financial reporting requirements by funds with those of public companies. We've also announced mandatory service standards, and we're reforming the retirement phase of superannuation as well. And today we're introducing this legislation to better target superannuation tax concessions and increase the listo. Now, our superannuation system is the envy of the world, and these changes will make it even stronger and even fairer, so it continues to deliver a more secure retirement for millions of working Australians today and into the future. Full details of the measure are contained in the explanatory memorandum.
The debate must now be adjourned. So the question is that the resumption of the debate be made in order of the day for the next sitting. All those of that opinion say aye. Contrary, no. I think the ayes have it. And Treasurer has the call.
Thank you, Deputy Speaker. I present the Superannuation Building a Stronger and Fairer Super System Imposition Bill 2026.
Thank you, Clerk.
First reading, a bill for an act to impose tax on certain superannuation earnings and for related purposes.
Treasurer.
Thanks, Deputy Speaker. I move that the bill be now read a second time. Today I'm also introducing the Superannuation Building a Stronger and Fairer Super System Imposition Bill 2026. This bill works in conjunction with the Treasury Laws Amendment Building a Stronger and Fairer Super System Bill 2026 to make our super system stronger, fairer and more sustainable. And for all of the reasons I outlined in my earlier speech on that bill, I commend it to the House. Full details, once again, of the measure are contained in the explanatory memorandum.
Thank you. And the debate must now be adjourned. Thank you. The question is that the resumption... You might just need for us to be able to record it. Sorry.
Yes, agree.
Thanks very much. The question is that the resumption of the debate be made in order of the day for the next sitting. That's the question I'm putting to the House. All those of that opinion say aye. To contrary, no. I think the ayes have it. Thank you. And I call on the clerk.
Government business, notice number 1, Commonwealth Entities Legislation Amendment Bill 2026.
Attorney General.
Madam Deputy Speaker, I present the Commonwealth Entities Legislation Amendment Bill 2026 and the explanatory memorandum.
Thank you. Thank you, Clerk.
First reading, a bill for an act to amend the law relating to the Australian Centre for International Agricultural Research and the Australian Safeguards Office, the Australian Trade and Investment Commission and the Office of Parliamentary Counsel and for related purposes.
Attorney General.
I move that this bill be now read a second time. Returning integrity, honesty and accountability to government has been a focus of reform efforts for the Albanese government. In July 2023, we established the National Anti-Corruption Commission, an independent statutory agency to investigate serious or systemic corrupt conduct across the Commonwealth public sector. In September 2023, we established the Parliamentary Workplace Support Service as a statutory authority to make Commonwealth parliamentary workplaces more safe and respectful. In May 2024, we made ambitious and enduring reforms to the Australian Public Service. These changes codified an expectation that the APS builds its capability and institutional knowledge and supports the public interest now and into the future. In making these changes, we ensured the APS was impartial, committed to service, accountable, respectful and ethical. In October 2024, we abolished the Administrative Appeals Tribunal, replacing it with the Administrative Review Tribunal to ensure effective administrative review of decisions made by the Australian Government. In December 2025, we released the Australian Government Appointments Framework, setting out the principles and guidance to strengthen and support the merit-based selection and appointment of individuals to public offices across the Commonwealth. Ultimately, these reforms have been about restoring the public's trust and faith in government and institutions. But there is still work to be done. That is why the government is proud to present the Commonwealth Entities Legislation Amendment Bill 2026 today. The bill makes changes to strengthen appointment safeguards, accountability and integrity of statutory office holders in the Australian Centre for International Research, Australian Trade and Investment Commission, Australian Safeguards and Non-Proliferation Office and the Office of Parliamentary Counsel. Existing arrangements have limited provisions for accountability where conduct or performance are unacceptable. The amendments would expand and clarify the grounds for termination of the statutory office holders and introduce a power to suspend relevant office holders from their duties. The amendments are sensitive to the inherent independence of decision-making by statutory authorities, particularly in relation to the Director of Safeguards at the Australian Safeguards and Non-Proliferation Office. The bill also permits the relevant minister, being the Attorney-General, to exercise a new directions power for the Office of Parliamentary Counsel. Importantly, however, directions issued under this power can only be general in nature, respecting the independence of the OPC. The community expects public officials to perform their duties with the utmost integrity, particularly those that operate at the highest level by leading our statutory authorities. Breaches of the APS Code of Conduct, discrimination, bullying and harassment, and corruption are types of behaviour that are unacceptable in a modern workplace. Failing to prevent or stop that type of behaviour is a failure to keep people safe in their places of work. These amendments will ensure statutory office holders with direct management responsibilities for staff can be removed from office where their behaviour is considered serious misconduct. Statutory office holders should also be held accountable for their performance. If their performance is unsatisfactory, then the government should have options to terminate them from their position. This is the standard expected of most working Australians. It should apply to statutory office holders too. The bill treats the role of the Director of Safeguards differently because of international standards for the chief regulators of nuclear and chemical non-proliferation. It is important for Australia's global standing that the Director operates without suggestion of political interference. For this reason, and in keeping with the principles of regulator independence, the bill limits termination of the Director of ASNO to serious misconduct that is found through a statutory inquiry for breaches of the APS Code of Conduct or findings by the National Anti-Corruption Commission. Through these continuing efforts to strengthen appointments provisions, the government has a clear focus on maintaining the public's trust, faith in our institutions, and ensuring the Commonwealth remains a model employer. I commend the bill to the Chamber.
The debate must now be adjourned. I give the call to Member for Wannon.
I move that the debate now be adjourned.
Thank you. So the question is that the resumption of the debate be made an order of the day for the next sitting. All those of that opinion say aye. To the contrary, no. I think the ayes have it. And I call on the clerk for the next item. Oh. Just one moment. I've just wish to advise I have a report that the Law and Justice Legislation Amendment New South Wales Local Court Bill of 2026 has been fully considered by the Federation Chamber and has been agreed to without amendment, and I present a certified copy of the bill. Thank you. So the question is that the bill be agreed to. All those of that opinion say aye. To the contrary, no. I think the ayes have it. So this bill has been agreed to. Attorney General.
I ask leave of the House to move the third reading immediately.
Is leave granted?
Leave is granted.
Thank you. Attorney General.
I move that this bill be now read a third time.
So the question is the bill be now read a third time. All those of that opinion say aye. To the contrary, no. I think the ayes have it. Clerk.
Reading. A bill for an act to deal with consequential and transitional matters arising from the enactment of the Local Court and Bail Legislation Amendment Act 2025 of New South Wales and for other purposes.
Chief Government Whip.
I declare that unless otherwise ordered, the Australian Security Intelligence Organisation Amendment Bill No. 2, 2025 stands referred to the Federation Chamber for further consideration at the adjournment of the debate on the motion for the second reading of the bill.
Thank you. So I give the call to the clerk for the next item.
Government business. Order of the day number 1. Australian Security Intelligence Organisation Amendment Bill No. 2, 2025. Resumption of debate on second reading.
Thank you. So this question is that this bill be now read a second time, and I give the call to Member Mitchell.
Thank you, Deputy Speaker, and I rise to speak in support of this bill, which represents the next stage in the Parliament's consideration of ASIO's compulsory questioning powers. This legislation follows the passage of the Australian Security Intelligence Organisation Amendment Bill No. 1, 2025, which temporarily extended the compulsory questioning warrant framework under the ASIO Act for a further 18 months until 7 March 2027. The content of this bill adds further weight to that change. It is aimed at providing greater long-term certainty for Australia's intelligence agencies, while strengthening safeguards and modernising the framework in light of the many national security challenges that confront us at both here at home and around the world today. At its core, the compulsory questioning warrant regime allows ASIO, with the approval of the Attorney-General and a prescribed authority, to compel a person to appear for questioning and provide information relevant to serious national security threats. In practice, these powers are used only where voluntary cooperation is insufficient and only where the intelligence at issue is of real consequence to the safety of Australians. If passed, this bill would give expression to 3 key changes. It would make ASIO's compulsory questioning powers permanent rather than subject to repeated sunset extensions, as has occurred in 2006, 2014, 2018, 2019, 2020 and again in 2025. Additionally, it would expand the definition of adult questioning matters to reflect contemporary threats. In addition to espionage, politically motivated violence or foreign interference, the framework would now also cover sabotage, the promotion of communal violence, attacks on Australia's defence system, and serious threats to Australia's territorial and border integrity. And the bill would also strengthen oversight, reporting and administrative safeguards, particularly by tightening the eligibility and termination rules for prescribed authorities, increasing reporting obligations to the Attorney-General and requiring post-charge questioning to be conducted before a retired judge. Deputy Speaker, these are not cosmetic changes. They go directly to the independence, impartiality and accountability of ASIO. ASIO's compulsory questioning powers were created in the aftermath of September 11, that horrible terrorist attack where the global threat environment fundamentally changed forever. They were designed to address critical operational gaps, and namely ASIO's inability to question individuals who refused to cooperate voluntarily, even where those individuals had intelligence of profound national security significance. And terrorism has always proved resistant to our standard mechanisms of justice. Regrettably, the gap hasn't disappeared in the years since. Indeed, if anything, it has widened. And in the aftermath of Bondi, I endorsed the government's approach and ASIO's request for these powers being made permanent. As we stand here in 2026, Australia faces a much more complex and volatile and contested security environment than we did 2 decades ago. Arguably, since September 11, the intelligence framework has gotten even worse for agencies in the West, and more difficult and more challenging. Intelligence threats are more diverse, more networked, more ideologically fragmented and more technologically enabled. In that context, it's essential that Parliament give ASIO a lawful but carefully controlled capacity to compel information from individuals who are terrorists, who want to commit terrorist acts, who would otherwise withhold it for the purposes of terrorist acts, especially when we know that the acquisition of that information could prevent serious harm or danger on a mass level to large amounts of Australians and Australia's national security. Legitimately, there are concerns about overreach. I have to say, while we're here today, I regard the program on Four Corners last night as an example of undermining of our National Security Agency. We should be careful about the legislative constructs for overreach, but when we hear the ASIO Director-General make an unprecedented intervention in the public domain, we should also know that it is not the role of journalists to undermine national security agencies without absolutely certifiable and trusted information that is reliable. And I think we have to take seriously the Director-General's message in public about the protection of ASIO. It is, in my experience as a former minister and as a member of this House, one of our best agencies. It works reliably and diligently in the national interest. It's careful, it's lawful, it's methodical, and it does its job. Of course, when we talk about overreach, my colleague and the then Shadow Home Affairs Minister, Mr Hastie, acknowledged that in the second reading debate on the predecessor bill, there are people on both sides who approach powers with caution. The opposition has always been alive to these concerns. It's why we committed in 2001 and after to have these mechanisms sunsetted, to have them closely scrutinised, to go before the Parliamentary Joint Committee on Intelligence and Security. And we've always believed in the proper construction and the proper oversight of the Parliamentary Joint Committee on Intelligence and Security and inquiries into this bill. In the course of that inquiry, including through detailed questioning of the ASIO itself and other witnesses, the concerns have been tested and I believe met. Some contributors to that inquiry argued compulsory questioning powers are inherently excessive and should not be broadened. Others suggested infrequent use demonstrates that they're unnecessary. Ultimately, while in a parliamentary democracy which is committed to the rule of law and freedom, we understand those arguments. We also understand that terrorism is a very thorny problem, ideological-based terrorism. Agencies require special power to be able to tackle that, not just after the episodes happen, but in advance, while they are happening. And the fact that these powers are rarely used should give us confidence as a parliament that our ASIO is doing the right thing. But they must have the power available. That's the purpose of government. That's the purpose of ASIO. to be available and ready to act to protect the lives and safety of law-abiding citizens at critical moments in time. So that's why we believe the evidence points in the other direction. These powers have only been used 20 times in more than 22 years. That's a reason for every member of this House to have confidence in ASIO. To us, that's not a sign of overreach. It's restraint, proportionality, and the disciplined operational judgment of an agency dedicated to Australia's national security. They are in effect a last resort. Those numbers show that, and they've historically only been used where other intelligence gathering agencies have failed and avenues of methods of interrogation. Witnesses before the committee struggled to identify any evidence or abuse of these powers, because there is none. They were given no concrete examples of systemic problems or that these are inappropriate at a moment of national crisis or when a person wants to commit serious harm against fellow Australians or against our country. These safeguards are working, they've always been firmly in place, and they would remain in place under this legislation. In the first instance, the Attorney-General must be satisfied that a compulsory questioning warrant is necessary. The Inspector-General of Intelligence and Security also retains the strong oversight powers, including the ability to be present during the questioning and provide real-time scrutiny, another protection, a very important protection. ASIO cannot arrest, charge or prosecute. Remains the case. It cannot gather evidence for criminal prosecution. Its activities remain subject to scrutiny by the IGIS, the Administrative Review Tribunal, the PGCIS and the Attorney-General. We have layers upon layers of oversight and scrutiny, as we should, but they exist, they are robust, and they work. This bill also strengthens the framework governing prescribed authorities, further reinforcing independence and oversight. So, Deputy Speaker, the opposition will be supporting the passage of this bill. We do so because the changes it encompasses are reasonable and responsive to the threats that Australia faces. We've just seen the tragic attempt at Bondi to undermine national security, to directly threaten not just Australians of Jewish descent, but to threaten the safety and order of our streets, to strike fear and terror into our whole society. As a society, we stood up and resisted the terrorists at Bondi, and we've said to them they will not strike fear and terror into our hearts or on our streets or divide us further. The country has come together. But we would be naive not to understand that we are living through a period of increasingly dynamic and dangerous security risks. Our agencies need special powers to deal with that. They must be contemporary. The risks are more numerous and more acute than that they were under contemplation in 2001 when the first tranche of this legislation came through. When we had 9/11, we now have the prospect of digital and cyber and radicalisation online almost every day, all around the world. So the critics that are arguing that this legislation is unjust because it could compel innocent people to undergo questioning are not thinking this through. I can say to this Parliament that we support the government on this because both the Labor Party and the Liberal Party and the National Party, the parties of government in this House, the parties of government in the Senate, understand intelligence work and understand that our security agencies are dedicated to this country and our national security. And I want to take a moment today after a difficult 24 hours for the ASIO and after a unwarranted assault on them through the media, after some unwarranted questioning by some parliamentarians over the past few months, just to say to the ASIO, we know that the brave men and women that work in there are as brave as every frontline responder in the police, in the other agencies of government that work for our country. We know that they're actually in there protecting our national security every single day, that they care deeply about the safety of every Australian, that their work is vital. Intelligence work in the modern era is as vital as any other part of the government's function, and we must have them supported. We must have them know that this Parliament believes in their mission, understands that they are passionate Australians of all backgrounds working together to prevent strikes and undermining of our country. So in short, the opposition, the Liberal Party, the National Party, every single member of the Liberal and the National Party supports ASIO. We support the work of the men and women that take on that cause every single day on behalf of our country. We know it is serious. We know that what they consider every day is actually a threat to our safety and security. We know that the pressure is high on an agency like ASIO. The capacity for error is high because it is intense, it is fast-paced, it is serious. These are bad and evil actors all around the world, and sadly within our country that want to do harm to other people. And one of the shields, one of the protections that we have is the ASIO. So we'll be supporting this bill. We commend the government on keeping pace with national security measures. We especially commend them for keeping pace with those measures in the wake of our worst onshore domestic terrorist incident. We must reinforce our security agencies. We must support the work of our intelligence agencies. And for that fundamental reason, we thank the government for the introduction of this bill.
Hear, hear.
Give the call to the Attorney-General.
I move that the debate be adjourned and the resumption of the debate be made an order of the day for a later hour this day.
So the question is that the debate be adjourned and the resumption of the debate be made an order of the day for a later hour this day. All those of that opinion say aye. Contrary, no. I think the ayes have it. I'll call on the clerk.
Government business, order of the day number 2, National Commission for Aboriginal and Torres Strait Islander Children and Young People Bill 2026. Resumption of debate on second reading.
Just before the debate is resumed on this bill, I remind the House that it has been agreed that a general debate be allowed covering this bill and the National Commission for Aboriginal and Torres Strait Islander Children and Young People Transitional Provisions Bill of 2026. And I give the call to the member for Barton.
Thank you, Deputy Speaker. They are dramatically overrepresented in our systems that intervene with things where it goes wrong, like child protection, out-of-home care and youth detention, while being underrepresented in systems that provide opportunities, stability and early support. When we say Aboriginal and Torres Strait Islander children are far more likely to be removed from their families or detained at a young age, we are not talking about isolated failures. We're talking about patterns that repeat across jurisdictions, across generations and across policy cycles. And during my time at St Vincent's de Paul Society as a regional director, I had the opportunity to look after the Vinnie Support Centre, but also work very closely with Vinnie Services. And I do recall a number of the workers in those teams telling me that sometimes children come to their attention and they've already been failed by multiple agencies. Very similar vein of what was presented through contributions from the member for Warringah. Health concerns flagged by not being followed up. School disengagement noted but unsupported. Family stress recognised but left to escalate. By the time the system intervenes decisively, the harm is already entrenched. That is the cost of disconnected systems and absent accountability. This bill responds to that reality by establishing a National Commissioner whose sole focus is Aboriginal and Torres Strait Islander children and young people, not as an add-on to an existing role, but as a dedicated national advocate with real authority. The creation of a National Commissioner fills a long-standing gap in our governance framework. While there are many individuals and organisations that are doing very important vital work in the states, territory and community level, there has been no single independent national voice empowered to look across systems, identify where they are failing and press governments to act. The Commissioner established under this bill is not intended to manage programs or deliver services. Instead, the role is designed to ask the harder questions. Why do the same problems keep occurring? Why do the same children keep cycling through the same systems? And why does reform move so slowly when the consequences are absolutely very severe? The Commissioner will provide advice that is informed not only by data and policy analysis, but by the voices and experiences of children and young people themselves. This bill ensures that those voices are no longer an afterthought. One of the most important features of this legislation is that it deliberately moves away from a deficient-based narrative. Rather than defining Aboriginal and Torres Strait Islander children and young people solely by disadvantage, this bill recognises their strengths, cultural knowledge, resilience, leadership and connection to community. The Commissioner's role is not just to identify what is broken, but to highlight what works and to promote approaches that are community-led, culturally safe and evidence-based. That matters because too often good practice exists in the pockets but never scales up. Programs that succeed in one place fail to influence policy elsewhere. Lessons are learnt, then they're forgotten, then they're relearnt a number of years later. A nationally coordinated commission helps break this cycle. This bill equips the National Commissioner with a broad and practical set of functions. The Commissioner will be able to examine how Commonwealth policies and programs affect Aboriginal and Torres Strait Islander children and young people, and to advise government on how those policies can be improved. They will be able to investigate systemic issues, not individual cases, and make recommendations aimed at preventing harm rather than responding to it after the fact. They will be able to speak publicly, to advocate independently, and to engage directly with children and young people across the country. Importantly, the Commissioner will also play a role in supporting young people to understand and assert their own rights. That empowerment is very critical. This Commission helps ensure that children know they have a voice and that voice matters. Deputy Speaker, one of the consistent failings in this policy space has been the absence of sustained accountability. Targets are set, reports are written, recommendations are accepted, but then what happens? This legislation embeds accountability by giving the Commissioner the power to monitor, report and advocate over time. It creates a mechanism that cannot be quietly wound back when attention shifts elsewhere. This is particularly important in areas such as out-of-home care and youth justice, where Aboriginal and Torres Strait Islander children continue to experience disproportionate harm. The Commissioner will be able to draw attention to systemic drivers like poverty, housing insecurity, intergenerational trauma, and a lack of access to services, and to push governments to address causes, not just the symptoms. That work directly supports the Closing the Gap framework and strengthens our collective ability to meet those commitments. Now, I had the opportunity to also listen to a number of contributions, including the member for Moncrief, and I do recall that she spoke about duplications. This commission is not about duplications. The National Commissioner will work alongside state and territory children's commissioners, guardians and advocates, as well as other Commonwealth roles, including the National Children's Commissioner and the Aboriginal and Torres Strait Islander Social Justice Commissioner. The bill establishes clear pathways for collaboration and referral, ensuring issues are handled by the most appropriate body while maintaining a national overview. This coordinated approach reflects the reality that children's lives do not fit neatly within bureaucratic boundaries. Their experiences across jurisdictions, portfolios and responsibilities in our systems must be able to do the same. The decision to establish this commission through primary legislation is deliberate and necessary. Without legislative backing, the role lacks the independence, the authority and durability required to drive change. Interim or administrative arrangements simply do not provide the tools needed to conduct inquiries, compel information, or report formally to Parliament. Legislation sends a clear message that this commission is not temporary, discretionary, or symbolic. It is a lasting part of our national architecture, and that matters, particularly to communities who've seen too many well-intentioned initiatives come and go. The call for a legislated National Commissioner has not come from government alone. It has come from Aboriginal and Torres Strait Islander advocates, leaders, and organisations over many years. More than 70 organisations have publicly supported the establishment of this role, recognising the need for an independent national body dedicated to children and young people. The development of this bill has been informed by extensive consultation and the involvement of the current National Commissioner, Adjunct Professor Sue-Ann Hunter, has been integral to shaping its design. The legislation also reflects agreed minimum standards developed through shared decision-making processes with Aboriginal and Torres Strait Islander leadership and governments. This is reform grounded in partnership, not imposed from above. Since the Commission was established in early 2025, meaningful work has already begun. Relationships have been built with community-controlled organisations, networks have been formed across jurisdictions, and advice has been provided on policy reforms affecting children and young people. Foundational work, including the development of child-safe and culturally appropriate engagement frameworks, has laid the groundwork for the Commission's future role. This bill ensures that work is not only continued but strengthened. Deputy Speaker, this legislation represents an opportunity to do something that has too often been delayed, to implant accountability, elevate voices, and confront systemic failure with honesty and resolve. Aboriginal and Torres Strait Islander children and young people deserve systems that see them, hear them, and support them to thrive. They deserve policies shaped with them, not just for them. By passing this bill, we take a meaningful step towards the future, one where government listens earlier, acts smarter, and remains accountable much longer. Thank you.
Thank you. And I call the Minister for Social Services.
Thank you, Deputy Speaker. All children and young people deserve to grow up with their rights, interests and well-being protected. I'm very pleased to say that the National Commissioner for Aboriginal and Torres Strait Islander Children and Young People is joining us today in the gallery to see the final stages of what we hope will be the passage of this very important legislation. I want to thank all members who spoke in this debate, and particularly those members who supported the bill. I say to those members who have indicated that they won't be supporting this bill, that I understand what some of them have said about not wanting to replace real action with bureaucracy, and I want to reassure them that that is the very furthest thing that we intend with this bill. The simple truth is that we have let down children and young people in this country, particularly Aboriginal and Torres Strait Islander children and young people, over many decades. And we set out some targets in the Closing the Gap strategy, and in many areas we're going the wrong way on those targets, or the inequalities that have been identified are stubbornly persistent. We can't keep doing the same thing and expect to get a different outcome. We need to change what we're doing. And in both Lil Gordon, the Interim Commissioner, and now in Sue-Ann Hunter, the Permanent Commissioner for Aboriginal and Torres Strait Islander young people, we have extraordinary advocates who I am convinced will make a difference to some of these stubborn inequalities that we are determined as a government to shift. We know there is more that we need to do as a government and as a nation to shift this inequality. We expect more from the states and territories. We know that communities and families need to be supported to deliver more for the children they love and care for. These bills will legislate the National Commission for Aboriginal and Torres Strait Islander Children and Young People under new primary legislation. This will be the first permanent statutory agency independent from government with a dedicated focus on promoting the rights, interests, development, safety and well-being of Aboriginal and Torres Strait Islander children and young people. This bill empowers the National Commissioner to speak directly with Aboriginal and Torres Strait Islander children and young people and drive greater accountability for the systems and policies that affect those young people. The government will invest $33.5 million over the forward estimates and $8.4 million ongoing to ensure that the National Commissioner can deliver on their statutory functions and responsibilities. Legislating an independent National Commissioner responds to decades of advocacy by many First Nations leaders. When we get it right for children and young people, our nation benefits. When we get it right for this generation, every subsequent generation benefits. I commend the Office of the Commissioner and the bill to the House, and I move that the bill be now read a third time. Not yet, okay.
The question is that the bill be now read a second time. All those opinions are aye. Ayes have it. I call the... So I put the question that the bill be now read a second time. All those opinions are aye. All those against? No. I think the ayes have it.
I think the noes have it.
The noes have it. Division required. Ring the bells. Yeah.
Thank you. Lock the doors. Order. The question is that this bill be now read a second time. The ayes will pass to the right of the chair and noes to the left. And I appoint honourable members for Werriwa and Bean as tellers for the ayes, and the honourable members of Bowman and Capricornia as tellers for the noes. We go. Order. The result of the division is the ayes 95, noes 39. So the question therefore is resolved in the affirmative. Call on the clerk.
Second reading, a bill for an act about the National Commission for Aboriginal and Torres Strait Islander children and young people and for related purposes.
Yeah, I might just call. I just need a bit of order in the House so I can hear the clerk. Give the clerk a call for the next. Thanks.
Second reading. A bill for an act about the National Commission for Aboriginal and Torres Strait Islander children and young people and for related purposes.
Thank you. Thank you. I have received a message from Her Excellency, the Governor-General, recommending, in accordance with Section 56 of the Constitution, appropriation for the purposes of this bill. Now, is leave granted for the third reading to be moved immediately?
Leave is granted.
Thank you. Minister.
I move that the bill be now read a third time.
I'll put that question. All those of that opinion say aye. To contrary, no. I think the ayes have it. Clerk.
Third reading. A bill for an act about the National Commission for Aboriginal and Torres Strait Islander children and young people and for related purposes. And business. Order of the day number 3. National Commission for Aboriginal and Torres Strait Islander Children and Young People Transitional Provisions Bill 2026. Resumption of debate on second reading.
So the question is this bill be now read a second time? And that's the question I'm putting to the House. All those of that opinion say aye. To contrary, no. No. I think the ayes have it. Is a division required? Lock the doors. Oh, no, sorry. Call the division. I'll do 4 minutes. Yep. No, just to be clear, the House is divided. Thanks. Thank you. Lock the doors. The question is that this bill be now read a second time. I appoint the ayes will pass to the right of the chair and the noes to the left. And I appoint the honourable members of Werriwa and Bean as tellers for the ayes, and the honourable members Capricornia and Bowman as tellers for the noes. Order. The result of the division is 97 ayes and 39 noes. Therefore, the question is therefore resolved in the affirmative. And I call on the clerk.
Second reading.
Order.
Second reading, a bill for an act to deal with transitional matters arising from the enactment of the National Commission
Members,
for Aboriginal
please
and
leave the
Torres
chamber quietly.
Strait Islander Children and Young People Act
Clark, I don't think your
2026
microphone is
and
on,
for
sorry.
related purposes. Microphone not working? Well,
We didn't hear a thing of that. It's on. Okay, I'm giving the call to the clerk, but before I do, could members please leave the chamber quietly? Thank you. Clerk.
Second reading, a bill for an act to deal with transitional matters arising from the enactment of the National Commission for Aboriginal and Torres Strait Islander Children and Young People Act 2026 and for related purposes.
Thank you. Is leave granted for a third reading to be moved immediately?
Leave's granted.
Thank you. And Minister.
I move that the bill be now read a third time.
I'll put that question. All those of that opinion say aye. To the contrary, no. I think the ayes have it. And I'll call on the clerk for the next item of business.
Third reading.
Oh, sorry, the third reading.
Third reading, a bill for an act to deal with transitional matters arising from the enactment of the National Commission for Aboriginal and Torres Strait Islander Children and Young People Act 2026 and for related purposes.
Thank you. And the next item of business, please.
Government business, Order of the Day number 4. Defence and Veterans Service Commissioner Bill 2025. Resumption of debate on second reading.
Yeah. Thank you, and I understand it is the wish of the House to debate the order of the day concurrently with the Defence and Veterans Services Commissioner Consequential and Transitional Provisions Bill of 2025. If there's no objection to that, then that is the course that I will be following. And so the question is that this bill be now read a second time, and I give the call to the member for Herbert.
Thank you, Deputy Speaker. To all those that continue to wear the uniform, our veterans and your families, the freedoms that we enjoy today are on the back of hard-fought battles, wars and sacrifice that you have made. Through natural disasters, peacekeeping, combat operations, our Defence Force members have served with honour and distinction. And when those transition out, they expect to get looked after, to make sure that their government has the policies, the framework to make sure that they get the support that they need. But tragically, we have seen far too many of our brave men and women succumb to their war within. Served their nation proud, but died by suicide. That is a national shame. It is something that we in Parliament should never accept as being a normal or a reality. Our veterans, our Defence Force members deserve the respect, the dignity and support that they need. And establishing a National Commissioner is a step in the right direction. And the Coalition called and established for the Royal Commission into Defence and Veteran Suicide, because veterans and their families deserve truth, accountability and reform. We took that step recognising that too many families had been ignored for too long and confidence in the system was broken. The Royal Commission confirmed that families in the ex-service community had been what families in the ex-service community had been saying. There were systematic failures and it required systematic oversight and structural reform. It made clear that lasting reform requires independent, system-wide oversight across the defence and veteran ecosystem, not oversight embedded within departments. One of its most significant recommendations was the creation of a permanent, independent statutory oversight body to drive reform and measure progress. These bills are intended to give effect to that recommendation, and the Coalition supports that objective. Independent oversight with real powers, public reporting and parliamentary accountability is essential if reform is going to be genuine, measurable and sustained. Oversight bodies without teeth do not drive change. They produce reports that gather dust. Establishing the Commission through standalone legislation is the right model, and it is the model the Coalition argued for from the beginning. The government's original attempt to create the Commission through a late amendment to unrelated legislation was rushed, poorly handled, and lacked proper consultation with Parliament and the veteran community. A major structural reform body should never be created through a last-minute legislative insertion that undermines confidence and scrutiny and the importance of it. Parliament was asked to wade through a complex oversight body with limited visibility and limited stakeholder engagement. That is not how serious veteran policy should be made. The Coalition supported the amended Vets Bill only to avoid delaying long overdue compensation and rehabilitation reforms for veterans, not because we supported the government's process or structure. We made it clear at the time that the Commission should be established through a standalone legislation, entirely separate from Defence and DVA, with stronger independence and guarantees. We moved an amendment to ensure that a dedicated Senate inquiry could provide proper scrutiny of the Commission model. That inquiry confirmed widespread stakeholder concern about independence, structure, powers, family inclusion and clarity on remit. Many of the improvements, including the true independence of this standalone bill exists because of the scrutiny that was forced, not because they were built into the government's original design. During the Senate inquiry, stakeholders were clear that the Commission must be genuinely independent from Defence and DVA, have clear authority and operate transparently, and this bill is stronger because of the contributions of those individuals and ex-service organisations. The inquiry and information gathering powers are appropriately strong because weak oversight powers produce weak oversight outcomes. Those powers are balanced with safeguards, warrants, procedural fairness and the rights of response, which ensures both effectiveness and fairness. Public reporting and mandatory tabling in Parliament are critical. Oversight only works when findings are visible and cannot be buried inside agencies. Mandatory government responses within set timeframes matter. Recommendations must trigger action, not silence. It is also important to put on the record that this is not a new idea from this government. The Coalition introduced legislation to establish an independent National Commissioner for Defence and Veteran Suicide Prevention back in 2020. And my friend, the member for Gippsland, stood next to me and the then Prime Minister in the courtyard after meeting with families and ex-service organisations and announced this as a policy, as a bill, as something that we wanted to bring forward to make sure that we weren't going to be burying any more of our bravest by having a strong, independent National Commissioner who would investigate and shine a light into where the problems have been, to learn from it, so we could make sure that our people were not dying by suicide. The bill that we proposed as an independent statutory oversight body was basically the same structural features that is now being implemented, but some 6 years later. Labor opposed that legislation at the time, and it was for political purposes. Their stated position then was that a Royal Commission was necessary first, but then rejected an immediate independent oversight mechanism that could have begun driving reform and accountability years earlier. As a result, the establishment of an independent statutory oversight body was delayed. The delay matters because early independent oversight working alongside the Royal Commission could have accelerated system reform, earlier accountability across DVA and Defence. The structure Labor is now implementing closely mirrors what the Coalition proposed after having voted against it. It is fair to say that if the Coalition's National Commissioner model had been supported instead of opposed, independent oversight would already be mature and operating. The Coalition will support this framework now because veterans and their families cannot afford further delay, but the history should be acknowledged. And Labor has put politics ahead of veterans' wellbeing 5 years ago and is finally delivering on the Commission. Later today I'll be moving an amendment to this bill, and I'll speak to that later. It is important to note that the National Commissioner is not here to pull out every individual case. It is to look at the systemic problems, the failures, shine a light on it, make sure we learn from it. So I'd really like the National Commissioner not to have a job. I'd like that person not to have to review what the coroner's written, speak to people in defence, speak to families who are heartbroken because their loved one has succumbed to their war within. We shouldn't have lost more people by suicide on Australian soil than we ever did in combat. It is not good enough. And it's a failure of consecutive governments. I don't care what colour shirt you wear. I stood in the back corner during the pandemic where we had to have a lectern where we weren't allowed to sit in our chairs. And I looked up to the gallery and I saw mothers of those sons who have died by suicide holding their photos. And I remember looking up, going, I'm sorry. I think every suicide that has happened since I've been elected means I've failed. We have failed. And the families have this part of their heart ripped out. And then we argued and debated and didn't act in the best interests of these families. And we divided, and it was politicised, and I don't think any political party was immune to it being politicised. It was horrible. It didn't bring their loved ones back. Didn't make their heart get filled with love again. But we have an opportunity now, an opportunity to make sure that we're putting in legislation that is right. Because I don't want to bury any more of my friends. I don't want families to bury any more of their sons and daughters. Wives and husbands burying their loved ones. Children growing up without a parent. And mums and dads growing up without growing older without their children. That's not what I want to see. And I think it's important that we, whilst debate this and highlight different areas, that we do it with the one thing in the front of our mind, which is we only sit in this place because of the brave, heroic actions of our Defence Force personnel, our veterans and their families. We owe it to them to make sure that we're doing everything we can to look after them, make sure we're doing everything we can to get them the help they need if they need it. Not all veterans are broken, some of us are. We're veterans, not victims. We want hand-ups, not handouts. But the Parliament's job is to make sure that they can get the support that they need. And I do want to again thank the member for Gippsland, because it wasn't an easy time when we were talking about the National Commissioner and the Royal Commission and a global pandemic and everything that was happening. And I remember having a long chat with him about, what's right. And it's very easy to get caught up in the political turmoils and what your political parties or the government or opposition are doing. But it's right to stand up and say, you know what, this is long overdue, it needs to happen, and we need to be sitting with the families and not saying, this is what you get. We're asking them what they need because we failed them. Thank you.
I call the member for Dixon.
Thank you, Deputy Speaker. I consider myself to be very lucky to be representing an electorate that has a large veterans and defence population. Gallipoli Barracks is right on our doorstep, and we have approximately 3,500 veterans, approximately more than I think now, 2,000 serving members of the Defence Force. They're spread out across Warner, Albany Creek, the Hills District, and we really value our veterans and defence community. Last month, I had the privilege of visiting Gallipoli Barracks with Minister for Veterans Affairs, Matt Keogh. But it wasn't the first time that I have had the opportunity to visit Gallipoli Barracks. Over 10 years ago, before I got involved in politics, and while I was still recovering from post-traumatic stress disorder myself, I was invited to Gallipoli Barracks on Are You OK Day to talk with serving Defence Force members about my personal experience with post-traumatic stress disorder, to talk through the real struggle every day that was getting out of bed, that was combating fear. And I got to talk directly with individual Defence Force members at their desks about their stories, about the sacrifices that they had made, about the sacrifices of family time, of being away a long time, of witnessing things overseas that almost all of us will never have to experience. I stood next to one one serving Defence Force member who had got back to work only recently in the last few weeks before I spoke at the barracks, and we talked directly about our experience of post-traumatic stress disorder. He was in tears, I was in tears, and I can tell you those stories and those conversations that I had over 10 years ago have stayed with me to this day. Gallipoli Barracks sits just outside the boundaries of Dixon, and for decades it's really shaped the character, the rhythm and the identity of our local community. I love that Defence personnel and their families proudly call our Dixon suburbs home, and their presence is felt in every single corner of my electorate. They're not just residents, they are neighbours, teammates, volunteers, mentors and leaders. You see our veterans and serving Defence Force members. They're coaching the junior footy team on Saturday mornings, helping out at school fetes, supporting local small businesses, lending a hand wherever our community needs. Our local RSL sub-branches, they're not just a place for mateship and for really recognising the contribution that veterans and our defence community make every single day. They're also a lifeline. They are a real lifeline for our whole community, but for so many families as well. Their service to our nation is something we honour deeply, but their well-being and the well-being of their families is something we have, as all elected members, a responsibility to protect. The Albanese Labor government is squarely focused on improving support for veterans and their families. It's why we've launched a new $24 million veteran employment transition program. We allocated in the last parliament $500 million to fast-track compensation claims for our veterans, with about an extra 500 people being employed to make sure they get done as quickly as possible. We also announced a $78 million for a new veterans and family wellbeing agency, which I think is incredibly important. That is why the establishment of this independent Defence and Veterans Commission represents such an important and long overdue step. For too long, many veterans and their families have been let down by systems that were meant to support them. These are people who step forward to serve their country, often at great personal cost, only to find themselves navigating a confusing, fragmented and sometimes indifferent system when they needed help the most. The Royal Commission into Defence and Veteran Suicide laid bare the scale of the problem. It revealed not just isolated failings, but deep, systemic issues that have persisted across governments, across agencies and across generations of our veterans. The Royal Commission made it clear that what was needed was not another review, not another temporary task force, and not another layer of bureaucracy. What was needed was an independent body with real authority, a body with the teeth to look at the whole system, not just individual cases, and the mandate to drive meaningful, lasting reform. A body capable of identifying systemic risks, holding agencies accountable, and ensuring that the voices of veterans and their families are not only heard, but placed at the very centre of decision-making. The Independent Defence and Veterans Commission is designed to do exactly that. This commission will provide independent oversight and shine a light on the issues that have been allowed to persist for far too long. It will report directly to the Minister and the Parliament, ensuring transparency and accountability at the highest levels. It will have the power to investigate, to compel information when necessary, and to scrutinise the performance of agencies responsible for supporting defence personnel, veterans and their families. Importantly, it will not be limited to reacting to crisis. It will be proactive, which I think is incredibly important, identifying emerging risks and recommending reforms before problems escalate. And at every step, it will ensure that the lived experience of veterans and their families is respected, valued and acted upon. For communities like Dixon, this matters deeply. With Gallipoli Barracks on our doorstep, we understand better than most the challenges that defence families face, the frequent relocations, the long periods of separation, the uncertainty and the unique pressures that come with military life. When defence members transition out of service, they deserve a system that supports them, not one that leaves them navigating a maze of agencies, forms and conflicting advice. They deserve clarity, compassion, a clear pathway to the services that they need. Their families deserve confidence that help will be there when they need it, whether that's mental health support, financial assistance or guidance through the transition process. And our serving members deserve to know that wellbeing is actually a national priority, not something that is considered only after their service ends, but something that is protected throughout their entire career and beyond. This reform is about rebuilding trust that has been eroded over many decades by systems that were too slow, too complex, and too disconnected from the real experience of veterans and their families. It is about ensuring that no veteran feels invisible, unheard, or left to struggle. It is about acknowledging those sacrifices made by those who have worn our nation's uniform and ensuring that the systems around them finally serve them back. When someone puts their hand up to serve Australia, they should never have to fight for support when they return home. The Independent Defence and Veterans Commission is not a symbolic gesture. It is a structural reform designed to create lasting change. It will help ensure that the lessons of the Royal Commission are not forgotten, that the recommendations are implemented, and that the momentum for reform is maintained long after the headlines fade. It will help create a system that is simpler, more compassionate, and more responsive, a system that recognises the dignity of veterans and their families and treats them with the respect they deserve. The Albanese Labor government is committed to delivering the change that veterans have been calling for a very long time. This is not just a policy commitment, it is a moral commitment. It is coming from the heart. It is a recognition that we owe a debt of care to those who have served, and that debt does not end when their service ends. Communities like Dixon, with such a strong defence present, understand just how important this reform is. We understand the impact of service every day, the pride, the resilience, the strength, but also the challenges, the transitions, and the moments when support is needed most. I reflect on my own experience with post-traumatic stress disorder. I was one of the lucky ones. I got psychology appointments every 2 weeks. It was acted upon early, identified early, recognised, supported, and it made all the difference. Many of our veterans have had to go through really extremely traumatic experiences of PTSD, and their recovery has been delayed, ignored, put off. They've been embarrassed to talk about it. This needs to change. By establishing the Independent Defence and Veterans Commission, we are taking a significant step toward a future where veterans and their families are supported by a system that is worthy of their service. A future where their well-being is protected, their voices are central, and their experiences shape the policies that affect them. A future where no veteran or serving defence personnel feels left behind. I commend the bill to the House.
I thank the member for Dixon. The question is the bill be read a second time, and I call the member for Goldstein.
Thank you, Deputy Speaker. Deputy Speaker. I rise on this important bill to support the work of Member Herbert, but also, of course, for all of the members of this Parliament who have done their duty in service to our nation, and, of course, to everybody who has done their duty in service to our nation in the Defence Forces. Public service in all of its forms is a noble calling, but to be prepared to risk and sacrifice one's own personal physical well-being and mental well-being for the task of defending our nation is one of the most noble that anybody can pursue. And the response from that must also be that our nation must back those people who are prepared to take risks, to back themselves, to be able to stand up for those who can't fulfil that service, and in pursuit of defence of our country and, of course, the broader environment of peace and security around the world. And that's the basis in which we've always supported a Royal Commission into Defence and Veteran Suicide, and ongoing support for Defence and Veteran Services and their need for ongoing support and assistance, because we know, tragically, as a consequence of the Royal Commission, what has happened where so many men and women who have served this nation honourably and in a decent way continue to endure the consequences of conflict and the risks that lead to significant quality of life after their term of service. And so this bill is important because it's about acknowledging our responsibility to our veterans. It's about acknowledging the responsibility this nation has to those people who are prepared to make sacrifice in pursuit of our national interest. And I know the member for Herbert has already given a stirring speech, but when I go to the RSLs and the Goldstein electorate, this topic of what support we're providing for our veterans continues to come through. A lot of the RSLs in my electorate were established at a time back after the Second World War, and of course as a consequence a lot of the veterans that now visit those RSLs of more recent conflicts tend to be lesser in number in comparison to years past. But that doesn't mean the community doesn't have an enduring concern about their health and well-being, whether they're in the community or elsewhere. The overwhelming majority of Australians fundamentally understand the debt and the burden that this nation owes those people who wear the uniform in defence of our country. And they want to see agencies and entities that exist to support them. Of course, we have DVA, but making sure that we have the Defence and Veterans Service Commissioner is an important part of that, because we want to address the deep problems of PTSD, mental health and well-being, stopping suicide, so that it is not the service in our nation doesn't become a pathway to a reduction in quality and standard of living. And we know that there's a lot of work to be done, Deputy Speaker. It's an enduring responsibility. It is going to be one that is not going to be solved with a flick of a switch. It's going to be from a nation that commits to invest in into their veterans to provide pathways. And I know that there is already a lot of work that is done in this space. Many years ago went and saw the St Kilda Football Club, which at the time was not in my electorate, but now actually is in my electorate, and due to a redistribution by the AEC. And they highlighted that a lot of the challenges that veterans have once they cease their service is equivalent to the sense of identity and place that footballers have. That's their commentary, not mine, but I can see what it means, where your identity and your sense of purpose in life is melded, and what happens when that sense of purpose is taken away. It's not the only profession, of course, and that they were looking at the parallels and overlaps between the two, and whether there was things they could learn from the ADF, and equally that they could do to support the ADF in their important work to be able to support people after they finish, because identity, place and purpose connected, once removed, raises deep issues for many people about where they fit in the world, the role they play, and particularly, of course, if they have the consequences of conflict lived out in their memories and that can significantly impact their mental health and well-being. So this bill, to me, is a fundamental proposition about how we show and honour and respect our veterans, and that there is nearly no end to the responsibility we share to invest in our veterans to be able to live out the best of their healthy lives. Because for those people who make that sacrifice and are prepared to invest, prepared to wear the uniform to defend our nation, What we should want is, at the end of their service, not just to provide them with the support they need to move on from their service, and of course in many cases we want them to continue to act as reservists, continuing supporting the ADF, but we should also want those who cease their service to go on and live healthy and productive lives. And we don't mean healthy and productive lives which means keeping them alive. We mean healthy and productive lives where they form families and live out their what they deserve as a consequence of their service for what they fought for, or what they certainly enlisted for. And so I'm very happy to be supporting the principles of this process and this legislation, because I think it goes right to the heart of what our responsibility, particularly those who have not worn a uniform, have to those who are prepared to step up and do so. Thank you, Deputy Speaker.
Thank the member for Goldstein. The questions bill be now read a second time, and I call the member for Patterson.
Thank you, Deputy Speaker. Today I rise to speak in support of the Defence and Veterans Commissioner Bill 2025, a bill that goes to the very heart of our responsibility to those who have served our nation and to the families who serve alongside them. Before I turn to the technical provisions of the bill, I want to begin somewhere very human and very local for me. My electorate of Patterson is home to Australia's premier F-35 base at Williamtown. It is also home to the Wedgetail, which has provided such incredible capability, nonetheless in places like the Ukraine in recent times. And around 5,000 people, not dissimilar to this building, work on that base each and every day. And I could not be prouder to represent those people, both serving and those who have served there in the past. And it is a popular posting, I have to say, Deputy Speaker. In fact, many people come back to Port Stephens and our local area because of their time at the Williamtown base. It is a beautiful area and they love it and they bring their families back. Now, one of the most powerful examples of community-led support for veterans can be found on the beautiful waterways of Port Stephens. Invictus Australia works closely with the Port Stephens Dragon Boat Racing Club. It brings together veterans, current serving Defence family members and members of the wider local community in a way that is inclusive, practical, deeply meaningful and can make those shoulder muscles burn. This is not just about sport, it is about belonging, it is about connection, it is about shared experience and mutual support. Members of this club speak openly about the joy of being out on the water, about the camaraderie that develops stroke by stroke, and about how being part of a team again has profound benefits for their overall health and well-being. For many, it provides a sense of purpose and identity during those times when they can feel lost post-service. For families, it offers understanding, solidarity and reassurance that they're not walking the path alone. It is genuinely incredible to see the effect that local Invictus initiatives like this have in supporting our communities. They remind us that recovery, resilience and well-being are not abstract concepts. They are lived experiences shaped by the systems we build and the support that we choose to provide. And it is precisely because of those lived experiences that this bill matters. The Royal Commission into Defence and Veteran Suicide was one of the most significant and confronting inquiries ever undertaken in this country. Its findings were sobering, its recommendations were clear, and it deemed Recommendation 122, the establishment of a new statutory entity to oversee system reform across the entire defence ecosystem, as its most important recommendation. The language was not used lightly. The Royal Commission recognised that without sustained independent oversight, meaningful system reform would not occur. And what does that mean, meaningful system oversight and reform? Well, it means that we save more Australian lives and that we make the quality of our veterans' lives better. That's what that really means. That fragmented responsibility, short-term initiatives and the lack of accountability had contributed to devastating outcomes for serving and ex-serving members of the Australian Defence Force. And I want to take a moment to remember Julianne Finney, who I'm sure those of us who've been in this place long enough will remember her campaigning particularly hard as she had endured the dreadful loss that no parent should endure of a child taking their lives, her son David. And she fought absolutely doggedly to ensure that there was a royal commission and that her son's life had real meaning, and I pay testimony to her today. In acknowledgement of the significance and urgency of that recommendation, 122, the Albanese Labor government acted. In February 2025, we legislated the Defence and Veterans Service Commission, and I am proud to say that it has been up and running since the end of September last year. But today's bill is about strengthening that foundation. The role of this new statutory entity is clear: to provide independent oversight and evidence-based advice to drive system reform, with the explicit aim of improving suicide prevention and wellbeing outcomes for defence and veteran communities. And I want to say, we put so much effort and money, to be frank, into training our defence personnel, and they deserve the best training. Therefore, it is imperative that we continue to support them. It is one thing to train people, but it is another to look after them, to not break them in the first place, and then look after them once they have served our nation. It's something that I feel very passionate about, and we talk about recruitment, and we put a lot of effort into recruitment. We've also got to concentrate on retention, and in retaining our people, that is an important thing, their wellbeing. And when they do finish their service, we must care for them and put in place things like this commission to ensure that it is meaningful. The Commission will have a dedicated and sustained focus on suicide prevention. That is the imperative. It will ensure that agencies responsible for implementing the Royal Commissioner's recommendations are not only encouraged but required. They must be required to deliver long-term change. It will drive the systemic reforms needed to reduce rates of suicide and suicidality among serving and ex-serving ADF members. For that work to be credible and for it to be trusted by Defence and the veteran community, importantly, the Commission must have genuine independence. It must have clear functions and it must have the powers necessary to do its job effectively. And that is what this bill seeks to deliver. The Defence and Veterans Service Commissioner Bill builds on work already undertaken by this Parliament earlier this year, when Schedule 9 of the Veterans Entitlements and Treatment and Support Act was brought in and was passed and subsequently examined through a Senate inquiry. That inquiry was thorough. It received submissions from veterans, their families, advocacy organisations, experts and stakeholders across the defence ecosystem. It was a thorough investigation. The evidence presented was thoughtful, at times challenging, and always grounded in lived experience, that very painful, often lived experience. Importantly, the government listened, our government listened, and not only listened, but we've acted. The submissions, evidence and the committee's report have directly informed and shaped the development of this bill, which implements several key recommendations. First, the establishment of standalone legislation for the Defence and Veterans Service Commission. This is critical. Standalone legislation reinforces the independence of the Commission and reflects its unique role in overseeing system-wide reform. Independence isn't symbolic, it is foundational for the credibility and authority of the Commissioner's work. Second, the bill ensures that the Commission's functions explicitly include reference to veterans' families. And this is something time and time again we have heard. I'm joined by some of my colleagues, and indeed you, Deputy Speaker. We were all elected in 2016, and one of the first things I did was engage with my veterans community and my defence personnel community, and they were at pains to tell me that their families were all pivotal. Their families were pivotal in their lives, and that's where this piece of legislation is important. For the first time, we're recognising families. We know the importance, the backbone that they play. They are indeed the additional defence force of our country, and I thank them for their support of our serving personnel and our veterans. The Albanese government is pleased that through this legislation we are formally recognising them. Now, third, the Commission's function and powers have been reviewed and strengthened. Proposed amendments arising from the inquiry process have been adopted. So we did listen when there were changes that needed to be made to ensure the Commission can operate effectively without obstruction. This bill further strengthens independence by ensuring the Commissioner is appointed by the Governor-General following a merit-based public recruitment process. This transparency reinforces confidence in the role and ensures appointments are based on capability, integrity and experience. The Commissioner's role is an incredibly important role in our country. The bill also strengthens the Commissioner's power to ensure accountability. It enhances the ability to access necessary information, and it removes barriers that could otherwise limit the effectiveness of inquiries or oversight, importantly. In addition, the bill expands the scope of witness protection. This is a crucial reform. People must feel safe to provide information to the Commissioner without fear of reprisal, without blowback. Protecting those who come forward is essential. If we are serious about uncovering systemic issues and driving genuine reform, this is pivotal. Transparency is another key pillar of this legislation. The bill improves the transparency of the Commissioner's work, ensuring accountability not only for those subject to its oversight, but for the Commission itself. This includes statutory deadlines for the completion of 2 major inquiries into the Commonwealth's implementation of the government's response into the Royal Commission's recommendations. Those deadlines, and they are the 2nd of December 2027 and the 2nd of December 2030. They align with the 3rd and 6th anniversaries of the government's response and ensure progress is measured, visible and sustained over time. And if you can't measure it, then you can't find out if you are doing the best. So I'm pleased that those dates are locked in. These timeframes recognise that system reform is complex and ongoing, though, and they also make clear that delay and inaction are not acceptable to this government. At its core, this bill reflects a government that has listened to feedback from stakeholders who are often family, and taken action. The changes before the House today ensure the Commissioner has the tools necessary to drive system reform and improve suicide prevention and wellbeing outcomes for serving and former serving Australian Defence Force members. This legislation will ensure agencies are held accountable to consider and respond to the Commissioner's recommendations, and the enduring nature of the Commission will ensure that voices of veterans and their families continue to be heard after the headlines fade. Systemic issues that contribute to suicide in our veteran community cannot be addressed through one-off responses or short-term commitments. They require sustained attention, independent oversight and courage to confront uncomfortable truths. This bill delivers exactly that. For the veterans paddling together in Port Stephens, for the families supporting them, and for every serving and ex-serving member of the Australian Defence Force who deserves a system that works for them, this legislation matters. I commend the bill to the House.
Thank the member for Patterson. The question is the bill be read a second time, and I call the member for Riverina.
Thank you, Deputy Speaker, and like the member for Patterson who has just finished her contribution, and a good one at that, I too acknowledge Julianne Finney and her role in supporting not just her son's legacy but indeed veterans per se. Acknowledge the veteran serving members in the chamber at the moment, the member for Solomon, thank you for your service, and the Shadow Minister at the table, the member for Herbert, who went through Kapuka. Blamey Barracks, 1st Recruit Training Battalion at Wagga Wagga in 2006 when Simone Wilkie was the first female commandant at that important and strategic training centre. And as all politics is local, acknowledging the role that Kapooka does in turning out the best and the bravest, of whom the member for Herbert was one, and acknowledging he went on to serve at Singleton, won RAR out of Townsville, his service in East Timor, appreciating and recognising the fact that the Prime Minister has just made a visit there, diplomatic visit, successful visit, acknowledging the role the member for Herbert played in Afghanistan and his tours of duty there. It's not easy being a veteran, and we need to acknowledge that not all veterans are broken, but for those who are, we need to be there for them, because we as a parliament send them to do their duty for and on our behalf. We as a parliament send them into harm's way, and many of them feel the lasting effects, lifelong effects of their service once they hang that uniform up. And given the fact that we do send them into conflict, into battle, putting their lives on the line, into the front line, we need to be there for them if they do need that support. And at some stage or other, they will all need our support. And I would urge and encourage any veteran to absolutely make sure that they use all of the services that are available to them. And I know that the Department of Veterans Affairs, for some veterans, has a bit of a trigger, but there are very, very good people in DVA. There are, and they are there to provide you with the wraparound support as a veteran that you need. I also, given the fact that, as I say, all politics is local and this is political, want to acknowledge the role that Bob and Gladys Back play at Bethungra Integrated Service Persons Association, the role that Jackie Vincent and her colleagues play at Cootamundra. The drop-in centre there in the main street, Parker Street of that town is important. And in Wagga Wagga, where there are many veterans, given the fact that we have Kapooka, given the fact that we have Forest Hill, RAF Wagga, where air power starts, it says so on one of the Royal Australian Air Force hangars, and of course a Navy base, would you believe, long, long way from the nearest drop of seawater, but we have a naval presence of 80 or so personnel operating out of Forest Hill, operating in close quarters and conjunctions with those at Kapooka, and of course nearby RAF. And so the veterans avail themselves of the services at Pro Patria in Ashmont, as well as the service provided in the main street, Bayliss Street, of the drop-in Veterans Centre there, run by the Return and Services League. And every week just about we have a commemoration of a service, of an event, of a marker, milestone, in the Victoria Memorial Gardens, also in the main street. It is very much a garrison town. Now, the Defence and Veterans Service Commissioner Bill 2025 follows on from the harmonisation that the government is doing with superannuation payments for veterans, and that is a good thing too. It is, because for years we have endeavoured to integrate and harmonise MERCA and DERCA and the other various provisions for veterans, and it's a big log of work. DVA, of course, very heavily involved. Ministers for Veterans Affairs and the Defence Minister and government and opposition as a whole. And when it comes to bipartisanship, we need to, as much as possible, when it comes to our veterans, be as one, because our veterans deserve no less. The Coalition established the Royal Commission into Defence and Veteran Suicide because veterans and their families deserve truth, they deserved systemic reform, and they deserved accountability. Now, there were a number of recommendations, 37, from that Royal Commission. It conducted its 8th hearing block at the Mercure Wagga Wagga from 28 November 2022 to the 1st of December that year, and heard some harrowing evidence, sombre evidence, evidence from veterans that needed and demanded an urgent response. But it wasn't just at Wagga Wagga, of course. It was every hearing the Royal Commission conducted. And we took that step of making sure that Royal Commission was available to hear from veterans because we knew that too many families had been ignored for too long. And confidence in the system, for some, not all, but for some, had broken down. And that was indeed unfortunate, Deputy Speaker. The Royal Commission confirmed what many, including the Julianne Finneys of the world, had known all along, that the ex-service community had been saying that systemic failure was affecting veterans, was affecting the services available to them. And we need to do better as a government, as a parliament and as a nation. It made clear that lasting reform requires independent, system-wide oversight across the veterans and the defence ecosystem, not oversight simply and merely and solely embedded with departments. Our departments are very good. Our public servants are exceptional. We should acknowledge that. I do recognise that. But we can always be better. We can always make improvements, and we can always review the performances of what we do as a parliament, the legislation that is in place, and the effects that our departments and the law has, and well, not just the law, but indeed such things as the payments, the welfare services, the health outcomes, all of that for veterans prevails across the sector. One of the most significant recommendations was the creation of a permanent independent statutory oversight body to drive reform and measure progress. I know when I was the Veterans Affairs Minister for not a very long period, between 2017 and 2018, the legislation for veteran-centric reform went into and through the Parliament. And that was an important, I'll say first step, because it acknowledged the fact that legislation had to have the lens of veterans placed over it, every piece of legislation. And because our veterans are embedded in all sectors, in all areas of endeavour, right across society, right across the economy. These bills are intended to give effect to the recommendation of creating that independent, permanent statutory oversight body. And the Coalition supports that objective. Oversight bodies without the muscle or the teeth do not drive change. They produce reports which unfortunately gather in trays, in departments, on departmental desks, and gather dust. That's not what this is about. That's not what this should be about. And I acknowledge the role that the government is playing to endeavour to ensure that that doesn't occur. Establishing the Commission through standalone legislation is the right model, and it's the model that the Coalition argued for from the very outset. The government's original attempt to create the Commission through a late amendment to unrelated legislation, I have to say, wasn't well done. It was poorly handled. It lacked the proper consultation. If there's one thing I would really urge and encourage this government to do, is not rush legislation through this House in haste, because haste leads to poor outcomes. And unfortunately, we have seen that this year already with the extraordinary sittings of the Parliament in January. And the thing is, I know the government has a legislative agenda. I appreciate the government has a huge majority in the House of Representatives. And that's the people's wish. I understand that, I acknowledge that. But don't use that majority to push through legislation, because legislation needs to be debated. Legislation needs to have proper consultation with the stakeholders who will feel its effects the most. And proper consultation through peak groups and others is really important, because it enables the Parliament to get lawmaking right. And we have an obligation and responsibility to the people of Australia to get lawmaking right. We do. And I do fear that there is this growing trend that this government is abusing its huge majority in the House of Representatives to push its agenda through. Take the time, be patient, be practical, be pragmatic. Make sure that you do on any piece of legislation, on this and others, and that's why we, from the very beginning of this piece of legislation, urged and encouraged the government to do the work, to get it right. Our veterans deserve that bare minimum. They deserve everything that we can do for them, and we need to make sure that, particularly with veterans legislation, that we don't rush the process, that we don't put it through Parliament in record time. A major structural reform body should never be created through a last-minute legislative insertion. It undermines the confidence of sectors in the system, in the people elected to do the job on their behalf. And our veterans do look to us for support, and it must come from both sides. Now, Parliament was asked to wade through a complex oversight body with very limited visibility and limited stakeholder engagement, and that is not how serious veterans policy should be made. It is not. So I would urge and encourage to ensure that with this Commission and with this bill, that we take the time. I know it will pass this place. It's got the support of the Coalition, but we also need to ensure that if there are any fine-tuning legislative measures that may happen in the House of Review, in the Senate, in the upper house, then there's the time taken to do that as well. And very much establishing this Commission will have a flow-on effect throughout our veteran community, and certainly in Wagga Wagga, which, as I said, is a tri-service military city. It is one of those cities that takes our veterans very seriously. It is one of those cities that takes our current serving personnel very seriously, and ensures that they are welcomed, ensures that they are very much part and parcel of our community, but not just indeed those who are currently wearing a uniform, but their partners, their families, their children. And I know that providing access to childcare, to health services, and all of that, the full gambit, is so very important. And particularly for our veterans, the provision of ensuring that mental health, welfare and support is there is a crucial part to understanding what our veterans are going through, what our veterans need, and ensuring that they can continue to contribute mightily to our nation. Thank you.
Thank the member for Riverina. The question is the bill be now read a second time, and I call the member for Macquarie.
Thank you, Deputy Speaker. When the Royal Commission into Defence and Veterans Suicide delivered its final report in September last year, it contained 122 recommendations. Now, recommendation 122, the very last recommendation, last but definitely not least, was that the government establish a new statutory entity to oversee system reform across the whole defence ecosystem. According to the Royal Commission, this was its most important recommendation. It went on to say that this recommendation would underpin all the other recommendations that had been made, the other 121 recommendations, and that it was the most significant action the Australian government could take to address defence and veteran suicide. Now, we acknowledge the urgency and significance of the recommendation, and in February 2025, the Albanese Labor government legislated the creation of the Defence and Veterans Service Commission, and it's been up and running since the end of September. And this legislation builds on that work, that early work, to have it up and running as a matter of urgency. And for people in my electorate of Macquarie, many of whom have had families working at the Richmond RAF base or at the Glenbrook RAF base, or they're connected to the Defence Force in many, many other ways, knowing that something was happening was really important. The role of this new statutory oversight entity really is to provide independent oversight and evidence-based advice so that the system can be reformed to improve suicide prevention and improve wellbeing outcomes for the defence and veteran community. The Commission has a dedicated and sustained focus on suicide prevention, as it should, having come out of that gut-wrenching Royal Commission. The establishment and the framework will ensure agencies implementing Royal Commission recommendations will be held to account by promoting long-term change and driving the changes that are needed to reduce the rates of suicide and suicidality among serving and ex-serving ADF members. Now, there's a lot of things that have to happen to make sure this is effective. And one of them is that the Commission must have independence. It has to have the functions and powers necessary to meet its objectives. And most importantly, it has to be able to maintain the trust of the veteran and defence community. This bill delivers on the full implementation of these things by enshrining the legislative establishment of the Defence and Veterans Service Commissioner and Commission into its own standalone legislation, as was always intended. I note that the previous speaker on the opposition talked about things being rushed. Well, let's look at how the work that has been done to get us to this point. The Defence and Veterans Services Commission bill builds on the work that was undertaken by the Parliament when Schedule 9 of the Veterans Entitlements, Treatment and Support Simplification and Harmonisation Act 2025 was passed, and a Senate inquiry was undertaken. The submissions, the evidence, the committee's report have informed the development of this bill, and it's led to the implementing of a whole range of recommendations that they had. And that's why we now have standalone legislation for the Defence and Veterans Service Commission, which reflects its independence. I think it's really important that for people to be aware that the Commissioner also has a role in recognising veterans and defence families. Now, there is no doubt that families of veterans and defence members play a vital role in the health and well-being of those who are serving or have served. And they also face some unique challenges themselves, whether it's the moving from location to location, whether it's the hours and the operational requirements that their family member has, means they're not always at home when they might want them to be. Just the whole lifestyle of being in a defence family is a very different thing than the average family experiences. So we're really pleased that through this legislation we're able to acknowledge the significance of veteran families. Under this legislation, the Commission functions and powers have been reviewed, and there's been a bunch of amendments adopted. So I'm very satisfied that this has been done at a pace that allowed for sufficient input from all the stakeholders who are important, most importantly from veterans and defence personnel and their families. The bill strengthens the independence of the Commissioner by ensuring the role is appointed by the Governor-General after a merit-based and public recruitment process. The bill strengthens the Commissioner's powers in ensuring accountability and accessing necessary information. The bill also expands the scope of witness protection to ensure that a person is protected in providing information to an inquiry by the Commissioner. That's a very important improvement, and the bill improves the transparency of the work of the Commission to ensure accountability for the Commission itself and those who are subject to its oversight. It is not unexpected but very important that we have in this legislation the requirement that the Commission will be publicly reporting on the government's progress on implementing the government response to the recommendations of the Royal Commission, and on the 3rd and 6th year anniversaries of the government's first response. So that will be 2027 and 2030. And that public reporting will ensure that anybody will be able to measure it against what was set out to be achieved. In preparing for this bill, the government's listened to feedback from stakeholders and taken action on it. It's one thing to listen, it's another to act, and that's what this bill does. So that the Commissioner has the tools necessary to ensure the Defence and Veterans Service Commission can drive system reform, because we do need to see an improvement in suicide prevention and wellbeing outcomes for serving and ex-serving Australian Defence Force members. This legislation, of course, is one of the steps that we're taking. It was recommendation 122, one of the most important things to do. We've already seen improvements that are happening on the ground that go to the objectives of this legislation. In my own community, where, as I say, we have the Richmond and Glenbrook RAF bases that have been there for a long time, the new Hawkesbury Veterans and Families Hub is part of ensuring that there is an easy point of access for current serving personnel and their families and veterans personnel and their families. And I'm very pleased to be attending an open day tomorrow, a Friday. I'm a day ahead of myself, wishful thinking, to be back in my electorate on Friday attending the open day for the Hawkesbury Veterans and Families Hub, to really showcase the work that has already been done in a temporary location underneath the Windsor RSL, while there is work being done for the permanent home of the Hawkesbury Veterans and Families Hub. And I congratulate Brett and his team on the work they're doing in this interim period, but also all of those working to restore the historic former Richmond Courthouse, which is right in the heart of historic Richmond, a building that has been not used and had no purpose for many, many years, but will come to life to provide a hub and support for the many veterans and defence personnel and their family in the Hawkesbury. When it's complete, around 20,000 veterans and families who live in the Hawkesbury, and then it will be linked to one in southwest Sydney, will be able to access tailored support close to where they are. What we've seen from the hubs, it really speaks to the piece in this legislation which is focusing on the recognition of mental health and wellbeing as being fundamental. And the hubs offer better access to support, resources and services all in one location. And more importantly, in some ways, provide an opportunity for that social and community connection. I'm very excited to see as it evolves. And of course, I can't wait for the beautiful renovation to be complete. At another part of the electorate, the same issues that this bill is seeking to address is being tackled in a different way, and that is through Task Force Veteran, formerly known as the Hunter Anzac Memorial Limited Group, who have been working on the properties at Skyville. They're working on historic veterans housing, and it was a veterans and migrants centre at different times. And that is thanks to a $5 million federal grant that is transforming dilapidated buildings into something really special. And I particularly want to mention the key person who has driven this, Brett Wild. And I want to wish him all the best because he's suffered a stroke and is in hospital. And I really want to see him back continuing the fantastic work he's done at Skyville, and all our thoughts are with Brett. He has an amazing committee who is continuing the work in his absence. The Skyville National Park transformation means that a very dilapidated part of our community is now alive with activities and has such a bright future, thanks to the very caring work that has been done. And it's been done with the work of local tradies and builders, and I know Allscope Constructions had a very large hand in it. I suspect very generous with the rates that they charge to do this important work. So these are the sorts of things that are already happening on the ground to ensure that veterans and their families have places that they can turn to so they don't feel isolated. My experience of being on a member of the Defence Liaison Program and spending time in Iraq, in Camp Taji, and spending time at Amberley in Queensland, what I saw from that is how tight the family is, the defence family, and what a big wrench it must be when you leave that defence family, particularly when it's at a timing that may be driven by a health reason, so not necessarily a natural timing that you might have chosen. And I've talked to many veterans who tell me that the stepping away from defence is one of the most scary things that they've done, and we hope that veterans hubs create a sense of place for people so that they can feel welcome in those places. And Deputy Speaker, as well as being so pleased to see this legislation as a key part of it, I've also been very pleased to see the work that we have been doing to improve veteran wellbeing outcomes, and that includes the latest commitment and announcement that we've made around how veterans' health is treated. And we've often focused on reactive treatment. When something goes wrong, it gets treated. But there is now consistent with the findings of the Royal Commission, DVA will now have a greater focus on early intervention and prevention, working really closely with the Department of Defence to identify risks earlier and act sooner. The announcement this week around these improvements will make a real difference to people's lives. It includes using insights from the claims decision-making to support Defence's proactive approaches and make it easier for veterans to access treatment and rehab early. I also want to let veterans know that we are taking action against bad actors who've been seeking to take advantage of the improvements in government service delivery and have been falsely putting in claims for veterans' health. Now, veterans should know that they can come directly to the Department of Veterans Affairs. Claims are being processed promptly. There are independent processes in place, and the integrity of that system is much improved in the changes that we've made. We will stop medical practitioners and unscrupulous people from exploiting these veterans.
I thank the member for Macquarie. The question is the bill be read a second time, and I call the member for Grey.
Thank you, Speaker. Speaker, our veterans matter. This seems obvious, but it is a fact that is too often forgotten here as the years progress and the memories of war fade. These bills before the House are about setting up a permanent, independent watchdog to look after our veterans. And what's more important than that? The Coalition supports this objective. We support it wholeheartedly, and I support it. Veterans have fought for us so that we can live in the best country in the world, and some, Speaker, have given the ultimate sacrifice for that. But, Speaker, we have to be honest about the history, and we must be honest about who has truly stood up for veterans where it mattered. it was a Liberal national government that established the Royal Commission into Defence and Veteran Suicide. We did it because it was right. We established it because veterans and their families deserved the truth. They deserved accountability. They deserved to know why their system was failing them. We took that step because we recognised a hard truth. Too many families had been ignored for too long. Confidence in the system had broken down. We listened to the mothers, the fathers, the partners, and the children who had lost their loved ones. The system was indeed broken, and the Royal Commission confirmed exactly what those families had been saying. It made it clear that if we want lasting reform, if we wanted to stop these tragedies from happening, we cannot trust departments to mark their own homework. We need independent, system-wide oversight. We need eyes on the problem that are outside of the bubble that is this god-awful Canberra bureaucracy. One of the most significant recommendations from the Royal Commission was the creation of a permanent, independent statutory oversight body, a body to drive reform. That is what these bills intend to do, and that is why the Coalition supports them. However, Speaker, it is important to put something on the record. This idea, an independent oversight body, is not an invention of the Labor Party. In fact, the Coalition introduced legislation to establish an independent National Commissioner for Defence and Veteran Suicide Prevention back in 2020, 5 years ago. That bill proposed an independent statutory oversight body with basically the same features that Labor is implementing today. And what did Labor do in 2020? They opposed it. Because of Labor's political games, the establishment of the body was delayed. And that delay matters. It matters because early independent oversight, working alongside the Royal Commission, could have accelerated system reform. It could have brought earlier accountability to Defence and DVA. The structure Labor is now implementing closely mirrors what the Coalition proposed the very same time they voted against it. The Coalition will support this framework now because veterans and families cannot afford any further delay. But the history should be acknowledged, Speaker. Labor put politics ahead of veterans' well-being 5 years ago. And Speaker, while we are debating how to best support our veterans and secure our future, we must look at what Labor is doing to our strategically important assets, our defence assets across Australia. And Speaker, it's important to me because in my electorate of Grey we have 3 defence assets. We have the Proofing Range south of Port Wakefield, we have the Army Base at Coltana, and of course Woomera, a significant asset to our Western alliances over the past 100 years. And Speaker, we have learned that this week the Albanese Labor government is planning a fire sale of more than 60 defence properties. They are planning to sell off historic sites like the Victoria Barracks in Sydney, Melbourne and Brisbane. They want to sell HMAS Penguin. They want to sell the RAAF base at Point Cook. The Shadow Minister for Defence, the member for Hume, has rightly called what it is, a fire sale. We are currently facing the most dangerous strategic environment in generations. The world is less safe today than it was yesterday. And what is Labor's response? To sell off the assets that support the recruitment, the training and the retention of our ADF personnel. And the RSLs have spoken out, and we should listen to them. The RSL National President, Peter Tinley, puts it perfectly. He said, "These aren't empty paddocks on a spreadsheet." He is right. These are places of history. These are places of heritage. These are places that matter to the veterans who marched on those parade grounds. And Speaker, there's 30 RSLs in the electorate of Grey, and they do such an important role for our community. I'd like a special shout out to the RSLs in Port Lincoln, Coober Pedy, Cummins, Port Augusta and Port Pirie for their welcome of me into their communities. And I'd like a special shout out to the Port Augusta RSL who at the Anzac Day last year offered me the first gunfire breakfast. And Speaker, if you know what a gunfire breakfast is, it's 8 a.m, you have milk and rum. Good way to start the day. So to sell off the assets that support the recruitment, training and retention of our ADF personnel. So Labor claims that this will raise billions of dollars, but the RSLs have warned that the cost of remediation, cleaning up these sites, could also cost a fortune, and it could take a decade. We have seen this movie before, Speaker. We saw failed divestment processes at North Head in Sydney and Portsea in Victoria. We urge the government do not repeat these mistakes. The New South Wales Premier is worried about the heritage of Victoria Barracks. The Greens want to turn our military history into housing blocks. And the Minister for Defence seems to think that this is only about, quote, value for money. Strategic assets are not just about money. They are about capability. They are about history. To sell off these sites without proper scrutiny, without a clear plan, and potentially just to plug a hole in the budget or to cover for their failures on housing is short-sighted. It is risky. As the RSL said, the headline figure on the sale might look very different when the final accounting is done. The Coalition stands with the veterans who are worried about their heritage being sold to the highest bidder. And we stand with the community who wants these sites protected. And we stand against a fire sale that treats a national security asset, a national security estate, like a garage sale. And finally, Speaker, I want to address the broader context of support for our veterans. We often hear criticism from those opposite, but let's look at the record. When the Liberal National Party was in government, the portfolio of veteran affairs was given cabinet status. That is a clear indication of respect. It shows that veterans' issues were at the heart of government decision-making. The Coalition also delivered more than $11 billion every year in support for veterans and their families. We introduced and passed the Australian Veterans Recognition Act 2019. We created the Veterans Covenant, the Veterans Card and the lapel pin. We ensured that there was proper national recognition for service and indeed sacrifice. We made sure that business and the community could say thank you in a practical way. We provided free, non-liability mental health care. This was a game changer. We said that for any veteran who completed at least one day of full-time service, mental health care was free. We removed the barriers. We didn't ask for paperwork first, we offered help. We expanded and modernised Open Arms, veterans and family counselling. We made sure it was a fit for purpose and accessible for everyone who needed it. We initiated the Psychiatric Assistance Dogs program, and Speaker, veterans' lives have been saved by these dogs. This program is now supporting hundreds of veterans across Australia with tailored, life-changing therapy dogs, and this was a Coalition initiative. We established the Prime Minister's Veterans Employment Awards to celebrate employers who hire veterans. We helped ADF personnel transition into civilian careers. We launched the Veteran Wellbeing Centre program. It put bricks and mortar into communities. We delivered support hubs in Darwin, Perth, Adelaide, Albury-Wodonga, Nowra, Tasmania, South East Queensland and Townsville. Places where veterans can go for help, meet mates and find support. We created the role of the Veterans Family Advocate. We ensured that the voices of families, often the unsung heroes of service, were heard in every major political decision. We committed $500 million to the Australian War Memorial redevelopment. And Speaker, what an amazing asset it is. It's so important that younger people can come to the nation's capital and understand the history that the Aussie diggers did for the beautiful, prosperous society that we have today. We ensure that the stories of contemporary veterans and modern diggers are told with the same respect and visibility as the Anzacs of old. We established the Joint Transition Authority to hold defence accountable. We delivered provisional access to medical treatment so veterans didn't have to wait for claims to be assessed before seeing a doctor. We increased fees for health professionals to keep doctors in the system. We boosted staffing at DVA to speed up claims. And we even added a question in the census to track the number of veterans in Australia. So we finally know where our veterans are and what they need. Speaker, that is a record to be proud of. It is a record of action, not just words. Speaker, the Coalition stands with our veterans. We stand with their families. We will continue to fight for a system that is transparent, fair, and respectful of the service and sacrifice of every Australian who has worn that uniform.
The question is that the bill be now read a second time. And I call the member for Maribyrnong.
Thank you, Deputy Speaker. Nestled in the heart of many ponds stands the Menin Barracks, home to the 5th 6th Battalion, Royal Victoria Regiment, Delta Company. It remains an active Army Reserve base, but it is also a living monument to my community's proud military history, a lineage that stretches back to the original AIF and the battlefields of Gallipoli. Last year, to welcome their surrounding neighbours and the broader Moonee Valley community, Delta Company held an open day. Major Braden Holmes walked me through the stations, through the machinery, the kit. It was all very impressive. But, Deputy Speaker, it wasn't the equipment that stayed with me, it was the people. I met young, enthusiastic cadets. I met men and women who live and work and are raising their families in Maribyrnong and who have made their selfless decision to serve their nation. Major Holmes and I spoke about the unique culture of the Delta Company and how those barracks have served our community for generations. And our community's connection to Australia's military history runs deep. We see it in the legacy of Essendon Airport, which served as a vital defence gateway during World War II. We see it in the names of our streets. In fact, 10 streets in the city of Moonee Valley are named in honour of Australian military heroes. And in our 3 local RSL sub-branches, which carry the legacy forward every single day. But our duty to those who serve is not just about preserving their brave and historic contributions. It is about how we protect the lives of the people who put their hand up to protect us. People like those who I met at Menin Barracks and at remembrance services across my electorate. No veteran and no veteran's family should ever have to fight their hardest battle alone. The Defence and Veterans Service Commissioner Bill 2025 is how we honour that promise. The Royal Commission into Defence and Veteran Suicide was a long, painful but necessary reckoning. It held a mirror up to our nation's soul and revealed a depth of service that was often followed by a depth of neglect. The final report contained 122 points of action, but the commissioners were explicit. Recommendation 122 was the most important. It was the cornerstone upon which every other reform would depend. They called for a new permanent statutory entity to oversee system reform across the entire defence ecosystem. But not another internal committee, not a body that answers to the very departments it is meant to scrutinise. They called for independent oversight with one sole purpose: to ensure that the systemic failures that led to suicide were identified, challenged and permanently fixed. The Commission recognised that too many had known for too long that suicide in the veteran community was not an isolated clinical issue, it was a systemic one, a product of culture, policy and institutional friction. To address it, we need an entity that exists outside the chain of command, with the longevity to outlast political cycles and the authority to demand change. An entity that ensures no one is left to navigate a broken system alone. In February 2025, the Albanese Labor government acted on this urgency by legislating the Defence and Veterans the Defence Veterans Service Commission. It has been operational since September, already undertaking the demanding and critical work of oversight. But today, with this bill, we are strengthening its foundation. We are transitioning the Commission into its own standalone legislation, giving it the absolute independence it needs to be respected and the statutory teeth it needs to be effective. We are ensuring that the Commission is not just a participant in the system, but a powerful, independent force for its transformation. Deputy Speaker, as I mentioned, my electorate is home to 3 local RSL sub-branches. And in October last year, I dropped into the Flemington-Kensington RSL sub-branch in the south of my electorate to catch up with President Andrew Camoni-Wood and Welfare Officer Scott Balestra. The Flemken RSL describes itself as a small sub-branch with a big heart, and that perfectly sums up the crew. Andrew and Scott walked me through the history of the branch and the quiet, essential work that they do to support our local veteran community, especially the growing number of younger veterans. Scott, a combat engineer, outlined the welfare assistance that they provide not just to veterans, but also to their families. Flemken RSL may be unassuming, but its social nights and strong welfare program are doing the heavy lifting of supporting veterans as they make the shift to civilian life. And that shift, Deputy Speaker, is not just a change of job, it's a fundamental change in identity. Andrew and Scott gave clarity to what I know as a qualified psychologist. When you lose the structure, that sense of mission, the tribe that military service provides, the psychological risk factors skyrocket. We know that suicidality is often the result of thwarted belongingness and perceived burdensomeness. When a veteran feels that they no longer fit in the civilian world, or when they feel like they're a burden to their families because they are struggling with PTSD or trapped in a complex DVA claim, they enter a zone of extreme risk. The current system has, too often, made those feelings worse. It has been a maze of paperwork and for too many no answers. Where it should have been a lifeline, it became another barrier, and no one should face those barriers alone. By creating this commission, we are creating a systemic intervention. We are ensuring there is a body whose sole focus is to dismantle those barriers to wellbeing, to move from reactive crisis management to proactive oversight. A system that will support the heavy lifting already being done quietly and with enormous heart by sub-branches like Flemken. Deputy Speaker, I want to speak now about a change in this bill that I'm particularly proud of, the formal inclusion of veterans' families. There is a group of people who are often overlooked for too long in government responses to veteran affairs. At the Men in Barracks Open Day and at many services I've attended in my community, I've met the partners holding toddlers. I've met parents watching their sons and daughters with a mixture of pride and anxiety. I've met widows and proud children who honour the memory of brave loved ones who have passed on. In my electorate, the RSLs in Essendon and Keilor East and Flemington Kensington are full of those family members. They are the silent ranks. They are the primary caregivers, the first responders in the home, the ones who notice the first signs of withdrawal or the quiet onset of a flashback in the middle of the night. When a veteran is struggling, the whole family feels it. These RSLs understand that because they too have lived it deeply and personally. I see this in the spirit and care, in the spirit of community and care at the mighty East Keilor RSL. It is always a great honour to stand with them at their Anzac Day dawn service, their Vietnam Veterans Day service and Remembrance Day, all led with such dedication and deep pride by their president, John Johnson, OAM. John and his team don't just run a sub-branch, they maintain a sanctuary. Whether it's a solemn commemorative service or a Friday night social event, the focus is always on the person standing next to you and the family standing behind them. Yet, for too long, our national systems have not treated these families with the respect and care that they deserve. This bill changes that. It legislates that the Commissioner's functions must also include reference to veterans' families. And as a qualified psychologist, I know that you cannot treat or support a person in isolation. Mental health is social, it's relational. You cannot heal the veteran if you ignore the family holding them up. By enshrining families in this legislation, we are telling the silent ranks, the partners, the parents, the children of our veteran communities, we see the quiet work that you do. We recognise you, and we are making sure you never have to carry that weight alone. We are giving the big hearts of the Flemington, Kensington and the dedicated volunteers at East Keilor and Essendon RSLs the institutional backing that they have long deserved. One of the strongest messages from the Senate committee and the veteran community was that this commission must be independent in law, in function and in spirit. This bill delivers exactly that by establishing standalone legislation. The Commissioner will be appointed by the Governor-General following a merit-based public recruitment process, ensuring the role is held by an individual with a mandate to speak truth to power, without fear and without favour. We have also refined the Commission's powers to ensure it is a watchdog with teeth. Based on stakeholder feedback, we have strengthened the Commissioner's ability to access vital information and expanded the witness protection so that anyone can provide evidence without fear of reprisal. Deputy Speaker, truth only emerges in an environment of safety. These protections are the foundation of the Commission's integrity. We are creating a space where systemic failures can be called out and corrected, backed by the full authority of the law. And transparency is nothing without a timeline. This bill sets statutory deadlines for the completion of two major inquiries into the Commonwealth's implementation of reform, 2 December 2027 and 2 December 2030, the 3rd and 6th anniversaries of the government's response. These are not arbitrary dates. They are deadlines of accountability, guaranteeing the Commission remains a sustained, transparent voice for change, long after the media spotlight has moved on. Deputy Speaker, as I reflect on the history of Maribyrnong, the wartime hangars at Essendon Airport, to the disciplined grounds of the Menin Barracks, I'm reminded that we are not just a community that remembers service. We are a community that lives it. The stories of the men and women I met, the 5th and 6th Battalion, the grit of the veterans at the mighty East Keilor RSL, and the enduring heart of the members of Flemken RSL, they all point to a single, inescapable truth. The system must be as resilient as the people it serves. This legislation is the institutional embodiment of that truth. A permanent, standalone commission, a watchman on the tower who will never again be silenced or sidelined. A move from temporary fixes to sustained, independent oversight. For a person to heal, they need to know the system looking after them is honest, transparent and safe. Through the strengthened powers and the rigorous accountability deadlines of 27 and 2030, this bill finally creates the environment of trust. And most importantly, we are bringing the silent ranks, the families of those who serve, into the fold of our national policy. We're acknowledging that the ripples of service touch every partner, every parent and every child. And we're telling them your burden is seen, your role is recognised, and you will not be left to carry it alone. We stand on the shoulders of proud local legacy, but our duty is to the present and the future. We owe it to every person today who wears a uniform and to every veteran who has since laid it down to ensure that the promise of service is met with the promise of support. No veteran and no veteran's family should ever have to fight their hardest battle alone. With this bill, we are building a system that finally holds itself to the same high standard that they hold for themselves. I commend the bill to the House.
The question is that the bill be now read a second time, and I call the member for Wentworth.
Deputy Speaker, I welcome the opportunity to speak in support of this bill. I'm privileged to represent a large and deeply engaged Defence Force community in Wentworth. Our electorate is home to veterans from many conflicts and many decades of service. They are a community defined by courage, professionalism and sacrifice. They have served our country with bravery and integrity, and they deserve nothing less than our full support in return. But alongside pride in their service sits a very real expectation that this Parliament will stand behind them not just with words, but in action. After countless reports, inquiries and reviews into the well-being of service members and veterans, that expectation has never been more justified. Following the release of the Royal Commission into Defence and Veteran Suicide recommendations, I wrote to the Deputy Prime Minister and Minister for Defence in late 2024 alongside a number of my crossbench colleagues. In that letter, we called on the government to adopt Recommendation 122 of the Royal Commission as a priority, which recommended the establishment of a new independent statutory entity to oversee system reform across the entire defence ecosystem. We made that call because we'd heard directly from veterans, from families and from stakeholders in our own communities, and people very specifically in Wentworth had conversations with a number of veterans in Wentworth about this very issue. They were clear that this was, for them and for many people, the most important recommendation coming out of the Royal Commission, and that any oversight body must sit independently both from the Department of Defence and the Department of Veterans Affairs if it is to command trust and deliver meaningful change. Independence is not a technical detail. It is fundamental to the success of this reform. For too long, veterans and serving members have been asked to provide evidence and lived experience into systems they didn't fully trust. Creating a commissioner that sits separately from Defence and Veterans Affairs helps reduce that burden. It provides greater confidence that inquiries will be conducted without fear or favour, and that those who come forward will be heard and protected. It also ensures that strong protections are in place for those providing information to the Commissioner. That is essential. If we're serious about understanding what has gone wrong and how to fix it, people must feel safe to speak openly. The need for this reform cannot be overstated. Over the past 30 years, more than 50 inquiries into defence and veteran suicide have generated over 700 recommendations. Yet too often, those recommendations have not been fully implemented. None of the previous inquiries have produced adequate or effective results, in part because successive governments have failed to act decisively on the advice of experts. Today, we are living with the consequences of that failure. The incidence of suicide and severe mental health challenges among current and former defence personnel remain an ongoing national tragedy. Behind every statistic is a life loss, a family grieving, and a community changed forever. This bill represents an important step forward to breaking that cycle. Firstly, to now turn to the bill. Firstly, the bill establishes the Defence and Veterans Service Commission and the Commissioner as a standalone statutory entity. This is significant because it moves the role out of existing defence legislation and into its own framework, reinforcing its independence and ensuring that it operates with clear authority and accountability to Parliament. The statutory footing sends a strong signal that this role is permanent, independent and central to long-term reform. Secondly, the bill sets out the core functions of the Commissioner. These include monitoring systemic issues affecting the well-being of serving members and veterans, reviewing the implementation of recommendations from the Royal Commission into Defence and Veteran Suicide, and providing independent advice to government. The Commissioner will also be empowered to engage directly with veterans, families and communities, and to bring lived experience to policy for reform. This ensures that the voices of those most affected remain central to the reform process. Third, the bill provides the Commissioner with strong inquiry and information gathering powers. The Commissioner will be able to initiate own motion inquiries, conduct reviews at the request of the Minister, and compel the production of documents and information where necessary. These powers are critical. Without the ability to access information and investigate systemic issues thoroughly, the Commission would risk becoming symbolic rather than effective. Properly exercised, these powers will allow the Commissioner to identify failures, monitor progress and drive meaningful change across the defence ecosystem. Fourth, the bill includes protections for those who provide information to the Commissioner. This is one of the most important elements of the legislation. Many veterans and serving members carry difficult experiences and may feel vulnerable speaking out. Clear legal protections and strong confidentiality provisions are essential to ensuring that people can provide evidence without fear of reprisal or harm to their careers, reputations or well-being. Fifth, the bill establishes reporting and accountability mechanisms. The Commissioner will be able to publish reports and provide advice to the Minister, and those reports will be tabled in Parliament. This ensures transparency and keeps the Parliament and the public informed about progress and ongoing challenges. It also creates the expectation that government agencies will respond to findings and recommendations in a timely and constructive manner. And finally, the bill includes transitional and consequential provisions to ensure continuity. Existing functions and inquiry will transfer to the new Statutory Commission without disruption. This allows a new body to begin work with momentum and clarity. Taken together, these elements create a stronger and more independent oversight architecture than has existed previously. However, the effectiveness of this new structure will depend not only on the legislation itself, but on the commitment of government and agencies to work with it in good faith. Independence must be matched by cooperation. The Minister, Defence and Defence Departments of Veterans Affairs must be prepared to engage openly with the Commissioner and to act on recommendations. Without that, even the strongest statutory framework will struggle to deliver the change that is needed. We cannot allow this Commission to become yet another body whose recommendations sit on shelves. Its purpose is to ensure the reform is implemented, that failures are addressed, and that the well-being of those who serve and have served our country is placed at the centre of policy and practice. For the defence community of Wentworth and for communities across Australia, this reform matters deeply. It reflects years of advocacy, the courage of those who came forward in the Royal Commission, and the collective determination to do better. To those who did so, I thank you. After decades of inquiries and too many lives lost, we cannot afford to fall short again. This bill lays the foundation for stronger oversight, greater accountability, and ultimately better support for our veterans and serving members. For that reason, I support the bill, but I continue to offer the challenge to the government of this day and of future days. We set up these statutory authorities, they are important, but if we do not listen and implement their recommendations, then we are literally doing something that feels good but actually makes no difference in the ultimate end. So that will be the proof of the success of this, and whether it makes a difference to defence families and veterans' families as it should. It is the implementation that really, really matters, and that is up to this government and every government after that. Thank you.
The question is that this bill be now read a second time. I call the member for Sturt.
Thank you, Deputy Speaker. I rise to speak in support of the Defence and Veterans Service Commissioner Bill 2025. In this House, we have spoken on many occasions about the Royal Commission into Defence and Veterans Suicide that delivered a report in September 2024. This report was the culmination of 3 years of inquiry into suicide in Australia's defence and veteran population, and it noted that even one suicide is a crisis. The final report, which was an analysis of complex cultural and systemic issues relevant to suicide and suicidality amongst serving and ex-serving Australian Defence Force members, contained 122 recommendations to government, designed to provide the foundation for meaningful, practical and sustainable reform. Given this level of significance, the Royal Commission, the report and the recommendations, including their progress, should continue to be spoken about in this House with an ingrained degree of regularity. The importance of keeping this conversation going, of keeping reforms moving, of continuing to discuss and mitigate risk factors, and of providing support to serving personnel and veterans cannot be understated, and it should never stop. The final recommendation, Recommendation 122, was that the government establish a new statutory entity to oversee systemic reform on a whole-of-defence basis. The precise wording of Recommendation 122 was that the government establish a new statutory entity to oversee system reform across the whole defence ecosystem. The Australian government should establish a new statutory entity with the purpose of providing independent oversight and evidence-based advice in order to drive system reform to improve suicide prevention and wellbeing outcomes for serving and ex-serving Australian Defence Force members. This was said to be the most critical recommendation of the 122 because of the foundation it would provide to the other recommendations and the fact that it would be the most significant action the Australian government can take to address defence and veteran suicide. In response to this recommendation, the government said it agreed to establish a new statutory entity to oversee the system reform across the whole defence ecosystem as a priority. The government agreed to appoint an interim head of the oversight body to work across government and provide advice on the establishment of permanent oversight entity, including the necessary legislation to enable its establishment by September 2025. The government delivered on that commitment. and it is important that it delivered on that commitment. The position of this government and of all Australians and all participants in this House is that the death by suicide of any Australian, including our veterans and current serving Australian Defence Force members, is a tragedy. It is unacceptable that Australia has lost more serving and former serving personnel to suicide over the last 20 years than through operations in Afghanistan and Iraq over the same period. It is unacceptable. So, since September 2025, the Defence and Veterans Service Commission, legislated in February 2025, has been up and running. The Defence and Veterans Services Commission is dedicated to providing independent oversight and evidence-based advice to the government in order to drive the necessary system reform that we need to improve suicide prevention and wellbeing outcomes for current and ex-serving members. It has at its heart the goal of facilitating long-term accountability for the systemic reforms envisaged by the Royal Commission so that the lives of those who protect Australia now and for future generations are themselves protected today. And quite rightly, the Commission has a dedicated and sustained focus on suicide prevention. In order to ensure that it can report on the government's progress in implementing the response to the recommendations of the Royal Commission, on the 3rd and 6th anniversaries of the government's response, being by 2 December 2027 and 2030, the Commission needs to enjoy independence, functions and have the powers necessary to meet these objectives and to maintain the trust of the defence and veteran community. It needs to have the structures, independence and mechanisms to call for accountability in this respect, to call for more progress, for improvements, for changes. This bill delivers on the full implementation of this by enshrining the legislative establishment of the Defence and Veterans Service Commissioner and Commission into its own independent standalone legislation, as always intended. The bill promotes the required independence in that the Commissioner will be appointed by the Governor-General following a public and competitive process. The bill also operates to prescribe powers of the Commissioner, which are entirely appropriate powers and drafted through the lens of accountability. Firstly, in addition to the reporting already outlined, the bill empowers the Commissioner to further report to the Prime Minister and Minister where they consider that inadequate and inappropriate action has been taken by a Commonwealth entity in respect of recommendations contained in a report to the Commissioner. This creates an appropriate duty on those in charge of Commonwealth entities to take steps to facilitate that the entity does use its best endeavours to assist the Commissioner in the performance of the Commissioner's functions, and a similar duty is placed on officials of the entity. Then, for a Commissioner-led special inquiry to be successful and produce meaningful and broad-scale outcomes, the Commissioner needs access to all relevant information needed for that inquiry. So the bill also includes entry to premises powers and powers to obtain access to documents by remote means for Commonwealth entities and their contractors for the purpose of a special inquiry. Quite rightly, this bill also includes new offences for the provision of false and misleading information or documents, or the destruction of documents or things. Inquiries can only be successful if relevant stakeholders with actual lived experience of the inquiry subject matter are consulted in an environment where they have the confidence to give full and frank evidence and explanations. So that is why the bill expands the scope of witness protections so that a person does not encounter detriment in providing information to an inquiry. And this has two outcomes. Firstly, the risk that the Commissioner will not be provided with all information relevant to the inquiry will be minimised. And secondly, the person providing the information to an inquiry will be supported and protected. It is critical to the success of the Commission that those with relevant information do feel supported and protected in providing information to an inquiry by the Commissioner. If someone voluntarily provides information, then any necessary and applicable protections from criminal and civil penalties have been expanded. That the work of the Commission is transparent is another key focus of this bill, as is the need to cement accountability of the Commission and to cement accountability of the bodies or persons that are subject to oversight. And this bill does that in a number of ways. A focus on procedural fairness. The bill crystallises procedural fairness by requiring the Commissioner to afford a response opportunity to an agency, official or other person the subject of any criticism in a draft report. Reporting. The bill requires Commonwealth entities, officials or other persons to provide to the Commissioner information about the implementation of recommendations relevant to them. Accountability. The bill requires the government to table a statement setting out its response to an inquiry report in Parliament. Clarity. The bill provides certainty that the Commissioner may publish reports at the Commissioner's discretion and make public statements about an inquiry. Urgency. The bills include statutory deadlines for the completion of 2 inquiries into the Commonwealth's implementation of the government's response to the Royal Commission recommendations. And transparency, providing the terms and conditions of appointment of the Commissioner in a standalone bill rather than in rules. As part of my work as the member for Sturt, I have met a number of incredible veterans who have served our country with distinction, who have sacrificed, endured, felt alone, been asked to draw on every strength within them in order to act with bravery and courage for others. I won't forget one veteran in particular, Tyrone, who served in the infantry and who I met at Sea Differently in Gillies Plains in Sturt as part of the OP-K9 program. Tyrone had a beautiful OP-K9 Labrador who was his best friend and who had saved his life. Tyrone explained to me that his mental health trauma from service had previously been so bad he couldn't get out of bed. A fit, healthy young man who couldn't get out of bed. Things got better with time and he could leave the bed, but he couldn't leave the house. He couldn't go onto the street, couldn't go to the grocery shop, couldn't talk to others. Then over time, things got a little better and he could leave the house, but only with his wife. He couldn't go out alone. This, of course, affected his wife and her independence and impacted her quality of life as well. And then Tyrone joined the OP-K9 Assistance Program and was allocated a support dog named Teddy. And Teddy changed everything. His calming, confident presence has allowed Tyrone to leave the house, to go to the shop and to do things on his own, but always with Teddy by his side. It makes me deeply sad when I think that things could have been different for Tyrone, much worse, without the support of his wife and the See Differently program. And that Tyrone received the support he needed to return to being a functioning member of the community is a positive story. But there are too many veterans who do not have the same level of support. There are too many stories that do not follow the same path as Tyrone's. There are too many tragedies, and that in itself is a crisis. The changes in this bill will ensure that the Commissioner has the tools necessary so that the Defence and Veterans Service Commission is enabled to drive system reform, to improve suicide prevention and wellbeing outcomes for serving and ex-serving Australian Defence Force members. Accountability, transparency and prompt action are facilitated by this bill, and it is our duty in this House to do this. And it's not set and forget. We must monitor and measure the effectiveness of these measures and continually adapt, make changes and make improvements to ensure that the Commission and the Commissioner can always be a powerful force for the systematic change that we need. I commend the bill to the House.
The question is that this bill be now read a second time, and I call the member for Curtin.
I rise today to welcome the Defence and Veterans Service Commissioner Bill 2025 and the accompanying Consequential and Transitional Provisions Bill. These bills implement Recommendation 122 of the Royal Commission into Defence and Veterans Suicide, a recommendation the Commission described as one of its most important. They established the Defence and Veterans Service Commission as a standalone statutory entity, strengthening its independence and authority. This is a meaningful reform, and I want to acknowledge the government for progressing it. The Royal Commission heard deeply distressing evidence from current and former ADF members. It revealed systemic issues in defence culture, leadership, transition pathways, mental health care and departmental processes. At every stage, witnesses stressed the need for a body capable of identifying systemic risks, providing frank advice and ensuring accountability across defence, veterans affairs and the broader government ecosystem. These bills respond directly to that call. The Independent Commissioner will be able to undertake inquiries, gather evidence, examine systemic concerns and, critically, refer matters directly to the Minister or even the Prime Minister when required. That authority is essential to driving ongoing cultural and structural reform. Many ADF members live, work or transition back to civilian life in my electorate of Curtin. Their service places enormous physical, psychological and moral demands upon them and their families. They face unique pressures of extended postings, isolation from support networks and the intense responsibility of protecting our country. It's essential that they receive better, more holistic support. I welcome these bills and I hope the establishment of an independent commissioner will lead to tangible improvements in the health, well-being and lives of current and former ADF personnel and their families. They deserve a system that supports them with consistency, compassion and integrity.
The question is that this bill be now read a second time, and I call the member for Solomon.
Yeah, thanks, Deputy Speaker. And I acknowledge the previous speakers and acknowledge that the minister's in the chamber and congratulate him on this bill and his work in general post the Royal Commission to really drive the implementation of recommendations. And I have the great fortune of having been appointed by the Prime Minister as a Special Envoy for Defence, Veterans Affairs in Northern Australia. So it is my distinct privilege to meet with Defence members and veterans across the country, and of course in my electorate, which is Solomon, Garrison Town, Defender of the North. We have Navy, Army, Air Force bases, and we also host the US Marines and many visiting training delegations, which is fantastic because we get to improve our interoperability, learn from each other, and every day that I talk with veterans, I'm keen to share their achievements and to assist them with issues, including in the wee hours of this morning where I was spending time clearing emails, veterans with help, and it's the very least that we can do for those that have put on the uniform and served our country. Every member of the ADF should be safe in the knowledge that whatever may happen in their service, of them and their families, will be looked after and acknowledged by our grateful nation. It's our nation's duty to empower and support the mental health and wellbeing of our defence and veteran community,
It's something I'm very passionate about as a fourth generation veteran, because there is an expectation that we will look after those that have done so much for us in the defence of our nation, the representation of our people overseas. With the Minister and others, I lobbied hard for the Royal Commission into defence and veteran suicide. We heard the calls from the veteran community, from their families, and we have acted initially in working with the government of the day to establish it, and now, as I said, with the interim report being released in 2022, really getting on with implementing those recommendations, particularly those that were most urgent. And that interim report, we've acted on all of those recommendations, and the final report, one of the 122 recommendations was to establish a new statutory entity to oversee systematic reform across the whole defence enterprise, the ecosystem. And it said that this would underpin all the recommendations that precede it and be the most significant action the Australian Government can take to address defence and veteran suicide, to establish this new statutory authority. So in acknowledgement of the significance and the urgency of this recommendation, in February 2025, our Labor government, federal government, legislated the Defence and Veteran Services Commission, and that's been up and running since the end of September last year. The role of this new statutory entity is to provide independent oversight and evidence-based advice to drive system reform, to improve suicide prevention and the wellbeing outcomes for the defence and veteran communities, including our families. The Commission will have a dedicated and sustained focus on suicide prevention. It will ensure agencies implementing Royal Commission recommendations will be held to account by promoting long-term change and driving the systematic reforms needed to reduce the rates of suicide and suicidality among serving and ex-serving ADF members, and for that matter, their family members. To do this, the Commission must have the independence, the functions and powers necessary to meet these objectives and maintain the trust of the Defence and Veterans community. The Defence and Veterans Services Commission Bill then builds on the work undertaken by the Parliament in February last year, when Schedule 9 of the Veterans Entitlements, Treatment and Support, that Harmonisation Act 2025 was passed and a Senate inquiry was undertaken. So, Deputy Speaker, let's go to independence. The submissions, evidence and the committee's report have informed the development of the bill, implementing the following recommendations. 1, that standalone legislation for the Defence and Veteran Service Commission will reflect its independence. This bill strengthens the independence of the Commissioner by ensuring that the role is appointed by the Governor-General after a merit-based and public recruitment process, so everyone can apply, public process. The Commissioner will be an independent statutory office holder when appointed. The Commissioner will carry out their functions and exercise their powers by looking through a system-wide lens, and to reflect their independence, the bill confers on the Commissioner complete discretion in carrying out their functions and powers and appropriately limits directions, including from the Minister. There's a subclause, 12.2, that in particular would ensure that the Commissioner has substantial discretion to determine how they will carry out their role. That independent judgment about what is best for the veteran is so important. Under Clause 50, the Commissioner is empowered to make public statements, which is important in keeping people informed, and transparency in the goals, function and operations of the Commission is paramount. It improves the transparency of the work of the Commission to ensure accountability for the Commission itself and those subject to its oversight. This includes statutory deadlines for the completion of 2 inquiries into the Commonwealth's implementation of the Government's response to the Royal Commission recommendations. Those deadlines are the 2nd of December 27 and the 2nd of December 2030, which are the 3rd and 6th anniversaries of the Government's response to the Royal Commission's recommendations. This bill strengthens the Commissioner's powers in ensuring transparency and accountability across defence and the veteran ecosystem, and enables accessing necessary information and disseminating public statements. So, Deputy Speaker, what I was just talking about went to the independence of the Commission and the Commissioner. Now, I want to go to families. The Commissioner's functions include reference to veterans' families. There is no doubt, zero doubt, that families and veterans, or families of veterans, play the most vital role in the health and well-being of veterans. But they also face unique challenges themselves. Our government, the Albanese government, is pleased that through this legislation we're able to acknowledge the significance of veterans' families. The Commissioner will be empowered under subclause 10(1) to promote understanding of suicide risk for veterans and factors that can improve the well-being of veterans through engaging with people with lived experience and the families of veterans. Last year, Deputy Speaker, I spoke at the Veterans Family Roundtable held here in this place, in Parliament House, and was fortunate to attend with the Minister for Veterans Affairs and my parliamentary colleagues and speak to the representatives there. It was a fantastic event run by the Families of Veterans Guild, and I'd like to take a moment to pay tribute to the Guild and to their CEO, Renee Wilson, for the organisation and for Renee's tireless advocacy for veterans' families, an issue very close to her heart. Theirs is a very worthy cause and one I fully support. At that event, I listened to the stories of veterans' families that have been affected by tragedy and hardship, a genuinely moving experience that all honourable members should seek out in order to expand their knowledge of the challenges faced by veterans and their families. A very deeply moving, as I said, event. We've also held events, and I want to pay tribute to Danny Everly from my electorate herself, like Renee, the partner of a serviceman, who has done some great work as well. And it was great that people like Danny were able to spend time with the Repatriation Commissioner and the Veteran Families Commissioner in Darwin, Khalil Fegan and Annabelle, in Darwin last week. And I'm thankful to them for heading up to Darwin and having those conversations with our local veterans and families. Deputy Speaker, veteran families often carry a lot of the burden of their service, as well as being the biggest carer and the biggest enabler of capability, and it's not well understood, not well enough understood. We've got a lot to learn from the experiences of our families, and we need to do everything we can to support them. In understanding the experience of the families, we can make the system better support the families. In the conduct of the duties of the Commissioner can invite the making of submissions under Clause 20. A feature of the legislation that I quite like is the ability to invite these from the public, from veterans, and importantly from their families, so that we can better understand how the system is working for veterans and their families and hear from them on an ongoing and a timely basis. And of course we want to hear how the system is not working for them as well, so that we can address issues. Having spoken to the independence of the Commissioner and also about families, I want to just go to ongoing reform in the time remaining. The Commissioner is empowered to be an agent of change and improvement. Their functions would enable the Commissioner as an oversight body to monitor, inquire into, to report on and to provide advice on systemic reforms, including the Commonwealth's implementation of the government's response to the recommendations of the Royal Commission. The government has listened to feedback from stakeholders and has taken action. These changes to the bill will ensure that the Commissioner has the tools necessary to ensure that the Defence and Veterans Service Commission is enabled to drive that systematic reform that will improve suicide prevention and wellbeing outcomes for both currently serving and ex-serving Australian Defence Force members. This will mean agencies are held accountable to consider and respond to the Commissioner's recommendations. The enduring nature of the Commission will ensure that the voices of our veterans continue to be heard and systemic issues that contribute to suicide in our veteran community are continually reviewed and addressed. Deputy Speaker, every day I have the privilege of engaging with veterans in our community, as I said, listening to their experiences, working to ensure their needs are met, listening to their family members, working to ensure that their needs are met. Those conversations continually remind me of the depth of service and sacrifice that underpins our freedoms in this nation, that underpins our Australian sovereignty and our way of life, and this is the guiding light for my work in this Parliament, as it is for other members of this place. And I hope that in time that understanding continues to grow in members of this place so that they can be a consistent source of support to veterans and their families in their electorates. And this bill is certainly a step in the right direction to that end. In the time remaining, Deputy Speaker, I want to give a shout out to all those who helped organise and conduct a very successful Welcome to Darwin event at the Convention Centre on the weekend. It was a fantastic event with a whole range of community stalls, and it was really, you know, our community opening its arms wide to ADF members and their families that have recently been posted into Darwin to say welcome. We're really glad to have you here. We love having you here. We'll do everything we can to make your time in Darwin as enjoyable as possible, and we hope that you elect to go for repeat postings up in Darwin, make Darwin your home, and help us with this enterprise in the national interest that we're also engaged in to keep our nation safe and to protect the interests of our nation. And I want to thank all the families. Thanks, Deputy Speaker.
The question is that the bill be now read a second time, and I call the member for Canning.
Thank you very much, Deputy Speaker. How a nation cares for its veterans and their families is an insight into the character of that nation. And as we reflect on the last 120 years where Australians have gone to distant shores to defend Australia and its interests, we note that more than 100,000 Australians have given their lives wearing our uniform and serving our country. And it's right that we remember and honour those people on Remembrance Day, on Anzac Day, and I know many Australians have a lot of pride in our Defence Force and in our veterans, and it's always great to see such big turnouts on those 2 days. But it's also important that government does its job and looks after veterans and their families. And that process is one that requires constant reform. It's not something that we can just forget about, but we have to constantly revisit it as we move forward into the future and as we reconcile with the wars that we've just fought, particularly in the last decade in Afghanistan. And I think it's important to say that things haven't been done well over the last 20 years or so. And that's why the Coalition established the Royal Commission into Defence and Veteran Suicide, because veterans and their families deserve truth and accountability. Confidence in the system had broken down. I know this myself, being a veteran, but also having to work through my own claim through DVA. I remember testing the system more than 5 years ago in the Minister's office, starting my process there, and it took about 4 years before it was completed. And so I got a sense of what many veterans go through when they encounter DVA. So the Royal Commission confirmed what families and the veteran community had been saying, and that is systemic failure requires reform. And everyone here in this House on both sides is committed to reform. And one of the most significant recommendations was the creation of a permanent independent statutory oversight body to drive reform and to measure progress. And these bills are intended to give effect to that recommendation, and the Coalition supports that objective. I support that objective as a former veteran. An independent oversight with real powers, public reporting and parliamentary accountability is essential. I believe in our institutions, I believe in accountability, and nowhere more importantly than in the veteran space. Now, establishing the Commission through standalone legislation is what the Coalition has argued for a long time. It's what we've argued for from the beginning. And the government's original attempt to create the Commission through a late amendment to unrelated legislation was rushed and lacked proper consultation. The Coalition supported the amended Vets Bill to avoid delaying compensation and rehabilitation reforms for veterans, but not because we supported the government's process or the structure. We supported it because always we put veterans first, and we saw the need for urgency and the need to get things done. That's why we supported it. We also made it clear at the time that the Commission should be established through standalone legislation, separate from defence and DVA, with stronger independent guarantees. So we moved an amendment to ensure a dedicated Senate inquiry could provide proper scrutiny of the Commission model. And that inquiry confirmed widespread stakeholder concern about independence, about its structure, about its powers, about family inclusion and clarity of remit. And this bill is now stronger because of the contributions of those individuals and ex-service organisations. And I want to thank every single person, every single organisation that took time to make a submission to appear before the Royal Commission and enhance this policy, which is now going to be enacted through this bill. I also want to make the point here that this is not a new idea from Labor. The Coalition introduced legislation to establish an independent National Commissioner for Defence and Veteran Suicide Prevention back in 2020, more than 5 years ago. And that bill proposed an independent statutory oversight body with the same structural features now being implemented. And I want to note in the House that Labor opposed that legislation at the time for political purposes. And as a result, the establishment of an independent statutory oversight body was delayed. Now, the structure that Labor is now implementing closely mirrors what we proposed back in government. And if the Coalition's National Commissioner model had been supported instead of being opposed by Labor, independent oversight would already be underway. So the Coalition will support this framework now because veterans and families cannot afford further delay, but I think it's important that that history should be acknowledged, particularly in the veteran community. Veteran care should not be a political issue, and I think it's fair to say that where we land today is bipartisan, but it hasn't been perfect, but we're here, and I think we've come together for veterans and their families, and that's an important message they need to hear from this House. The Coalition will be moving an amendment to bring forward the timing of the first implementation review by the Commissioner, and as currently drafted, the first assessment is not required to be completed until December 2027. We think that's too slow. It's much too slow. We want to bring that back 15 months, and our amendment would require the first implementation assessment to be completed no later than the 30th of September of this year, 2026. I think that's more than sufficient time to assess whether early stage reforms are being delivered. I think earlier reporting ensures veterans, families and Parliament can see measurable progress, and it falls in line with our overall objective, which is that the reforms recommended by the Royal Commission be implemented quickly and assessed openly. I think transparency is absolutely critical here, and in the end, what we care about is our servicemen and women and their families being cared for. They have to respond quickly when their nation calls. I know many have leave, particularly over Christmas, disrupted, whether it's to deploy overseas or indeed respond to natural disasters. They drop everything for our country. I think it's important that we get on with the job of getting this review done. So, As our ADF personnel move with a bias for action, I hope too, once this bill is passed, that the government will move for a bias for action as well and look after our veterans and their families. Thank you.
The question is that the bill be now read a second time, and I give the call to the member for Adelaide.
Thank you, Deputy Speaker. And Deputy Speaker, can I just pay tribute to the two previous speakers, the member for Canning and the member for Solomon, and recognise both having distinguished careers in the Defence Force and being very capable people to talk on this particular subject. And we thank them for their services, putting themselves on the front lines to protect our wonderful nation. Deputy Speaker, governments of all persuasions, and this government is supporting those that fight for this country. They put, as I said, their bodies and minds on the front line for us. They become tough leaders, strong, persistent. However, who is there remaining to help them when they come back home? Deputy Speaker, the role of the Defence and Veterans Service Commissioner is designed to bring greater openness, understanding and care to the system that supports current and former members of the Australian Defence Force. The Commissioner will report publicly to the Minister and to the Parliament, creating a clear and transparent pathway for identifying what is working well and, importantly, what is not working well. And its core, this role exists to help meaningful reform aimed at improving suicide prevention and an overall well-being for those who have served. Far too many individuals and families in the veterans community have been touched by loss, by grief, or a long-term struggle. So the Commissioner's work will recognise this reality and seek to shine a light on systemic issues that can contribute to the distress among serving and ex-serving members. The Defence and Veterans Service Commission Bill draws on the findings and recommendations, Deputy Speaker, of the Senate Foreign Affairs, Defence and Trade Legislation Committee's review. It reflects an effort to take those recommendations seriously and respond in a way that strengthens the systems veterans rely on through out and after their service. And it also reflects on the Royal Commission with its 122 recommendations. The Commission will play an important role in improving transparency, accountability across the border defence and veteran support landscape by monitoring, investing and investigating and publicly reporting on systemic issues. The Commissioner aims to support sustained long-term improvements. This work will help to rebuild trust within the veterans community. Deputy Speaker, the trust, we need to build that trust, but trust that their concerns are heard, that the veterans' concerns are heard, their experiences matter, and action is being taken to better meet their diverse and often complex needs. Importantly, the Commissioner's mandate is very broad. Nothing is off limits when it comes to identifying and examining the structural or administrative factors that contribute to risk. And this includes looking closely at the Commonwealth's policies, programs, systems and its practices. The goal is not to assign blame, but to understand why certain issues persist and how they can be addressed with compassion, evidence and, of course, very importantly, accountability. The Commissioner's work acknowledges the simple truth. Behind every statistic, there is a human being, a person, a family, a spouse, a child, a son or a daughter, a network of friends, and a community forever changed. So, Deputy Speaker, by addressing systemic issues openly and thoroughly, we move closer to building a system that genuinely supports well-being, honours the service that these people have given for their nation, and offers real pathways to healing and hope for those who have given so much. Deputy Speaker, the Commissioner has the ability to undertake inquiries on their own account, on their own motion, providing a wide net for the niche and unusual, and it allows the Commissioner to take an initiative rather than waiting and it means being proactive and taking preventative measures before families, sons, daughters, mothers and fathers say goodbye too soon. Deputy Speaker, the Commissioner is not a role for the government, that is made up to tick a box. This is after extensive research and investigation from the Royal Commission into Defence and Veteran Suicide, and we heard the member for Solomon speak extensively about the Royal Commission. Recommendation 122 of the final report suggested establishing a new statutory entity to oversee the system reform across the whole defence work, and it was deemed to be the most important recommendation. So this is something that hasn't just been a thought bubble, something that's come out of that Royal Commission and the most important recommendation. So these bills before us are to establish that role of the Commissioner, and the role of the Commissioner is to complement the Defence and Veterans Service Commission legislation by this government back in February 2025. So the Commission has been up and running since September, overseeing the whole defence ecosystem. However, that's not enough. We need these bills to pass for our commitment to better the life of the ADF personnel and veterans, and we need a Commissioner to act in the best interests of veterans and those serving in an independent manner. And we need to see proactive steps to prevent the ongoing trend of all the issues associated with veterans when they leave the Defence Force, whilst they're in the Defence Force, and all those things that we heard during the Royal Commission. The Commissioner's role is designed to look at the entire system, as I said, the entire ecosystem, the policies, structures, practices that shape the experiences of current and former Defence Force members. Their work isn't about investigating individual cases or single decisions. Instead, the Commissioner steps back to see the bigger picture, identifying patterns, identifying underlying issues that may be contributing to harm, and systemic patterns and issues that may be contributing to harm. So the broad perspective is deliberate. It ensures the Commissioner can focus on what truly matters, preventing future suffering and by recognising system-wide problems that might otherwise remain hidden. To honour this responsibility, Deputy Speaker, the bill gives the Commissioner full independence on how they carry out their work. No one, absolutely no one, including the Minister, can tell the Commissioner what conclusions to reach or how to conduct an inquiry. Their loyalty is solely to the truth and to the well-being of the people their work is meant to protect. To ensure the Commissioner can uncover the realities that veterans and their families face, the bill grants special powers when an issue is serious enough to require deeper investigation. In these situations, the Commissioner can request documents, ask questions, and if necessary, seek a warrant to gather that information directly. These are powers that don't exist at the moment. These powers exist, again, not to intimidate, but to make sure nothing stands in the way of understanding why detrimental situations occur, and even more importantly, how they can be stopped. At the same time, the law protects the Commissioner, their staff, and anyone who steps forward with information, and this is essential. People who share their stories, often painful and private stories or difficult stories, must know that they are safe to speak out honestly and openly. Deputy Speaker, because the Commissioner will be entrusted with highly sensitive information, the bill creates strong safeguards. It becomes an offence for the Commissioner or anyone working with them to share that protected information unless it is currently allowed under the law. And this ensures that personal stories, private information, medical details and confidential experiences are treated with the respect, dignity and the care that they deserve. Deputy Speaker, when the Commissioner completes an inquiry, the process is open, fair and designed to ensure accuracy. A draft report must be prepared and shared with those whose actions or responsibilities are discussed. This draft will include the findings, the evidence behind them, and any recommendations for change. If an agency or organisation is involved, its leadership is given the chance to respond. This step matters because it recognises that change is most effective when everyone has been heard, when those involved can clarify, correct or contribute to the understanding of what has happened. Deputy Speaker, all of this is about ensuring the experiences of veterans, including their pain, their courage and their hope, lead to real change. Deputy Speaker, we know that veterans, Vietnam veterans living alone, young veterans raising families, naval personnel connected to the shipbuilding precinct, RAF members transitioning into civil life, reservists balancing service with their careers, all of these experiences and all of the experience that these people have can help shape the national picture. So the Commissioner's work ensures those experiences are not lost or ignored or dismissed. Instead, they are part of the driving force behind the systemic change. It means veterans are not expected to struggle alone. It means families can trust that someone is watching over the system. And it means problems that were once hidden or not brought to the light can be brought forward and addressed properly, systematically. And it means every story, every challenge, every frustration, every moment of courage can help create change. And ultimately, it means that veterans and their families can feel seen, respected and supported by a system that genuinely strives to do better. Just before I resume my seat, Deputy Speaker, I also like to pay tribute to a great Australian in my electorate, Julianne Finney, who worked so hard for the Royal Commission a few years ago and still works voluntarily without pay, without any benefit, to have veterans' voices heard. And I think at times like this, we come to a certain point with legislation, with Royal Commissions and the work that we do here, but we should always think of those people who advocated strongly to bring us to this position, to bring about change. And I pay tribute to Julianne Finney today as well.
The question is that the bill be now read a second time, and I give the call to the member for Gippsland.
Well, thank you, Deputy Speaker, and I rise to speak in support of the Defence and Veterans Service Commissioner Bill of 2025, notwithstanding the Coalition will be moving some amendments in relation to the reporting date of the Commissioner in the legislation. And at the outset, Deputy Speaker, I want to say simply thank you for your service to the men and women in the Australian Defence Force and our veterans community, but particularly to their families who support them and the members in this place who have served in uniform as well. Thank you for what you've done in your previous career and bringing that expertise and lived experience to either the House of Representatives or the Senate. Deputy Speaker, the purpose of the Department of Veterans Affairs is to put in place a system of support for our veterans and their families if it's required. And I emphasise the point about if it's required, Deputy Speaker, because a large number of our service personnel will train well, serve well, be deployed, defend the values of our nation, and then they'll transition well and go on to live exceptionally successful civilian lives. Mm-hmm. But if they're fed a diet of hopelessness and helplessness, which is often the case in the Australian mainstream media, they sometimes get the feeling that there's no help available to them whatsoever. And that is simply not true, Deputy Speaker. So I say to anyone who may be listening to this debate that if you are a veteran and if you do need help, help is available. Please reach out through your ex-service organisations or through DVA directly, because help is available to you if it's required. In the Veterans Covenant, Deputy Speaker, there is a term which is very simple. It says, "For what they have done, this we will do. For what they have done, this we will do." That is the promise we make as Australians who haven't served in uniform, that we have this contract with Australian Defence Force personnel and their families. For what they have done, this we will do. That contract requires us to support them after their service obviously during their service as well, but certainly to support them after their service. And those support measures will change over time, just as society is changing, and sometimes for good, sometimes for worse. But just as our society is changing constantly, the needs of our Defence Force personnel and our veterans will change as well. What a young veteran needs on transition to civilian workforce is going to be very different to the supports required by a 95 or 98-year-old World War II veteran. And we need to acknowledge that the DVA system is there to support veterans through the entire course of their lives as their needs change as well. So I do want to acknowledge that the legislation before the House is intended to make sure there is proper oversight, accountability and transparency around the systems put in place in this place via DVA to support our veterans and their families. An independent commissioner has enormous opportunities to make sure that the system remains fit for purpose into the future. Our veterans make a huge contribution during their service, but they also make an amazing contribution when they leave the service and in their civilian lives. And it's so important that they are supported in that transition phase. Because, and I say this in the Minister's presence, I am sure that just like myself, in his role, the need to reduce the level of self-harm, the need to eliminate suicide is an ongoing battle. There is no acceptable level of suicide amongst Australian Defence Force personnel and veterans, and I'm sure the Minister agrees with me that we need to keep working towards zero, because that is a challenge that we need to address in a bipartisan way across this chamber. And I'm sure it's going to surprise some people listening to hear me say this, but there is an amazing amount of bipartisanship on this portfolio issue, on this area of key responsibility. My office works very closely with Minister Keogh's office, and we have a very good working relationship. There have been times in recent months where we've disagreed vehemently, but it was professional and we got on with our roles. But wherever possible, there will be bipartisanship on this side of the House to the government of the day in terms of our veterans and their families. Our number one interest has to be making sure veterans and their families are well supported as they move on to their civilian lives. So, having said that, Deputy Speaker, I'll also note in the Minister's presence that most of the easy stuff has been done. In this portfolio, everything's complex, everything is difficult, everything involves personal challenges for the people involved, and the system isn't always fit for purpose, and the challenge of reforming it is not something that I suggest for a second is a walk in the park. But I do wish him success in his tenure, because if the Minister is successful as Minister for Veterans Affairs, our veterans will flourish, their well-being will improve, the families will do better. So I sincerely do extend my best wishes to the Minister in his role as he seeks to try and improve the system of support for veterans and their families. It's important though, Deputy Speaker, as we gather today to talk about this legislation, just to acknowledge a couple of simple facts as well. This is not a new idea. Those opposite might think that the world was created on the day the Albanese government came to office in 2022, but let me assure you, some good things happened before that, Deputy Speaker. And this idea, this concept of a National Commissioner, was actually included in coalition-introduced legislation back in 2020. Now that bill, which proposed an independent statutory oversight body with basically exactly the same features, the structural features now being implemented today, was opposed by the Labor Party at that time. I was disappointed as Minister that occurred. I think it was opposed for political reasons, and I was frustrated by the decision the government took, the opposition took at that time. Because the delays in implementing this independent commissioner has resulted in delays in having an independent statutory oversight body for the system. And it matters because working alongside the Royal Commission, we could have accelerated system reform in that period of 4 or 5 years. So it's fair to say that the Coalition supports the National Commissioner model being presented today because it was our idea. And it was our idea and it came from feedback from the lived experience of veterans and their families. I didn't make it up. It wasn't something I just dreamed up one night by myself. It came about through feedback from ex-service organisations that had strong support in the veteran community, but we weren't successful in getting it legislated back in 2020. So I say to the Chamber, and I say with all sincerity to our veterans community, the Coalition will always look to find ways to put veterans and their families first, and we will support the government in this legislation. with the amendment we're proposing, which I'll get to later on. Our record as a coalition in terms of supporting veterans and their well-being is substantial. In our time in government, there were some substantial reforms by myself as minister and other ministers on the coalition side, despite the rhetoric we hear from those opposite from time to time. Under our time in government, the role of the Minister for Veterans Affairs was actually in Cabinet. And I think that's a mistake to have it not in Cabinet. I'm not solely motivated by my best wishes for the Minister's political career, but the Minister should be in Cabinet. The role of Veterans Affairs, where there are 600,000 veterans in this country, plus their families, the Minister should be in Cabinet. Now, in our time in government, the support for our veterans and their families was in the order of $11 billion per year. There was the Royal Commission, which was established, and the Defence and Veterans Suicide, established under the Morrison government. We introduced and passed the Veterans Recognition Act of 2019. We provided free non-liability mental health care for our veterans. We expanded and modernised Open Arms, the Veterans Counselling Service. We initiated the Psychiatric Assistance Dogs program, which has been very well received and has resulted in literally hundreds of veterans receiving the benefit of a psychiatric assistance dog, which the veterans themselves and their families have written to me personally and thanked me for in some of the most beautiful letters I've received as a member. Now, Deputy Speaker, we also established the Prime Minister's Veterans Employment Awards, which I note have continued, and I thank the government for doing that. We launched the Veteran Wellbeing Centre program, and the current government has added to the Wellbeing Centre program. I encourage them to keep doing that because I think those hubs are very important as providing accessible areas for our veterans, particularly in regional areas, to get the support they need when they need it. We created the role of the Veterans Family Advocate. We committed $500 million to the Australian War Memorial redevelopment, which will ensure the stories of our contemporary veterans will be told in a timely manner. We established the Joint Transition Authority, which is designed to make sure Defence is held more accountable for that critical time when our members leave the Defence Force and go on to civilian life. We delivered provisional access to medical treatment. We increased the fees for health professionals. We improved financial support for veterans undertaking additional education. We boosted staffing and resources across the Department of Veterans Affairs to speed up the claims processing. And we also added a question in the census to track the number of veterans in Australia for the first time. Now, you'd think that was a minor point, but up until the 2021 census, we didn't know how many veterans we had in Australia. So simply adding that question in the census gave us the capacity to, first of all, measure the number of veterans in Australia, people who served at least one day in the Australian Defence Force, but also track where they are in the sense of making sure services are provided in a manner that fits the veteran population in those communities. So while it may seem like a small point, Deputy Speaker, it's something that I think will assist DVA and the Minister in his role going forward. And I do note, Deputy Speaker, as I said earlier, work in this space will never really be finished because the needs of modern veterans will change, they'll be different to previous generations, and we do support the extra scrutiny and the transparency in a timely manner, which is at the core of the appointment of a Defence and Veterans Service Commissioner who is going to be separate and independent from the department and separate from the Minister. Now, I flagged earlier, Deputy Speaker, we'll also be moving an amendment, and the amendment is quite a simple one. We'll be moving to bring forward the timing of the first implementation review by the Commissioner. So what we're aiming to do, Deputy Speaker, here is not hinder the passage of the bill, but simply, as currently drafted, the first assessment of the government's implementation of the Royal Commission's recommendations is not required to be completed until December 2027. And that means that while government may get the report in December 27, it may not be tabled for many months after that. We could be well into 2028 before we see the report. So we fear that's a bit slow. We feel it's a bit risky in terms of weakening accountability, and we'd be much more comfortable if we could bring forward that reporting date to no later than 30th September 2026. Our view there is that the veterans and families were promised urgent reform out of the Royal Commission, and unfortunately Royal Commissions have a habit in this country of sitting on a desk and eventually being forgotten about. By bringing forward the reporting date, and that would coincide with the 2-year anniversary of the actual Royal Commission tabling their findings, We think that's a better way of ensuring that veterans and their families have confidence that the bureaucracy in Canberra is not slowing this down, that the Commissioner will report back to the Australian public in a more timely manner, and we can see some evidence of what's actually being implemented, where we need to hurry things up a bit, and if there are any changes that need to be made, the Commissioner would be in a position to make those recommendations at an earlier date. So we do believe that's more than sufficient time to assess whether the early stage reforms are being delivered and whether the government commitments are translating into real action on the ground for Australian Defence Force veterans and their families. So we think the amendment is credible. We think it strengthens the transparency and reinforces accountability, and it doesn't change in any way the Commissioner's independence or the Commissioner's powers. So we do commend our amendment to the government, commend it to the crossbench as well. It is a simple amendment. It's all about making sure there is increased transparency and a sense of urgency is instilled into the bureaucracy, because as much as I have had an incredibly positive working relationship with senior members of the Australian Public Service during my time in ministerial offices, there have been times where I've been frustrated by the urgency shown by some in the department. So let's put it politely that an occasional push along wouldn't hurt the Australian public servants on some of these issues. So, Deputy Speaker, I'm going to finish where I started. That simple line, for what they have done, this we will do. It's a contract, but it's also an action statement. This we will do. It requires our action. This is not pretty words on a piece of paper just to be forgotten about. The Veterans Covenant is the contract for men and women who've never served to recognise that there are people who have put on that uniform, they've been willing to place themselves in harm's way, and sometimes they get physically or mentally injured in that process. For what they have done, this we will do. We honour them and we respect them by living up to our side of that contract. They have done their job, we have to do our job. It's an action statement, Deputy Speaker, and it requires us to take the action required to support our veterans and their families. So I do urge the Minister to think seriously about the amendment put forward by the Coalition. In this place, we do have the opportunity. It's an incredible opportunity, every member in this place. We have the opportunity to stand up here, make speeches, but also make speeches which require action, to take action which improves the lives of veterans and their families, and subject to the Coalition's amendment, I commend this bill to the House, and I look forward to working in the same spirit of bipartisanship as I've demonstrated in these comments today with the Minister when I return from the sin bin on March the 1st.
The question is that the bill be now read a second time, and I give the call to the member for Gorton.
Thank you, Deputy Speaker. I rise today to speak in support of the Defence and Veterans Service Commissioner Bill 2025, introduced by the Minister for Veterans, and I commend him for doing so, and I note his presence in this chamber today. I'm proud to come from a family who have served our country. My grandmother, Jean Lynette Jordan, and her sister-in-law, Sergeant Marjorie Steele, also known as Sarge Marge, supported the Second World War effort from Australia through their work with the Australian Women's Land Army. My grandfather, Stanley Jack Jordan, served in the Air Force in the Second World War. My dad's grandfathers, Robert Bruce Baird and Alfred Caldwell, also served in the Air Force in Darwin during the bombings of 1942, but returned home to Melbourne post-war. My great-uncles were not so lucky and sadly perished while they were serving overseas. These men gave their lives to our country, and I'm proud to stand on their shoulders. Once the soldiers returned home from the Second World War, many received pieces of land in regional Victoria, including my great-grandfather, Stanley Jack. Stanley Jack was my grandfather's dad. He was provided a soldier settlement farm by the Australian government near Tatura, along with many veteran families. But living post-war wasn't easy. My grandfather recalls a time post-war when his dad, Stanley Jack, had woken up in the middle of the night and jumped out of a window from the fear of a nightmare. This is post-traumatic stress disorder, and it's a reality that many veterans live with every single day. There's a reason we tell these stories, because it's a part of us. And it's a part of our nation's shared history, shared heritage, and shared culture. We tell these stories to keep them alive, to honour and remember those they're about. Those who are no longer with us, those lives who were cut short too young an age, like my great-uncles. So I'd like to tell you another story about one of my mum's relatives. Hugo Thrussell, VC, was an Australian soldier in the First World War. He served in Gallipoli, the Sinai and Palestine, and fortunately returned home to Australia safely. He was the first Western Australian and the only light horseman to receive the Victoria Cross, or VC, the highest award for valour in battle that could be awarded to a member of the Australian Armed Forces at the time. Unfortunately, even an honour like this doesn't take away from the pain. While Hugo physically came home, his mind had never truly left the battlefield. 15 years later, Hugo committed suicide. These servicemen and women see unimaginable things. They go through unimaginable trauma and are plagued with this mental harm forevermore. A statue of Hugo now stands in the Avon Mall in Northam, and his Victorian Cross can be seen in the Australian War Memorial here in Canberra. His legacy lives on and is a reminder to us all that we must do better. We must do better for veterans in our country, and that's exactly what this bill is about. This bill is a response to the Royal Commission into Defence and Veteran Suicide, which delivered its final report in September last year. I'd like to thank the current and former serving personnel and their families who have bravely shared their stories with the Royal Commission. The Royal Commission was an important moment for our country. It was a moment to give proper recognition to our ADF personnel and veterans for what they do for our country, and at what cost. This recognition extends to the families and communities of ADF personnel and veterans. The Royal Commission was a once-in-a-generation opportunity to learn and strengthen the Defence's approach to mental health and welfare, and to create a better workplace experience for personnel. And most important was the findings. The Royal Commission found that for our veterans and our servicemen, the system wasn't working. The Commission made 122 recommendations. Recommendation 122 was that the government establish a new statutory entity to oversee system reform across the whole defence ecosystem. The Royal Commission said that this was its most important recommendation. It said that this recommendation would underpin all of the other recommendations that would precede it. This is the most significant action the Australian government can take to address defence and veteran suicide. So that's what we're doing. In acknowledgement of the significance and urgency of this recommendation, in February 2025, the Albanese Labor government legislated the creation of the Defence and Veterans Services Commission, and it's now been up and running since the end of December. And now we're establishing the Defence and Veterans Service Commissioner and Commission into its own standalone legislation, as it was always intended, and we're strengthening it. The role of the new statutory oversight entity is to provide independent oversight and evidence-based advice to drive system reform to improve suicide prevention and wellbeing outcomes for the defence and veteran community. And what's unique about this statutory oversight is its focus. There is a dedicated and sustained focus here on suicide prevention. Since this underpins the rest, it really matters that we get this right. We're ensuring that agencies implementing the Royal Commission recommendations are held to account, that they're promoting long-term change and building structural change the system needs to reduce the rates of suicide and suicidality amongst serving and ex-serving ADF members. The Senate Foreign Affairs, Defence and Trade Legislation Committee gave a list of recommendations for what should be included in this bill. I'd like to thank the committee for their work, and I'd like to run through some of those really important recommendations now. The first recommendation is the implementation of standalone legislation for the Defence and Veterans Service Commission to reflect its independence. As I've mentioned previously, this bill is about delivering on this commitment. Recommendation 2 was that the Commissioner functions include reference to veterans' families, and the Senate committee review did just that. It means that stakeholders have an opportunity to raise their concerns with the legislation. These are the people who are closest to the issues at hand, the ones that will feel the impacts of these reforms every single day. And they're the people whose experiences have shaped this legislation. There's no doubt that families of veterans play a vital role in the health and well-being of veterans, and these families face their own unique challenges as well. That's why it's so important that these community members, the real people, form the building blocks of this legislation, because they really are the centre of it. I'd like to thank every member of the community who contributed to this committee's review. Your insights, your experiences are invaluable. This bill is also strengthening the Commissioner's independence and powers. The Commissioner will be empowered to report to the Prime Minister when they are of the opinion that adequate and appropriate action has not been taken by the Commonwealth entity in respect to recommendations contained in a report of the Commissioner. This is so powerful because it truly puts the duty of the heads of Commonwealth entities to make sure that the Commissioner is being assisted properly in carrying out their functions. This bill will also make sure that the Commissioner has all the relevant information needed for a special inquiry, enabling them to gain access to documents by remote means. And it includes new offences for the provision of false and misleading information or the destruction of documents or things. These are all to support the Commissioner to carry out their job to the best of their ability. And as for ensuring the Commissioner's independence, a person will not be eligible to be appointed as Commissioner if they have served in any capacity in the ADF within the past 5 years. The Commissioner will be appointed by the Governor-General after a merits-based and public recruitment process. This is important to mention because it's important that the Commission and the Commissioner remains independent so that we can ensure the purpose of this bill is met: independent oversight, evidence-based advice. The bill also expands on the scope of witness protection by ensuring a person providing information to an inquiry is protected in doing so. And it improves the transparency of the work of the Commission to ensure accountability for the Commission itself and those subject to its oversight. This includes statutory deadlines for the completion of 2 inquiries into the Commonwealth's implementation of the government's response to the Royal Commission recommendations. Veterans are really important, Deputy Speaker. They have done so much for our country and they do so much in our local communities. I'd like to share a little bit about the amazing Caroline Springs RSL sub-branch in my electorate of Gorton. This sub-branch RSL was established in November 2013 by Vietnam veterans Peter Burquest and Murray Lewis to support the growing number of veterans in Melbourne's western suburbs. The Caroline Springs RSL sub-branch began with just $65 in the bank. It officially opened in February 2014 and it's now grown into a thriving non-profit community hub with over 300 members. These 300 members are service personnel, veterans who have served themselves, families and their families who have supported them and stood by them. This group is focused on welfare, companionship and supporting veterans from World War II to Afghanistan. This sub-branch is known for not having poker machines in their venues because they understand the potential for gambling harm. They're known for fostering veteran and family welfare and have strong community ties with local schools, scout groups, football clubs and other local community organisations. They're out and about in schools talking about their experiences as ex-service personnel and about the impact of war. I'm proud to say that the SBS aired a documentary highlighting the history of the Caroline Springs RSL sub-branch, interviewing a number of members. The documentary shared the sometimes untold scares and sacrifices in the service of the Defence Force. It looks honestly at the impact of service on these veterans. If I may, Deputy Speaker, I'd like to share a brief story of Brian Ross. Brian served in East Timor in 2002 and struggled with the transition to civilian life after his return. He found himself snapping at his wife and children. The turning moment for Brian was when his son came home and told him that he'd never been the same since he came back from East Timor. It was then he knew that he needed help and turned to Open Arms for counselling. Open Arms, Veterans and Family Counselling, was founded by Australia's Vietnam veterans. It is Australia's leading provider of mental health assessment and counselling for Australian veterans and their families. Brian is now actively involved in the RSL and is in a much better headspace with his family. Early intervention and supporting mental health are so incredibly important for our veterans and their families. Our veterans and their legacy are ingrained in my community. We have a walk of honour in Aintree, a 600-metre walk in the Woodley Estate, which features 150 individual plaques honouring veterans, each with their own story, their own experience and their own legacy. The Ode of Remembrance is played at 6 p.m. every Friday at the West Waters Entertainment Complex in Caroline Springs. This social gathering provides a constant in the lives of veterans and their families, and that of our wider community as well. The health and wellbeing of our veteran community is a priority for the Albanese Labor government. There's no doubt that we're committed to providing more effective and efficient support to veterans and their families. On Monday, the Minister for Veterans Affairs announced that the Albanese Labor government is investing $739.2 million to improve the provision of the treatment and rehabilitation for veterans, to reduce the impact of injury on them and improve their lifetime wellbeing. Modern clinical evidence shows that early access to the right care helps in a number of ways. It helps to improve daily functioning, prevent conditions from worsening, reduce long-term impairment, supporting mental health and strengthening long-term wellbeing and quality of life. This reform is one of our government's responses to the Royal Commission into Defence and Veteran Suicide. It's a response which recognises that fostering the wellbeing of veterans is one important protective factor against suicide. Mental health is so important, and for so many, government mental health measures is a lifeline, and that includes our veterans. These veterans have served in our communities, defended our country. They deserve for their wellbeing to be accounted for, and for their families too. Speaker, in my local community in Melbourne's western suburbs, we have a beautiful war memorial just opposite Lake Caroline. Like many in our community, I often go there for moments of peaceful reflection. I think about those who have given their lives to serve our country. I think about those who return home, but who live with the mental anguish of war. I think about those families who have grieved for their loved ones. And I think about my own family and the legacy of Hugo Throssell VC. This bill is for all of you. I commend this bill to the House.
The question is that the bill be now read a second time, and I give the call to the member for Durack.
Thank you, Madam Deputy Speaker. I rise to speak on the Defence and Veterans Service Commissioner Bill 2025. As the Shadow Minister for Defence Personnel and Industry, I'd like to first acknowledge our veterans and those currently serving in our Defence Forces. When the Coalition was last in government, we established the Royal Commission into Defence and Veteran Suicide. It was imperative for us as a government to deliver families and veterans the truth, accountability and systemic reform that they needed and they deserved. That Royal Commission confirmed what the ex-service community and families had been saying for many years, that systemic failure requires systemic oversight and structural reforms. It made clear that lasting reform requires independent, system-wide oversight across defence and veteran departments, not embedded within one department. Amongst the recommendations was one of the most significant: the implementation of an independent and permanent statutory oversight body to drive reform. The Coalition supports the objective of this bill to give effect to that recommendation. We have always advocated for independent oversight with real powers, public reporting and parliamentary accountability, because only then is reform able to be genuine, measurable and sustained. As an opposition, we will continue to hold the Albanese government to account for their attempt to create the Commission through a late amendment to unrelated legislation. This attempt was frankly insulting to our veteran community. That bill was rushed, poorly handled, lacked proper consultation and showed a lack of respect for our veteran community by the Labor government. Quite simply, our veterans deserve a body with teeth, established through standalone legislation, a model the Coalition has argued for from the beginning. It should never have been the case that it was created through a last-minute insertion. This simply undermines confidence and scrutiny. I call on the government to acknowledge their mistakes and their lack of judgment with the original Commission proposal. The government asked the Parliament to wade through a complex oversight body with limited stakeholder engagement and visibility. That is not how serious veteran policy and legislation should be handled and ultimately made. The Coalition moved an amendment to ensure that a dedicated Senate inquiry could provide scrutiny on the Commission model. From that, many of the key improvements, including the independence of this standalone bill that we are debating at this point in time, only exist because we forced that scrutiny and fulfilled our duty to scrutinise the legislation presented to us. It was not in the government's original design. Now, it is important for us to acknowledge and to remind the Albanese government that what we are debating today was not an original idea, and no amount of their political spin or press releases will make it theirs. The Coalition tried to establish an independent National Commissioner for Defence and Veteran Suicide Prevention back in 2020. The bill proposed an independent statutory oversight body with essentially the same structural features being introduced now. Well, you have to ask yourself, what did the then Labor opposition do at that time? Well, they opposed it, purely for political purposes. The Albanese-led opposition prevented its establishment. Unbelievable, but now we have the very same people are proposing a model that exactly mirrors what the Labor Party voted against. If Labor had supported the Coalition's National Commissioner back in 2020, rather than opposing it, independent oversight would already be mature and operational. Instead, there has been an unnecessary 5-year delay because Labor prioritised politics over veterans' welfare and wellbeing, but are now finally delivering a commission. Some would say better late than never, but it's 6 years too late. The DVSC will lead an independent inquiry into military sexual violence within the ADF. The Coalition welcomes the government's decision to launch an inquiry into sexual violence in the Australian Defence Force, but notes that it has taken more than a year, yes, a year, since this action was recommended in the Royal Commission into Defence and Veteran Suicide final report. This is an important and overdue measure. The Royal Commission found that sexual violence remains a systemic issue within the ADF and is directly linked to suicide and suicidality, as the Commission stated, and I quote, "This has been the case for decades, and it will continue unless the ADF commits to deep systemic reform." End of quote. No member of the ADF should ever be subjected to sexual violence, harassment or abuse. The Australians who serve in uniform, our men and women, are there to protect us, and it is equally essential that they are protected by the institutions of the ADF. Military sexual violence disproportionately affects women and can profoundly shape their experience of service. The fact that ex-serving women are twice as likely to die by suicide as women in the broader community who have not served cannot be ignored. The Minister for Veteran Affairs and Defence Personnel has requested the Defence and Veterans Service Commission to lead this independent inquiry. The inquiry will implement Recommendation 25 of the Royal Commission and aligns with the DVSC's remit to examine systemic reform to improve suicide prevention and wellbeing outcomes for serving and ex-serving ADF members. However, it should be acknowledged that the government's handling of the announcement itself had been confused and poorly executed, which is troubling, incredibly troubling, given the sensitivity of the subject matter. On the 2nd of December, the Minister at the National Press Club announced that there would be an inquiry. Later that same day, the Minister for Veteran Affairs told the ABC that, in fact, no final decision had been made about how it would be conducted or indeed who would lead the inquiry. The Minister stated that these decisions would be made after consultation on the terms of reference had been concluded. You have to ask yourself, well, why did he say that everything was sorted when it wasn't? Now, despite this, just over 2 weeks later, on the 19th of December, the government announced that the DVSC would lead the inquiry, even though the consultation process remained ongoing. For an issue as serious and personal as military sexual violence, let me tell you, attention to detail matters. Survivors, serving members and their families deserve clarity, consistency and confidence, particularly confidence, that the Minister is across his brief. Announcing an inquiry, publicly conceding uncertainty about its structure and then preempting the outcome of consultation risks undermining confidence at the very moment that trust is most needed. It is essential that this inquiry is appropriately resourced, that it allows serving members to remain anonymous and enables people to come forward without fear or hesitation. This inquiry is expected to commence by mid-2026, with the DVSC to publish a report of its findings. The Coalition continues to stand ready to support the government in implementing the recommendations of the Royal Commission and will assess the outcomes of this inquiry once they are released. I would just like to note, in light of this subject matter, this very sensitive subject matter, I think it is important that we do remind anyone who might be listening to this broadcast and affected by this issue about the help that is out there. So help is available through Lifeline on 13 11 14 or through Open Arms on 1800 011 046. The Coalition will be moving an amendment to bring the timing of the first implementation review by the Commissioner. Veterans and families were promised urgent reform, not delayed reporting. Independent oversight only works if it is timely and if it is visible. The amendment would require the first implementation assessment to be completed by no later than the 30th of September 2026. Earlier reporting ensures veterans, families and the Parliament can see measurable progress, not just promises. If the government is confident in its reform program, it should welcome early independent assessment and should support the amendment. Our amendment strengthens transparency and reinforces accountability. It does not change the Commissioner's independence or indeed powers. The Coalition's objective is simple. Reforms recommended by the Royal Commission must be implemented quickly and assessed openly. The Opposition's commitment to veterans will remain unwavering. When in government, our Minister for Veterans Affairs was given cabinet status. Disappointingly, in the current Labor government, the responsible minister does not. That is a clear indication of how Labor views veterans and their families. The Coalition's track record on veterans affairs speaks for itself. We will continue to support and advocate for veterans and their families because that is what those who serve their country deserve the most. The Coalition will support this bill with our amendment. I thank the House.
The question is that the bill be now read a second time, and I give the call to the member for Petrie.
Deputy Speaker, the Royal Commission into Defence and Veteran Suicides was one of the most confronting and sobering inquiries this country has ever undertaken. It heard testimonies that no family should ever have to give or experience. Parents speaking about the children they lost, partners describing the lives forever changed, and mates remembering those who never made it home, not from war but from the aftermath of service. Again and again, the Royal Commission was told the same story of people who served their country with pride, who asked for help when they needed it, and who became lost in a system that was fragmented. A system that was complex and too often unresponsive. A system that failed to see the human cost of delay, confusion and silence. The Royal Commission made clear that these deaths were not inevitable. They were not isolated tragedies. They were the result of systematic failures that compounded trauma, injury and distress over time.
That is why the Royal Commission identified its recommendation to establish a new independent statutory entity to oversee reform across the entire defence ecosystem as a key recommendation. Not because it was easy, but because it was essential. This was a call to action and a call for enduring oversight, real accountability and sustained reform, long after the headlines fade and the hearings end. The families who came forward did so not just in grief, but in hope that their loss would lead to change. Hope that the future generation of serving and ex-serving members would be better supported than their loved ones were. This legislation is part of how we're going to honour that courage. It is how we ensure that the findings of the Royal Commission do not sit on a shelf, but instead drive lasting cultural and structural change. It is about saying clearly and unequivocally that the lives of our defence personnel and veterans matter, not only in service, but long after it ends. I'm honoured to speak in support of these bills. Together, they represent an important step in strengthening the independence, authority, and effectiveness of the Defence and Veterans Service Commission and the Defence and Veterans Service Commissioner. They reflect the government's commitment to ensuring that the system reform across the defence and veterans system is enduring, transparent and accountable, and that it has sustained focus on suicide prevention and wellbeing outcomes. This bill replaces the current enabling legislation for the Defence and Veterans Service Commission. In doing so, it transitions the Commission and the Commissioner out of the Defence Act and into a standalone legislation. This approach is deliberate. It reflects the seriousness of the role of the Commission, the role the Commission is intended to play, and reinforces its independence from the agencies it oversees. This bill also reflects the government's response to the recommendations from the Senate Foreign Affairs, Defence and Trade Legislation Committee, following its report on 29 August 25 into the existing enabling legislation. That committee recommended, among other things, that the functions of the Commissioner explicitly include reference to veterans' families. Wellbeing does not exist in isolation. Supporting veterans means supporting the people who stand behind them. This recognition strengthens the Commission's work and ensures reform is informed by the lived experiences of the entire defence and veteran community. The government has listened carefully to the committee's findings, to the evidence put forward by stakeholders, and to the concerns raised during the inquiry process. A key feature of this bill is strengthening the independence of the Commission. To support that independence, it provides for the appointment of the Defence and Veterans Service Commissioner by the Governor-General. This is a significant safeguard. It ensures that the Commissioner is appointed through a formal, merit-based and public recruitment process, and that the role is clearly established as independent of Defence and other agencies. Prompt passage of this bill will facilitate the appointment of the inaugural Commissioner in accordance with the provisions relating to appointment and terms, ensuring that the Commission is fully operational and able to carry out its critical functions. These reforms must also be understood in the context of the Royal Commission into Defence and Veterans Suicide. The Royal Commission deemed recommendation 122 of its final report to be the most important recommendation. The recommendation called for the establishment of a new statutory entity to oversee systems reform across the whole defence ecosystem. The Royal Commission was unequivocal in its findings. It identified that fragmented responsibility, insufficient oversight and a lack of sustained accountability. This had contributed to systematic failures, with devastating consequences for serving and ex-serving Australian Defence Force members and their families. In acknowledgement of the significance and urgency of the recommendation, the Albanese Labor Government legislated the Defence and Veterans Service Commission in February 2025. The Commission has been up and running since the end of September last year. This bill builds on the foundation by ensuring that the Commission is placed on the strongest possible legislative footing. The role of this new statutory entity is clear. It is to provide independent oversight and evidence-based advice to drive system reform, with the objective of improving suicide prevention and wellbeing outcomes for the defence and veteran community.
Order. The debate is interrupted in accordance with Standing Order 43. The debate may resume at a later hour. The member will have leave to continue speaking when the debate is resumed. Are there any statements by honourable members? And I give the call to the member for Bradfield.
Thank you, Deputy Speaker. I take this opportunity to congratulate two very special constituents in my electorate of Bradfield, Turramurra residents Carolyn and David Steadman, on an extraordinary milestone. Carolyn and Dave are foster parents. 2026 marks 50 years since they first welcomed a child into their home, and now they're fostering their 75th child. They have dedicated their lives to helping children of all ages by offering them a safe and loving place to call home. The couple currently fosters the children through Wesley Mission's foster care program. Jim O'Rourke, who reported on the milestone in the Manly Daily, quoted Mr Steadman as saying, "We are both Christian people, we have a good home, good health and a good family, and we're just giving back to these people who have nothing." Now, according to Carers of Kids New South Wales, in New South Wales alone, there are around 14,720 children and young people living in foster care or kinship care, of which 45% are Aboriginal or Torres Strait Islanders. And in November last year, the New South Wales Government launched a statewide campaign urging people across New South Wales to change a child's life by becoming a foster carer. If there's anyone out there who has ever had an inkling that they might like to become carers of kids in need, I offer this incredible inspiration, the example of Carolyn and Dave Steadman.
I give the call to the member for Newcastle.
Thank you, Deputy Speaker, and I rise to pay tribute to a much-loved local identity, Paul Scott, who passed away last month, and extend my deepest condolences to his beloved daughters, Emma Jane and Grace, his partner, Victoria, his friends, colleagues and countless members of our community who mourn his loss. Paul was a true Novocastrian in every sense, a passionate advocate for our region's heritage, a trusted voice in our local media, and a guiding mentor for students and young people who benefited from his insights and generosity of spirit. His work to protect and celebrate community institutions from Surffest through to our historic Newcastle Post Office helped shape the cultural fabric of Newcastle and gave voice to the pride that all Novocastrians feel about our city. In the face of health challenges later in life, Paul made the deeply personal decision to access voluntary assisted dying, a choice he spoke about with courage and clarity, guided by his values of dignity and self-determination. His passing reminds us of the importance of compassion, not just in how we live, but in how we support people at the end of life. We remember Paul as a storyteller, a champion of community, and a thoughtful, generous human whose legacy will endure in the people he inspired and the places he helped protect. Vale Paul Scott.
Give the call to the member for Barker.
Madam Deputy Speaker, the Prime Minister doesn't decide South Australia's gun laws. Premier Peter Malinauskas does. And unless he rules out changes, law-abiding firearms owners in my electorate of Barker remain squarely in the firing line. Responsible, law-abiding, licensed firearm owners should never be punished for the actions of criminals or extremists. While other state premiers have already ruled out changes, Premier Malinauskas, in the shadows of an election campaign, continues to leave the door open to enforcing a gun buyback on South Australians. In Barker, firearms aren't a political talking point. They're essential for farm safety, for animal and pest control, for hunting, for sporting shooting, from the Murray Mallee to the Barossa, from the Riverland to the Limestone Coast. More red tape won't stop criminals, it won't stop extremists, but it will impact law-abiding people who are doing the right thing day in, day out. This is a decision the Premier can make, and he's got to make it now. That's why I'm calling on Premier Malinauskas to rule out any changes to South Australia's gun laws, and why I'm asking people right across Barker to sign my petition to get him to do the right
Member for
thing.
Corangamite has a call.
Deputy Speaker, I rise to recognise an outstanding achievement by a remarkable local sportswoman, Jakara Anthony, who has once again shown why she is Australia's most successful winter athlete and our nation's flag bearer at the Winter Olympics. Last night, Jakara delivered a dominant qualifying performance at the Winter Olympics in Italy. She showed the composure, precision and grit that have become her trademark on the world stage. The result reflects years of disciplined, relentless training and the ability to perform under immense pressure when it matters most. Jakara, a proud Barwon Heads local in my electorate of Corangamite, carries the pride of our coastal community whenever she competes. She has already etched her name into sporting history, and now she stands on the brink of adding another extraordinary chapter with the prospect of a second Olympic gold medal. What makes Jakara's success even more inspiring is the pathway behind it, the early mornings, the winter training at Mount Buller, the support of family, coaches and community, and the resilience to come back from injury setbacks. For young people across my region, watching her compete, Jakara represents what is possible. She proves that growing up in regional Australia is no barrier to reaching the pinnacle of world sport. As she prepares for tonight's final, our entire community stands behind her. Jakara, Corangamite and the whole of Australia are cheering you on. Thank you.
Member for Curtin.
In the past, reforms to how we tax property have been constrained by fears of political backlash, particularly following the 2019 federal election. But the political landscape has changed, and the appetite for reform in my electorate of Curtin demonstrates this. Curtin has high rates of investment property ownership, benefiting from the capital gains tax discount and negative gearing. Yet in late 24, when my office surveyed 370 constituents, 3/4 supported reform to both the capital gains tax and negative gearing systems. And in November 25, I undertook a community consultation with 240 participants, and 2/3 of those owned at least one investment property. The results were striking. More than 80% supported reform to capital gains tax discount, and more than 90% supported reform to negative gearing. Of course, in both instances, those who chose to participate may have been more open to reform, but the overwhelming support shows that community views have evolved as the housing crisis has worsened. This is driven by a fundamental belief that came through strongly in the consultations. Housing should be treated as a necessity, not as an investment for building wealth. People want the next generation to be able to afford to buy a house to live in. The government must consider options for reform and must make these decisions based on the impact on housing affordability, intergenerational equity, budget sustainability and productivity, not politics.
Member for Macon.
Thank you, Deputy Speaker. Every day, thousands of Australians quietly go about their day doing invaluable community work. And today I acknowledge those people who were this year recognised with Tea Tree Gully and Salisbury Council Australia Day Awards. In Salisbury, the Citizen of the Year was Cheryl Smith, who with her daughter Chloe rescues animals and supports homeless people. Young Citizen went to Alina Arlai for her work in promoting social cohesion. Senior Citizen was awarded to Paul Dittmar, a lifelong stalwart at the Paraka Football Club, and who with his wife Bronwyn has created a very popular community hub through their bakery shop, the Fabulous Baker Boys. Song Now received the Active Citizenship Award for his work within the Cambodian community, and Jim Binder received the Community Achievement Award as the long-standing leader of the Salisbury Bicycle Users Group. Community Event of the Year went to the Salisbury Business Association's Family Fun Day and Emergency Services Appreciation Day, which recognised the service of the Salisbury CFS, the Salisbury SES and the Playford St John Cadet Division. At Tea Tree Gully, Noelle Wallace was the Outstanding Citizen of the Year for the terrific work she and her team do at the Pathway Community Centre. And the Jubilee Way Park Run was the Outstanding Community Group for their Saturday morning community fun runs. Congratulations to all of those recipients, and thank you for all you do for our community.
Member for Fairfax.
Thank you very much, Deputy Speaker. Often in this place I talk about the importance of a strong economy, and that's not because it's the end game, it's the means. It's a means by which we build the hospitals and the schools. It's a means by which we build the roads and the rail, and we ensure that everyday Australians can have a good standard of living. They can have a roof over their head, they can put food on the table, and they can otherwise enjoy a fulfilled, happy and healthy life. But today the economy is not strong, it is weak. And that is why we see symptoms right across the country of people who are doing it tough. And there is no more alarming consequence than that of homelessness. In my own electorate on the Sunshine Coast, the town of Nambour is experiencing an enormous amount of homelessness at the moment. And everyone's trying to do their bit. Everyone from Mayor Natoli through to State MP Marty Hunt to the local chamber, charities and churches. But there's still more we can all do. And as a community, I believe we can do more. An initiative I want to give rise to the House today is the Sunny Coast Sleeper. This is a bus which has 7 sleeping pods. It costs $15 for someone who would otherwise sleep on the street to have a good, safe, sound, secure night's sleep in the sleeper. Now, I'm going to get behind this initiative and try to raise funds for it. And if anybody does have $15 and you want to make a contribution, please do. Let's all do our bit.
Member for Solomon.
Thanks, Deputy Speaker. Well, today, the 11th of February, is a great day because I am able to confirm to the people of Solomon, my electorate, Darwin and Palmerston, that due to the actions of this Albanese Labor government, there are now 23 bulk billing Medicare practices across Darwin and Palmerston. 15 of them are newly bulk billing and 8 that have shifted from mixed billing to fully bulk billing. Now, Deputy Speaker, I have worked to continually improve health in my electorate in the far north, but before politics, beyond Darwin, with the remote area health corps that I established. But before that, I worked to improve the health, particularly of babies and mothers in Timor-Leste. I'll never forget today, the 11th of February, back in 2008 in Timor-Leste. I was working as a civilian advisor to the President of Timor-Leste, Jose Ramos Horta. I received a phone call that the President had been shot while returning from his morning walk. Luckily, and thanks to his resilience and expert medical care in Dili from the ADF personnel from Aspen Medical, and then at the Royal Darwin Hospital, Jose Ramos Horta lived. So you can imagine my delight, Deputy Speaker, to return to Dili recently with the Prime Minister and to meet with Jose Ramos Horta again as the President, and also to spend time with Shanana Guzman.
And I give the call to the member for Hinkler.
Thank you, Deputy Speaker. The cost of living is out of control, and in my electorate of Hinkler, one of the lowest socio-economic regions in the country, pressure points like interest rate rises hit Hinkler hard. Only yesterday I heard from the Salvos in Bundaberg, where Captain Chris Millard described a 20% rise in demand at Christmas time. More people needing food and essentials than ever before. The growing list of essential needs are simply too expensive under this government. After nearly 4 years of Labor, Australians are paying more for everything. Insurance up 39%, energy up 38%, rent up 22%, health up 18%, education up 17% and food up 16%. The Salvos in Hinkler, like many service providers, need more support to deliver and answer the constant and rapidly rising calls for food, shelter and general expenses. This is about the weekly shop, the monthly power bill, the rent and the mortgage. Inflation rose to 3.8% in December, accelerating over Christmas and at the worst possible time for families. I said in my first speech, all Aussies deserve a nice home, cheaper living standards and a fantastic family lifestyle. But please do not make decisions in this place affecting other electorates you wouldn't want to implement in your own. This is Labor's cost of living crisis. Labor spend, prices rise, Australians pay.
Member for Maribyrnong.
Deputy Speaker, because on this side of the House we are a united team focused on delivering for working Australians, today we introduce changes that will make our super system fairer from top to bottom. This is for the early childhood educators shaping the minds of our next generation, the school cleaners keeping our kids' classrooms safe, and the aged care workers looking after our parents and grandparents. Workers who have given so much yet have been given not a fair go on their retirement savings. Today we're changing that. We're increasing the listo rate and increasing it over time so we secure it as a meaningful lift in the super that gives these essential workers a better retirement. And I'm proud today to speak, Deputy Speaker, for what this means for people and women in my community of Maribyrnong. In Maribyrnong alone, 7,500 people will benefit directly. It will add an additional $3.1 million in super flowing to the accounts of local workers, and 2/3 of those accounts are held by women. This is what a government focused on the job looks like. While those opposite are hopelessly divided and distracted by their own internal politics, we are getting on with the job of delivering for Australians who need it most. This measure rewards work, it closes the gender super gap, and it ensures that the people who care for our children, our elderly and our communities are not left behind in retirement.
Member for Nichols.
Thank you, Deputy Speaker. Yesterday, the Minister for Regional Development, Territories and Local Government tried to school us in question time, but maybe it's the Minister who needs to go back to school. The fact is, Labor is completely neglecting regional communities, and no amount of trickery and slight increases in one program while scrapping a swathe of others can pull the wool over the eyes of country people. She talked about Roads to Recovery. Well, Roads to Recovery was a program put in place by the Coalition in 2000, and over its time in government, the Coalition increased the funding by $43,000 to $500 million. Most significantly, the Coalition provided $3 billion in new funding for councils via the local roads and community infrastructure programs. And listen up, everyone. In 2023, Labor scrapped that program and the $3 billion. Labor's Growing Regions program has no money. It's a PINO, a program in name only. Stronger Communities has no money. I have a question for the Minister, who's trying to school me, and I'd appreciate an honest answer. How can regional councils apply for critical infrastructure funding at the moment? And one example is Kerwin's Bridge in Nagambie, which has been knocked back several times by the Albanese government. The fact is, the cupboard is bare and it's just not fair.
Member for Aston.
Thank you, Deputy Speaker. Labor is the party of Medicare. We created it, we protected it, and under the Albanese Labor government, we are strengthening it for the future. At the last election, the Albanese Labor government made a clear promise to the Australian people that we would rebuild bulk billing and make it easier for families to see a bulk billing doctor. And Deputy Speaker, that is exactly what we are delivering. Thanks to our historic investment in Medicare, Australians can now access more than 3,400 bulk billing practices across the country, and that number continues to grow every week. Almost 1,300 of these practices were previously mixed billing. That means more families are now walking into a GP clinic knowing that they will only need their Medicare card and not their credit card. In just 3 months, the national bulk billing rate has surged to 81.4%, the largest quarterly increase in 20 years outside of the pandemic. In my electorate of Aston, almost half of the GP clinics are now bulk billing only practices, with there now being 22 bulk billing practices in total. That's 15 additional GP practices now bulk billing patients due to Labor's reforms. That is real cost of living relief for local families in my community in Melbourne's Outer East. Because of our delivery, 96% of Australians now live within a 20-minute drive of a registered bulk billing practice. We promised a stronger Medicare. We promised more bulk billing, and that's exactly what we're delivering.
Member Bowman has the call.
Deputy Speaker, Labor's Spendathon is costing the people of my electorate dearly. Commonwealth spending has blown out from around 24% to 27% of GDP, and that's the highest level outside of a recession in nearly 4 decades. Debt is now projected to climb to $1.2 trillion by the next election, and local families in my electorate are paying the price. They are paying through higher inflation, driven by out-of-control government spending. They are paying again through higher interest rates, with more pressure likely to be piled on in 2026. Every mortgage holder in my electorate feels it, and every small business feels it. But the opportunity cost of Labor's reckless spending is just as staggering. The federal Labor government is now paying around $50,000 every single minute just to service interest on the national debt. Imagine what that money could achieve in my electorate across the Redlands. In just half a day, we could green seal every remaining unsealed road on the southern Moreton Bay Islands. In a single day, we could fund stages 2 and 3 of the duplication of Wellington Street in Cleveland, a project that stage 1 was funded under the former coalition government. And in just a couple of weeks, we could deliver a major expansion, a much-needed expansion of Redland Hospital. This is the cost of waste, and this is the cost that my community is paying for this Labor government.
Member for Moreton.
Thank you, Deputy Speaker. Deputy Speaker, people have been diligently counting. The numbers are in. It's the hottest topic in the gallery. But I'm not talking about the opposition, no. I am talking about the national bulk billing stats. And let's have a look at them, because there's some good numbers here. 3,400 Medicare bulk billing practices across the breadth and depth of this nation. A whopping 81% increase in just those short 3 months to bulk billing practices. And Deputy Speaker, in my own electorate on Brisbane South Side in Moreton, much like the member for Aston and much like the member for Solomon, has had a good increase here too. Because 11 formerly mixed billing practices are now fully bulk billing. And that's a total of 23 fully bulk billing practices in my local community. 23 places where you don't have to check your bank balance before you go to the doctor. It's 23 places where all you need is that little green card. And it's 23 places where you getting better is the only currency that counts. Deputy Speaker, I had the great privilege of being able to visit one of those, Bow Desert Road Surgery in Maruka, with the fabulous Dr. Gary Chang. And on top of the urgent care clinics in Canossa and at the PA, my community is reaping the benefits of the Albanese's laser-like focus on healthcare for Australians.
Member for Calare.
I'm calling for an independent inquiry into Orange City Council's management of the Orange Regional Sporting Precinct project. This $75 million development is made up of state and federal funding that should deliver a world-class regional sporting facility. Unfortunately, some serious questions need to be answered about what's gone on with this project. One whistleblower, who is also an expert, has provided me with council documents that include scientific lab tests which showed that sand for the playing fields was supplied to the site, which contained too much clay and silt in breach of the contract. Despite failing lab tests multiple times, the sand was apparently spread anyway. The lab test results sourced from council also show that sand failed drainage tests. Questions have also been raised about whether turf laid on the playing fields was washed first in order to remove silt as required by the contract. Another whistleblower has come forward and stated that before sand was delivered to the site, unwashed sand was mixed in with washed sand. Washing the sand removes silty particles. When I first raised this with council, their first response was, in effect, there's nothing to see here. Now they've finally admitted that there are problems with the construction of several of the fields, but bizarrely state that there are no issues with the sand. This isn't good enough. We need full transparency and accountability from Orange City Council. The public needs to know what's gone on here, who's responsible and how much it's all going to cost to fix. We need an independent inquiry to investigate Orange City Council's management of this project.
Member for Hunter.
Thank you, Speaker. Doctor, give me the news. Speaker, in the Hunter for too long, the news was not great. For too often, the next line felt like, and here's the bill. Speaker, every family in the Hunter wants to know they can see a doctor with their Medicare card, not their credit card. Before this government strengthened Medicare, bulk billing in the Hunter was in real trouble. Just 10 out of 50 GP surgeries were bulk billing. That's only 20%, Speaker. For too many people, seeing a doctor meant pulling out a credit card instead of a Medicare card. But, Speaker, today that picture has changed. 25 out of 50 GP surgeries in the Hunter now bulk bill. That's 50% of practices and growing. This is real progress for local families right across the Hunter electorate. It happened because this government, the Albanese Labor government, made the largest investment in Medicare in our nation's history. We backed doctors to bulk bill and made sure the system worked for patients as well. After years of neglect, bulk billing was in free fall. We are turning that around, Speaker, and communities like mine are feeling the difference right now on the ground. This is good for pensioners, families, apprentices and working people. This is good for local clinics and our health system. Labor built Medicare and the Albanese Labor government will continue to strengthen it to make sure we're looking after the everyday mums and dads and Aussies in this country. Thank you.
Member for Durack.
Last week's announcement of Labor's fire sale of more than 60 defence sites was an absolute disgrace. The sale of these sites is nothing more than a way for the Deputy Prime Minister to raise funds to pay for the defence of our nation. The Coalition maintains that defence spending should be at least 3% of GDP. Labor clearly does not understand nor care about our nation's defence needs.
Yeah.
It beggars belief that during Australia's most dangerous strategic environment since World War II, that the Albanese government has failed to equip our men and women in uniform with the resources that they need to defend our nation. The number of training facilities that have been earmarked for disposal leads to the obvious question: where are you going to train our defence personnel? To quote retired Brigadier Ian Langford, how do you recruit and retrain a workforce that is unable to serve in populated areas? To make matters worse, this morning in Senate estimates, we've learned of the disrespect Labor have for our servicemen and women. It is incredibly disrespectful that the media found out about this fire sale of defence assets before our defence personnel. Well, maybe Labor thought it was going to be a good news story. Well, let me tell you, the defence community certainly does not think so. So, to the Deputy Prime Minister and the Prime Minister, if you are looking to get more defence funds for the defence of our nation, rather than selling off our heritage and our history, just fund defence properly.
Member for Bennelong.
Deputy Speaker, what happens in this place matters. What programs we fund, what laws we pass, and what decisions we make all have the potential to change lives for the better. And when it comes to Medicare, I'm so proud that this Labor government has worked hard to make Medicare better each and every day since we were elected in 2022. Deputy Speaker, in October last year, Health Direct listed 9 bulk billing general practices in Bennelong. Today's data shows that there are 18 fully bulk billed practices in Bennelong. Now, we all know the member for Hume has been doing the numbers lately, and he told me that 18 is double what it was in Bennelong only 3 months ago. Deputy Speaker, 1 in 3 practices in Bennelong now fully bulk bill, meaning free care for those who need to see a GP. Australians rely on Medicare every single day, and most of us expect health care to be accessible when we need it. But there's some in this place who don't think the same. Never forget what the Liberals and Nationals do to Medicare when they take government. Last time they cut $50 million from hospital funding and they froze the Medicare rebate for 6 long years. Labor understands that Medicare is in Australia's DNA, so be it Medicare urgent care clinics, the Medicare mental health centres or more bulk billing practices, will always strengthen it.
Member for Goldstein.
Thank you, Deputy Speaker. And Deputy Speaker, well, it has all now been revealed. Earlier, when the Watson did an inquiry, Geoffrey Watson SC did an inquiry into the Queensland CFMEU, what he found was CFMEU officials standing over public servants and directing them like they were the government. At the end of last year, Mr Watson outlined that he was going to table his latest report about CFMEU corruption in Victoria. We FOI'd it. We wrote to the minister, no response. Now we know why. She's refusing to answer our questions and release documentation because a secret report has now been revealed for the nation to see, titled "Rotting from the Top." That is the lived reality of the CFMEU Labor cartel and the kickbacks that are being paid. And what does this report show? $15 billion of money has been laundered, public money, from the Albanese government projects and Allen government projects, and the Allen government knew exactly what was happening. They turned a blind eye to the theft of public money to go to organised crime and to bikie gangs, because the Albanese government's response is to keep corrupt power structures in place in the CFMEU and take out the media cycle. But because we know 2 chapters were removed, Speaker, I seek leave to table this report so it can never be whitewashed from history again.
Is leave granted? I give the call
running
to
interference
the
for CFMEU corruption.
Sit down, please, Member for Goldstein.
Thank you, Deputy Speaker. Here's a report. Because of
order, I cannot hear. I'm sorry. Member for Brisbane has. Leader of the House.
An inference was made in the last comment from the member and should be withdrawn.
100%. I think you should reflect on what you said and withdraw any imputations made on the reputations of other members. Would you assist the House and withdraw? I believe that would be
To assist the
helpful.
House, I withdraw.
Thank you. Member for Brisbane.
Thank you, Deputy Speaker. Here's a report, Deputy Speaker. Because of the Albanese Labor government, more people in the seat of Brisbane can see a GP for free. This is just one step we're taking to rebuild Medicare, our world-class health system. Deputy Speaker, in November last year, this government made the single largest investment in Medicare in its history. We extended the bulk billing incentive to cover every patient, not just pensioners, concession card holders and families with children. And we tripled the incentive for doctors to do this. Why, Speaker? Because this Labor government believes all Australians should be able to see a GP for free. So my message to the young people of Brisbane is, if you've put off going to a GP because of the costs, like many of you have admitted to, then you can now go with only your Medicare card. My second message is, if you're at the GP and you're not getting bulk billed, you might want to ask them why. Deputy Speaker, though, bulk billing is only part of the story.
Order.
This government is delivering across our healthcare system. This week marks the one-year anniversary of our historic women's health package, putting women's health and equity at the heart of this government's agenda. For too long, women's health has been overlooked, underfunded and misunderstood. Labor has changed that. Labor is delivering on its commitment to more affordable and accessible health care because we built Medicare and will protect it.
In accordance with Standing Order 43, the time for member statements has concluded. I'll just invite members to take their seats quickly and quietly as possible. Before we begin question time, I wish to make a statement to the House. This week has been a particularly combative week in the chamber, and this behaviour does not reflect well on the House. I shouldn't have to say this, seeing as I already made a statement, but further incidents have occurred. It leaves me with no other choice. The standing orders have been changed. I want all members to understand that I won't hesitate in using the naming powers I have. Of course, in parliamentary debates, members will have differing opinions, even in question time. That is to be expected. But the House has to find ways of engaging in debate that maintains respectful behaviours. We have a shared responsibility to display exemplary leadership. Regardless of the challenges inside this chamber or challenges outside the chamber, we must exercise that shared responsibility to ensure people are always treated with the highest standards of respect. We all know that everyone is looking to the Parliament and looking to us. They have expectations of how we speak and how we behave towards each other. In recent reforms for behaviour codes and standards at Parliament are truly to be meaningful, then we must act with intent to set the standard for an inclusive, respectful and professional workplace in Parliament, House and across Australia. I'm asking all members to rise to this challenge. And on indulgence, give the call to the member for Wentworth.
Cool. I'm regularly told from members of the public that the behaviour in this chamber is out of step with what modern Australia expects. People often tell me that if they behaved like we do in their workplaces, in their schools, in their community centres, they would be thrown out or suspended. I know we are all genuinely concerned about social cohesion. As a country, we disagree passionately about many issues, and as politicians, we keep on asking everyone to have a robust debate, but with respect. People are sick of politicians saying, "Do as I say, but not as I do." If as a parliament we want to, if as a parliament we expect this from our country, then we must start by leading by example and start by doing it here. Thank you.
We shall move to order. The member for O'Connor, I cannot believe you just said that. We shall move to questions without notice. Are there any questions? I give the call to the Honourable the Leader of the Opposition.
Thank you, Mr Speaker. My question is to the Prime Minister. Today, Australians learned that sections of a report into CFMEU corruption were removed by the Prime Minister's hand-picked administrator. These sections included government inaction on the CFMEU and the cost of inaction to the taxpayer. The probe's chief investigator said, "I did not suggest the changes. I was directed to make the changes." Prime Minister, did any individual in the Albanese government have any involvement in the removal of these two sections?
Put to the Minister for Workplace Relations.
Well, thank you, Speaker, and I thank the Leader of the Opposition for her question. The CFMEU Administrator commissioned Jeffrey Watson to provide a report into the Victorian branch of the CFMEU to help him with his important work. Let me be very clear. This is a report to the Administrator, not a report to Government. The handling, distribution and publication of reports commissioned by the Independent Administrator is a matter for him. To be abundantly clear, my office received this report on the 9th of February, and at no stage have we requested any changes to the report or made any requests for amendments to the contents of the report. Any suggestion is misleading the Parliament. Now, let me be very, very clear. Mr Irving has been clear and transparent about why parts of the report had been removed. And it is because he was not satisfied that they were well-founded or properly tested. Now, in terms of the transparency, the Watson report has been tabled by the Administrator, and he has responded publicly. We retain full confidence in the Administrator, respected KC Mark Irving. Not a single bad actor referred in this Watson report still works for the CFMEU, and all have been removed by the Administrator. Those opposite have irresponsibly called for his sacking of an Administrator that has achieved more progress in cleaning up the union in 18 months than they achieved in their whole time in government. Over 50% of the organisers in the Victorian branch have been removed. 90% in New South Wales, and in Queensland 50%. Let's remember how many those opposite removed. A big
member
fat
for Wright,
zero.
member for Gippsland.
Now, I will also refer, considering that the Leader of the Opposition has referenced Jeffrey Watson, and he has provided evidence to say today, if anything I've said here today would suggest there is an outcome about removing the Administrator, they should think again. They would be mad to get rid of Mark Irving. So those opposite might want to distract from their chaos and disruption. Nothing will do that. We have been very, very clear about they can say they're smoke and mirrors, but we have been clear. We have been very clear, and they need to think again.
Order when the House comes to order. We'll hear. Order the Manager of Opposition Business. We'll hear from the Honourable Member for Bass.
Thank you, Speaker. My question is to the Prime Minister. How is the Albanese Labor government investing in bulk billing and strengthening Medicare for every Australian after a decade of cuts and neglect? How have the government's policies been aimed at correcting past policy mistakes?
Grateful to the Prime Minister.
Thank you very much, Mr Speaker. Well, in February last year, I proudly stood in Launceston with the then Labor candidate for Bass and announced that a re-elected Labor government would make the biggest ever investment in bulk billing. And on the 3rd of May, Australians voted to strengthen Medicare, and on the 3rd of November, our commitment to tripling the bulk billing incentive for every Australian began to roll out. 3 months later, and it's clear that what we promised is delivering for Australians. Around Australia today, more than 8 in every 10 visits to the GP are fully bulk billed. Millions of people getting the health care they need with just their Medicare card, not their credit card. And now nearly 3,400 GP practices are fully bulk billed, an increase of 1,300 clinics since November in that short period of time. More bulk billing, in fact, in every single state and every territory, giving Australians access to the health care that they need. Now, we don't know who the Liberal leader will be next week, but we do know that they'll be against Medicare, because the member for Hume wanted Tony Abbott's GP tax, and he said this: we know that the GP co-payment is reasonable. They were against any free visits to the doctor because they wanted a co-payment on every single visit. But it gets worse, Mr Speaker, because in 2015, the current Leader of the Opposition and then the Health Minister decided to extend the freeze on the Medicare rebate. That's bad enough, Mr Speaker, but the member for Hume called for her cuts to go even deeper and further. In an opinion piece from 2015, he said the member for Farrer's program of cuts
The member for
should extend
Gippsland will cease
across the
interjecting.
health system. Across the health system. We all remember when they came to office the last time in 2014, ripping money out of health, ripping money out of education. But for the member for Hume, it didn't go far enough. They wanted to rip even more out. Now, only Labor is committed to strengthening Medicare. It's what we do. Through cheaper medicines, the tripling of the bulk billing incentive, the urgent care clinics, the increased hospitals funding, the Medicare mental health clinics, all of these measures all aimed at strengthening Medicare and repairing the damage that those opposite did.
Prime Minister's
those opposite did over their time in office.
Give the call to the honourable member for Warringah.
Thank you. To the Prime Minister. The grieving family of Australian aid worker Zomi Frankum, killed in Gaza nearly 2 years ago by Israeli airstrike, still seeks answers. The conflict has been among the deadliest on record for journalists and aid workers, with over 200 journalists killed and 400 aid workers killed. Zomi's brother raised his concerns directly with the Prime Minister about no one facing accountability. Will the government now push for an independent war crimes investigation into her death, the targeting of aid workers and journalists? What accountability will the Prime Minister request of President Herzog?
Give the call to the Prime Minister.
I thank the member for Warringah for her question, and I note that if President Herzog wasn't here, I wouldn't have been able to raise the issue of Zomi Frankum with him, which is precisely what I did this morning, along with a range of other Australian government concerns. That's one of the reasons why you have dialogue in a respectful way, to get outcomes and to advance Australia's national interests. So one of the issues that I have raised is Zomi Frankum and her 6 World Central Kitchen colleagues. These deaths were a tragedy and an outrage. We said that at the time. We've made it clear that that remains the Australian government's position, and we've also made clear our expectation that there be transparency about Israel's ongoing investigation into the incident. We continue to press for full accountability, including any appropriate criminal charges. Last year at the United Nations, Australia and our partners launched a declaration for the protection of humanitarian personnel. That was led by our Foreign Minister, Penny Wong, who engaged with her colleagues right around the world to issue that statement, to which more than 100 nations signed on, attempting to get a global position so that the figures that the member referred to, every one of them a tragedy, every one of them an outrage, whether it be journalists or aid workers losing their life, going about doing their job, whether that be reporting on what is occurring in Gaza and the Middle East, or whether it be that critical work providing humanitarian support to Gaza, which is under the middle of a humanitarian catastrophe, something that Australia has increased our aid for and will continue to do. We have spoken about humanitarian aid as well with the Israeli government and with the Israeli president. I must say the Israeli president has said that he will engage and come back to the Australian government about the issues that we have raised. The issue of the protection declaration is about honouring the courage and kindness of Zomi Frankham and her fellow aid workers. This is someone who didn't just provide aid in that area of the world, but along with other World Central Kitchen colleagues, the head of whom is based in New York and is known to President Herzog, has done extraordinary work in war zones and under extreme difficulty, taking risks in order to help their fellow humanity. We honour Zomi Frankham. We say to her family that our sincere condolences on what is a tragic loss, and we'll continue to work each and every day to do our best to ensure there is transparency and there is appropriate action.
Call to the honourable member for Barton.
Thank you, Speaker. My question is to the Minister for Health. How are the Albanese Labor government's record investments in Medicare making it easier for Australians to see a doctor for free? And why is it important to lift bulk billing rates after a decade of cuts and neglect?
Call to the Minister for Health and Ageing and the Minister for Disability and the National Disability Insurance Scheme.
Thanks, Speaker, and thanks to the member for Barton. She told me that her time at St Vincent de Paul before she came to this place reinforced for her the importance of healthcare being more accessible and more affordable for all Australians. And that's why we have a strengthening Medicare agenda that rests on 4 core pillars, rolling out 137 urgent care clinics, including the Carlton Urgent Care Clinic that we visited 18 months ago and has already seen more than 23,000... I'm not going to respond to this provocation, Mr Speaker.
Order.
Not going to respond again.
Order.
I got suckered yesterday. I'm not going to be suckered again, Mr Speaker. More doctors and cheaper medicines as well, Mr Speaker, but the central pillar of our agenda is turning around bulk billing rates, which were in free fall, Mr Speaker, when we came to government after a decade of cuts inflicted on our cherished Medicare system by those opposite, including the now Leader of the Opposition, Mr Speaker. Now, our first decision back in 2023 was to triple the bulk billing incentive that GPs receive when they bulk bill pensioners and concession card holders and kids. And I'm pleased to report to the House, Mr Speaker, that the bulk billing rate for those 11 million Australians now sits at 92.5%, Mr Speaker. But we were also very worried about the bulk billing rate for people who don't have that concession card, which was continuing to slide after the cuts made by those opposite. And that is why, as the Prime Minister said last year, for the first time ever, we extended bulk billing support to every single Australian and decided also to pay an incentive to general practices that switch to bulk billing all of their patients all of the time. And, Mr Speaker, I'm happy to say in just 3 months, an additional 1,300 general practices have switched from charging gap fees back in last October to bulk billing everyone. And I'm particularly pleased to report to the member for Barton that now more than 3 out of every 5 general practices in her electorate are 100% bulk billing practices, because it's good for the practice, it's good for the doctors, and most importantly, it's good for their patients, because it means more Australians can feel confident that they can go to their doctor whenever they feel they need to, rather than when they feel they can afford to, Mr Speaker. And I also want to say this has been especially good for those Australians who don't have the benefit of a concession card. In just the last 3 months, the bulk billing rate for those Australians has climbed by 8%, Mr Speaker, delivering millions of additional free visits to the doctor. Now, we know there's more to do, we know there's more improvement to make, but our record investment here is already making a huge difference to millions of Australians and delivering a stronger Medicare.
We'll move to the next question. I'll just do some quick acknowledgements. I'm pleased to inform the House that present in the gallery today is Tony Stewart, the former Deputy Speaker and former member for Bankstown in the New South Wales Legislative Assembly. Accompanied Mr Stewart is Ms Judy Barraclough, the CEO of Youth Off the Streets, a guest of the Leader of the House. I'm also pleased to inform the House that present in the gallery today is David Ballantyne, the CEO of Homefront Australia, an Australian veteran success story. And also, it's a bit dangerous, I'm pleased to inform the House that present in the gallery today are representatives of the Richmond Football Club, who are here for Tigers on the Hill, hosted by Minister Catherine King and the member for Wannon, Dan Tehan. Welcome to you all. Order. 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 When the House comes to order, we'll hear from the honourable member for Goldstein.
Thank you, Speaker. My question is to the Minister for Employment and Workplace Relations. Revelations in The Age today expose that the Prime Minister's handpicked CFMEU administrator has requested the deletion of 2 chapters from the independent probe highlighting the CFMEU Labor cartel report, calculated at $15 billion of washed taxpayers' subsidies that end up in organised crime. In your previous answer, you said that the report was received by your office on the 9th of February. Did your office seek a copy before that date, and which version did you get? The full version, the redacted version, or the version with 2 chapters missing?
Call to the Minister for Employment and the Minister for Workplace Relations.
Thank you, Speaker. I need to be very, very clear to the Minister, for the member for Goldstein, that at no stage has my office in any way requested any changes to the report that was provided to the administrator. We received the report.
The Minister will pause. The Minister will pause. The Minister's 30 seconds in, so you can have your point of order now, but you'll only get one shot at it. So the member for Goldstein, a point of order.
Point of order relevance. The question was specifically whether a copy was requested, not.
Order. Resume your seat. Yep. The Minister was in mid-sentence saying about the copy of the report when you took that point of order, so I'm going to make sure she's being directly relevant. But we've had the point of order on relevance now, so we can't ask that again. And I'll make sure she is directly relevant, and she may continue.
Thank you, Speaker. My office received the report. I need to be very clear to the member for Goldstein that at no point has my office requested any changes, any omissions, anything different to this report. We received the report, but I need to be clear to the member for Goldstein, this is a report to the administrator, not a report to government.
Order. Give the order when the House comes to order. We'll hear from the honourable member for Gorton.
Thank you, Speaker. My question is to the Minister representing the Minister for Women. How is the Albanese Labor government investing in bulk billing and taking women's health seriously? And what are the risks that this investment faces?
The call to the Minister for Infrastructure, Transport, Regional Development, Local Government and the Minister representing the Minister for Women.
Thank you very much, Mr Speaker. And can I thank very much the member for Gorton for her question. Her electorate is now home to 23 Medicare bulk billing clinics, an increase of 10 bulk billing clinics since we made our record investment in bulk billing, the heart of Medicare. In both the member for Gorton's electorate and now in my own electorate of Ballarat, more than 70% of our GP clinics are now fully bulk billed, joining more than 3,400 fully Medicare bulk billed practices right the way across the country. And this matters. This matters a great deal to the accessibility of healthcare in this country, because we know general practice is absolutely at the core of Medicare. I also know that at least half of the member for Gorton's constituents have seen their access to healthcare improve as a result of the $792 million women's health package. Since we announced that just last year, it has been delivering results for women around Australia that they have been asking for a long time. In just 1 year, women have saved $73 million on contraceptives, menopause and endo treatments. 71,000 women have had a menopause health assessment covered by Medicare. In March, 33 endo and pelvic pain clinics will be up and running all around the country, and by the middle of the year, those same clinics will also be providing peri and menopause care as well. PBS scripts are now capped, meaning every single woman accessing PBS medications is now paying less for their medicines. This is groundbreaking work that treats women's health with the seriousness that it deserves. And it doesn't happen by accident. It's what happens when you support women, and you support women to be in the room making decisions in a majority female government with a majority female cabinet, instead of undercutting women who are brave enough to put their hands up to lead. While we wait for the men in the Liberal Party to draw straws on who their next leader will be, we know exactly what their next leader and the one after that will do to Medicare because they have formed. Liberals always cut our health services and always cut Medicare, and that includes the health services and care that Australian women rely on each and every single day. They let the cost of PBS medicines blow out. They tried to end bulk billing and add the GP tax, a compulsory co-payment, and when we stopped that, as Shadow Health Minister, we're leading the charge, when I stopped that in the Senate, what we then saw was the then government decide that they were going to freeze the Medicare rebate, and we saw basically bulk billing in this country absolutely collapse. They have got form when it comes to healthcare. We know that the pretender, the person who wants to be the leader, has form on it as well.
Call to the honourable member for Cowper.
Thank you, Mr Speaker. My question is to the Minister for Climate Change and Energy. Why can't the Minister just be honest and give a straight answer to the Australian families who have promised a $275 reduction in their power bills by 2025?
Give a call to the Minister for Climate Change and Energy.
Well, thanks very much, Mr Speaker. I appreciate the question. I'm not entirely sure what it is, though. He asked me why I want to answer a question, and then he didn't ask a question. But I'm happy to say, Mr Speaker, we believe energy prices are too high, and we believe governments should take action to reduce them. And that's what we're doing. When you are dealing with higher energy prices, you can have a policy of introducing more of the cheapest, most reliable form of energy available, which is renewables, or you can have a $600 billion plan to introduce the most expensive form of energy available, which is what the honourable member and his friends took the Australian people at the last election and appear to be going down that road again. Now, if you think energy prices are too high, as we do, then you take action to deal with it. You take action through energy bill rebates, which we've done 3 times. You take action through supporting renewable energy, which we are doing, which has seen wholesale prices fall 44% in the last quarter of last year. You take action to ensure that as much of that as possible flows through to retail prices, which we're doing with things like Solar Sharer, which sees 3 hours of free power in the middle of the day to those Australians whom we're able to provide it to, which we support, and those opposite members oppose. So you have a choice. You take action to help Australian families, or you have policies which will make the situation worse, which is what the National Party and their coalition partners in the Liberal Party are proposing.
Order. Leader of the Nationals and the member for Fisher interjected continuously during that answer, and I'd asked them to assist the House by ceasing interjecting. I'd like to hear from the Chief Government Whip.
Thank you, Speaker. My question is to the Treasurer. How is the Albanese Labor government helping people tackle the cost of living now and into retirement? And how does that compare to other approaches?
Call to the Treasurer.
Oh, thanks, Mr Speaker. What an absolute champion the member for Lawler is for her community and for our team here in Parliament House, Mr Speaker. The member for Lawler knows, we all know, that people are under pressure, but more than acknowledge that and recognise that, we're acting on it. We're delivering when it comes to more help with the cost of living. And on that front, today is a really, really important day, Mr Speaker, because we've got this new data out which shows that Australians now have access to more bulk billed GP clinics than ever before. Something like more than 3,400 practices across the country, also more than ever before. And so I pay tribute here to the Health Minister, the PM and the colleagues for the work that we have put into lifting bulk billing in this country, because we understand that when there's more bulk billing, there's less pressure on families. It's a really important way that we're helping to ease the cost of living, but it's not the only way that we're going about that, Mr Speaker. We're also making sure that people on lower incomes can get a boost to their superannuation balances. And that's because just today we introduced legislation into this parliament to make superannuation fairer from top to bottom. By boosting superannuation for people on the lowest incomes and funding that, by making the tax concessions for people with the biggest balances still concessional, but more sustainable, Mr Speaker. That's what today's legislation is all about. Now, if those opposite vote against that legislation, they'll be voting for less super for people with low balances and bigger tax breaks for people who've got $20 or $30 or $40 million in their superannuation accounts. Now, that wouldn't be the first time that they have voted against people on low and middle incomes in this parliament. Perhaps the most egregious example was when, just before the election, when we legislated our tax cuts, those opposite, at the urging of the member for Hume, not only voted against those tax cuts but said if they got the opportunity in government, they would repeal those tax cuts. That would mean higher income taxes under every one of the 14 million Australian tax-paying workers in this country. Under this side of the parliament, Mr Speaker, a tax cut for every taxpayer. On that side of the parliament, because of the economic genius of the member for Hume, every single taxpayer would get a tax increase. I notice the Leader of the Opposition is not leaping to his defence, Mr Speaker. Now, the point that I'm making, whether it's in bulk billing, whether it's superannuation, whether it's tax cuts that we're rolling out for the second and third time in the life of this parliament, this side of the House is delivering more super, more tax cuts and more bulk billing. That side of the House is divided and they look like a total shambles.
Call to the Honourable Leader of the Opposition.
My question is to the Prime Minister. Treasury has advised the government that its target to build 1.2 million new homes could not be met and that it is more than 80,000 homes behind. But instead of cleaning up union thuggery on construction sites to make it cheaper to build houses, the Prime Minister's hand-picked CFMEU administrator suppressed entire sections of a union corruption probe. Prime Minister, why are home buyers paying the price for Labor's failure to stand up to union corruption?
The call to the Prime Minister.
Thanks very much, Mr Speaker. I do thank the Leader of the Opposition for the question, which draws some very long bows there. Some very long bows indeed. But those opposite
for right
sat on this side of the chamber for 9 years. John Setka, during that period, increased his influence over the CFMEU. They did absolutely nothing. And I tell you what I did after I became leader of the Labor Party was I expelled John Setka within weeks. That's what leaders can do when they lead their party with authority. When they actually have people behind them as part of their party who are working for them, not undermining them. That is what we did on this side of the House, which is why we were able to, when we came to government, take strong action. And we took strong action to intervene, to insert the administrators, which has seen people leave that union and that industry. Now, when it comes to our target, construction cost inflation has fallen from a half-century high under the Coalition. Housing construction costs were rising at 17% when we came into office. Now it's 1.8%. There are more first home buyers under Labor than there were under the Coalition. We've directly helped over 220,000 Australians into home ownership sooner. New home starts are up. New dwelling commencements were up 11.6% compared to a year ago. And of course we're doing something that those opposite never did, which is to actually build social housing. To actually, we on this side don't look down our nose at people. We understand that social housing is an important part of what we want to achieve. Now, the Master Builders CEO has said the 1.2 is achievable. For the first time, we've seen a federal government actually recognise that they've got a leadership role in resolving this problem. Up until the Albanese government, we have seen federal government say, no, it's the problem of the states, it's the problem of local government. That's Danita Warren, the CEO of the Master Builders of Australia. We are getting on with the job of building homes for Australians. Those opposite are just trying to tear down their own house.
The call to the honourable member for Braddon.
Thank you, Mr Speaker. My question is to the Minister for Regional Development, Local Government and Territories. How is the Albanese Labor Government improving access to health care for people in regional Australia? And how does increasing the bulk billing rate improve health outcomes after a decade of cuts and neglect?
The call to the Minister for Emergency Management, the Minister for Regional Development, Local Government and Territories.
Thank you, Mr Speaker, and thank you to the member for Braddon for the question. Her advocacy on healthcare across Tasmania is legendary. Mr Speaker, the Winter Olympics may be on in Italy at the moment, but there are green and gold signs popping up all over regional Australia because the government is strengthening Medicare. Because when you're sick, seeing a doctor shouldn't be a struggle. The Albanese government is laser-focused on improving access to healthcare for people across regional Australia. And we're doing this by encouraging more GPs to bulk bill and by opening Medicare urgent care clinics around the country. Since the Albanese government expanded the bulk billing incentive on the 1st of November, Australians can now access over 3,400 Medicare bulk billing clinics across the country. From Burnie in Braddon to St George's Basin in Gilmore, there are more GPs bulk billing in our regions than ever before because your postcode shouldn't determine your access to health care. I'm proud that the Labor government is helping more people in our regions access urgent care when they need it. In just 3 months, the bulk billing rate for Australians has jumped to 81.4% nationwide. It's the largest quarterly jump in 20 years. Bulk billing rates are up 6.4% in our regional areas, 5.5% in rural communities. There's been an increase in GP bulk billing in every state and territory across the country. Mr Speaker, Medicare urgent care clinics are critical to improving health outcomes in our regions. More than 2 million Australians have already received free urgent care at Medicare urgent care clinics. And just recently, I joined my local healthcare professionals at the launch of the Bega Valley Urgent Care Clinic, one of 123 urgent care clinics that have opened, with 40 of those being in regional, rural and remote areas. So if you have a nasty spill on your bike or in a party room, you can just pop over to your local urgent care clinic. They'll patch you up, they might pat you on the head, they'll say, fantastic, great move, well done, insert name here. Not only are we investing in Medicare, we're investing in more places for doctors to train in rural and regional communities, making it easier for people to see a bulk billing doctor. This year, 2,100 junior doctors are starting their training as GP or rural generalists. That is 500 more than the intake under those opposite. While we're focused on healthcare and the access that we have in our regions, those opposite are still focused on themselves.
The call to the honourable member for Lyne.
You wish. Thank you, Mr Speaker. My question is to the Minister for Climate Change and Energy. Does the...
Order, no.
Don't worry, it's coming.
Order. Members on my right, members on my left. We're going to apply the same standards to everyone. The member for Lyne is entitled to ask her question to the minister. I'm going to ask her to begin again, and she's going to be heard in silence, just like everyone else. Minister for Lyne now has the call.
Thank you, Mr Speaker. My question is to the Minister for Climate Change and Energy. Does the minister think he's being clever by refusing to answer specific questions about the Albanese government's broken promise to reduce household energy bills by $275? Why won't the minister respect Australian families with an honest answer?
Order. The standing orders regarding questions are pretty clear regarding Standing Order 100D number 4. I just want to remind members both those last questions are within that band of not being acceptable. I'm just going to make sure the House is following all the standing orders when you're impugning those sorts of motives. We're just getting into danger territory. So just moving forward, I'll allow the question and the Minister will continue.
Thanks very much, Mr Speaker. As someone who holidayed in Taree as a kid, I'm happy to get the question from the honourable member for Lyne because she represents a beautiful part of Australia. I'll give her that, Mr Speaker. It's a magnificent part of Australia. But I'd say this to the honourable member.
Order.
Every honourable member should be honest with the Australian people about their energy policies. Every honourable member should be honest about the impact of their energy policies on Australians. Like if you were inserting the most expensive form of energy known in the world, nuclear energy, you should be honest about the impact that would have on the people you purport to represent, Mr Speaker. And I say this.
Order. The member for Barker, I'm trying to hear the member for Wannon and you're making it very difficult to do so. I know you'd love to assist the House. So I'm going to hear from the order. I'm going to hear from the member for Wannon on a point of order.
Thanks, Speaker. It goes to relevance. The question had nothing about the opposition in it. It was a very direct question talking about the $275, and I'd ask you to draw the minister back to the question.
The Leader of the House.
Just to the point of order and the audition that was just taken, can I say that whenever a question is out of order, as you'd indicated that was, when it's allowed to go ahead, there is always a very broad ruling that's given with respect to relevance.
Yeah. I mean, it's not like a question we've had earlier in the week, which was provide a figure, provide a number, which I dealt with. When you're asking, does the minister think he's being clever, those sorts of questions, and as I indicated to the House under Standing Order 100D4, it's pretty difficult to say it's a tight question. It's not. So just going to make sure when he's asked about energy policy and about the reduction in energy bills, he has been directly relevant. And if you get asked that question, you're going to get this answer. I think that's pretty common sense. The minister has the call.
Thank you, Mr Speaker. And I say to the members of the National Party, if you're going to ask the government about climate and energy policy, how about you be honest with the people you represent, that climate change is real and people in rural and regional Australia will pay the price for that climate change, Mr Speaker, and policies which delay action will see people in rural and regional Australia, farmers who've already seen their productivity fall because of climate change, pay the price, and future generations in regional Australia pay the price. And that people in rural and regional Australia have a lot to benefit from well-calibrated policies to see jobs and investment. And that the Morrison-Joyce government told the Australian people that net zero was good for people in regional Australia, and that since then they have walked away from people of rural and regional Australia and are betraying them by their actions.
Order. The member for Gippsland's had a really good go, so he's now on a warning too. So we've got the member for Fisher, the member for Wright and the member for Gippsland's. Yes, the member for Wright, you're in that mix. Just reminding the House where everyone sits. Give the call to the honourable member for Gilmore.
My question is to the Minister for Aged Care and Seniors. How are the Albanese Labor government's changes to bulk billing delivering better health outcomes for older Australians? Why was this necessary after a decade of cuts and neglect?
Call to the Minister for Aged Care and the Minister for Seniors.
Thank you, Mr Speaker. And I thank the member for Gilmore for her tireless advocacy for older people across her community on the beautiful south coast of New South Wales. I'm grateful for the opportunity to tell the House how we're supporting senior Australians to access the services they need, no matter their means. Mr Speaker, I'm happy to inform the House that bulk billing for over 64s is now at over 88%, thanks to this Labor government. And new data shows that older Australians can now access over 3,400 Medicare bulk billing practices across the country. In the member for Gilmore's community, 32 clinics are now fully bulk billing. That's an extra 12 clinics since our changes came into place, delivering free healthcare to seniors close to home. And that number continues to grow across Australia every week and means that more than 96% of older Australians now live within 20 minutes' drive of a bulk billing GP. To all the GPs across the nation who are now supporting seniors to see a doctor for free, our government says sincerely, fantastic, great move, well done, doctors. And Speaker, all of this work builds on our government's other investments to support Australians, including older Australians, with the cost of living. On January the 1st, we delivered the next stage in our plan to make the biggest cut to the cost of medicines in the history of the PBS, with all PBS medicines available for $25 or less. And for seniors who hold a concession card, PBS medicines cost only $7.70 with an annual cap of $277. We're opening 137 Medicare urgent care clinics. More than 2 million Australians have already received free urgent care at an urgent care clinic. We've boosted Medicare with $25 billion in extra hospital funding, helping older Australians get the quality, affordable health care they deserve. It's a long list, Mr Speaker, because it was a big job to claw Medicare back after those opposite left it on its knees. They tried to cut $50 billion from public hospitals. They tried to end bulk billing for all Australians with a GP tax. They tried to jack up the price of medicines, and when they couldn't get any of that through, they started a 6-year-long freeze on the Medicare rebate, which tore $8.3 billion out of the Medicare system. Mr Speaker, for 9 long years, those opposite took Australians for granted. This government is relentlessly focused on the needs of older Australians. Healthcare is a critical component of their happiness and their ability to live with dignity in the community. We'll continue to invest in Medicare so that older Australians can get the healthcare they need at every opportunity.
Order. Give the call to the Honourable the Deputy Leader of the Opposition.
Thank you very much, Mr Speaker. My question goes to the Treasurer. According to the Australian Financial Review, the Treasurer's medium-term budget forecasts have blown out by around $57 billion since the election. The Treasurer has been unable to explain why. The Independent Parliamentary Budget Office has been unable to explain why. And today, the Secretary to the Treasury was unable to explain why. Nobody seems to know. Why won't the Treasurer come clean about his $57 billion budget black hole?
Call to the Treasurer.
Thank you, Mr Speaker, and to the honourable member for his question. I wanted to begin my answer by putting him at ease. He shouldn't read anything into the fact that the member for Goldstein got all the early questions today, or the member for Hume has a haircut. He shouldn't read anything into any of those things, Mr Speaker. Now, when it comes to the substance of his question, Mr Speaker.
The Treasurer will pause. The member for Bruce will leave the chamber under 94A. Order. No, we're not going to have any of that sort of interjections. Order. Just asking the House to settle and asking the Treasurer to return to the question.
Thank you, Mr Speaker. A couple of important elements to the answer to his question, Mr Speaker. The first one is, and he may not be aware, but in the last few minutes, as I understand it, in estimates where the fiscal group were there, they did talk about the change that you're referring to. I think they answered a number of questions about it, and so it may be that you've not yet caught up with that, but that's understandable because you've been in here with us. That's the first point. The second point. Order. The second point is that, as I said on the day of the release of the mid-year budget update in the middle of December, a big driver of the medium-term change has been the provision that we made for the hospitals deal that has subsequently been struck by the Health Minister and the Prime Minister. And so a big part of the change over that 10-year medium-term period, as I said on the day of the MyEFO's release, is the provision that we made for hospitals. Now, the third point is, if you look at the last year of the medium term, in the middle of the 2030s, in the last year, the biggest driver of the change is a change in receipts, lower receipts. And I think I made that point in response to a question from a journalist in the last couple of weeks, 2 or 3 weeks. And so we have answered his question comprehensively. It's been answered in estimates, and now it's been answered by. What? Are you serious?
All right. Yeah, we're just going to hang on a second. The manager, we're just going to do this in an orderly way, as we always do. The Treasurer is going to pause, and the manager under the standing orders is allowed to make his point of order, and I'm going to allow him to do so now.
On relevance, the Treasurer is speaking about an answer given by other people in another place. He's been asked here in the House of Representatives to answer a question. He's saying someone else has answered it somewhere else, but I won't tell you what.
Resume yourself. Well, no. Okay. You've made the point of order, but the Minister is now warned. The Minister for Defence Industry. Okay. When the Treasurer is asked about the department is unable to explain why, the Treasurer is providing. I'm listening carefully. Trust me. The Treasurer, let me just deal with the manager. I'll come back to you, but he's giving information to the House. He spoke about the officials speaking at estimates, providing that information. So he's answering directly that part of the question and providing information. And you may disagree with what he's saying, but he is being directly relevant in providing information to the House about what he was asked about. So you're correct to raise it, but he's also correct in answering the question.
Mr. Speaker, I've answering his question comprehensively in at least 3 different ways. I refer him to the estimates transcript. I'm trying to be respectful in case he doesn't have many more question times as the Shadow Treasurer, and asking him to refer to that. Now, the number that the Treasury has provided is 54, and they provided that. You really should know that. They've done that publicly. The budget papers don't provide that number, but that number's been provided in estimates. And the 2 main drivers of that number are lower receipts and a provision for the hospitals deal. Now, I finish on this point, Mr. Speaker. If those opposite think that we shouldn't be investing that money in our hospitals, then they should tell the Australian people how much they'll cut from hospitals.
That's right.
Because that, on the spending side, that's the major driver of the difference, is hospitals. And what this tells us is that they haven't changed a bit since the last time they were in office, went after Medicare, went after health funding. They'll go after hospitals if they get into office. And the second related point, Mr. Speaker, he asked about the Parliamentary Budget Office. The Parliamentary Budget Office, get this, says that their medium term, their 10-year period, would be $142 billion weaker than ours. So the deterioration in the budget, if they had won the election, 3 times bigger than the deterioration that the Shadow Treasurer is asking me about. I conclude by saying, Mr. Speaker, no wonder he's unlikely to last the week.
Call to the honourable member for Petrie.
Thank you, Mr. Speaker. My question is to the Deputy Prime Minister. How is the Albanese Labor government delivering for defence, and what are the alternative approaches and policies?
Give a call to the Deputy Prime Minister and the Minister for Defence.
Well, I thank the member for her question and acknowledge her service since coming to office in 2022. The government has undertaken the Defence Strategic Review, which is the most comprehensive reassessment of our strategic posture in 35 years, and we are now building a defence force to meet that moment. We've taken the idea of AUKUS and given substance to it, providing for the biggest industrial project in our country's history. We inherited a shrinking defence force. We have now turned that around and it is growing again, and we are undertaking the biggest reform to the defence estate ever. And all of this is being underpinned by the biggest peacetime increase in defence spending in our nation's history. Now, in our system of government, it is important to understand alternatives, as the honourable member has asked, and that really invites me to make a critique of the Shadow Minister's positions on defence. But the issue here is that when it comes to the Shadow Minister and defence, what we have is a completely blank page, because he has said absolutely nothing. I mean, as the Shadow Treasurer in the last parliament, he did say that defence spending should be confined to the fiscal envelope that the Liberals took to the 2022 election, which would mean that he is against the $70 billion worth of investment that our government has made in defence. But on the other hand, and to be fair, in the last couple of weeks he has visited with the member for Flinders to HMAS Cerberus, after which he posted a video in which he said, and I quote, "Massive investments in recent years making a real difference. Zoe, tell us all about it." And helpfully the member for Flinders chimes in, "Never been more recruits coming into the Navy than there is now." And in response to that, let me say, fantastic, great move. Well done, Angus. I actually spoke to my social media team.
Yes, Yes, we'll deal with this in an orderly way. Just want to make sure he was quoting. I'm not sure. I couldn't hear what he was quoting. If he was quoting a social media post or whatnot. But the member for Gippsland on a point of order.
Speaker, in your exhortation at the start of question time for a kind of parliament, and the minister should really direct his.
Order. The Minister for Climate Change. Yes, the member for Gippsland is correct. If the minister was quoting directly, this gets into dangerous territory. The easiest way to do that is simply for everyone to refer to them by their titles, not first names, not surnames, just their titles. Order. The Deputy Prime Minister in continuation.
I suggested to the social media team that we actually repost the video, but they said, in a two-party system based on a contest of ideas, it's really not the done thing. But the problem here in contesting ideas with the Shadow Minister is he literally has no idea. And when it comes to the two-party system, the Liberals are single-handedly trying to dismantle that concept. The only statement of substance that the Shadow Minister has said since being the Shadow Minister is that he wants to be the leader. But if those opposite are going to turn to the Shadow Minister, I can assure them what they will get is a giant vacant space.
Order. Minister for Social Services will cease interjecting. I'd like to hear from the member for Mayo.
Thank you, Mr Speaker. My question is to the Minister for Infrastructure, Transport, Regional Development and Local Government. I understand the Civil Aviation Safety Regulations Part 43 that simplifies field maintenance requirements for aerial work Australian aviation companies has been on the desk of the Minister awaiting approval since October 2024. The delay is causing frustration and hardship for Australian aviation businesses such as crop dusters or aerial firefighting businesses. When will the Minister approve these regulations?
Give a call to the Minister for Infrastructure, Transport, Regional Development and Local Government.
Thanks very much. Well, I invite the member that if you do want to come to my office at any point to talk to me about those matters, I'm very happy to do that. I have a drop-in clinic. In fact, I have one this afternoon, so you'd be welcome to that, and I'd be happy to, if I have it, to provide an answer to the member then.
Order. Order. We'll hear from the honourable member for Menzies.
Thank you, Speaker. My question is to the Minister for Small Business. How is the Albanese Labor government continuing to support hard-working Australians and their small businesses? And what puts this at risk?
Give a call to the Minister for International Development, the Minister for Small Business and the Minister for Multicultural Affairs.
Thank you, Speaker, and I do want to thank the member for Menzies for his question. We spent a lot of time in Menzies, the member and I, visiting local businesses in his electorate. More recently, we visited the Box Hill markets, where we stopped at Blissful Station and met the owner-operator there, Lan, who treated us to some pretty delicious vegan dumplings. Now, I'm not very big on vegan dumplings, but I have to say those from Blissful Station were pretty good. Now, from Box Hill to Broome, right across Australia, Australian small businesses create jobs and they support families and local communities and economies in our regions and in our cities. And that's why the Albanese government is backing Australia's record high 2.66 million small businesses to run and to grow and to succeed. Australians have started 800,000 new small businesses since we came into office, Mr. Speaker. That's a clear sign of ambition and resilience and belief in the future. Now, as someone who has owned and operated small businesses—
The Minister's going to pause. The Minister's giving information to the House. The Leader of the Opposition and the member for Moncrieff just continually going on like that. Just give it a rest. I just want to hear the Minister, and that just is disruptive. And you're doing it to disrupt the Minister, but it's not. It's disrupting the House. So we'll just pause for a while on that. The Minister has the call.
Thank you, Mr. Speaker. As I was saying, Australians have started over 800,000 new small businesses since we came into office, a clear sign of resilience and belief in the future. Now, as someone who's owned and operated small businesses, I know how rewarding it can be, but I also know how difficult it can be. And I just want to take a moment, if I may, Speaker, just to thank the hundreds of small businesses who have taken their time to meet with me and speak with me and share their experiences with me. And I want to ensure them that their insights have been invaluable to shaping what we do as a government. Today I announced an extension of the new Access for Small Business Owners program and the Small Business Debt Helpline, delivering small businesses the help that they need when they need them. It's just one of the ways that our government is helping to ease pressure on small businesses in line with our National Small Business Strategy, the very first strategy of its kind. And that strategy outlines how we will work with states and territories to drive a coordinated and collaborative approach to helping small businesses. We're easing pressure on small businesses by extending the instant asset write-off, and we've given tax cuts that have benefited 1.5 million sole traders. We're levelling the playing field by extending unfair trading practice protections to small businesses and ensuring that large businesses pay them on time. So, Mr. Speaker, while those opposite continue to focus on themselves, we continue to focus on backing Australian small businesses, giving them the certainty that they need to thrive.
Give the call to the member for Indi.
Thank you, Speaker. My question is to the Attorney-General. In the almost 3 years that the National Anti-Corruption Commission has been operating, there's been one finding of officer misconduct, a new investigation of officer misconduct and no public hearings. The NAC's most significant investigation had to be reopened and referred to an independent assessor. The public has heard more about the Commissioner's conflicts of interest than findings of corruption. Attorney-General, do you accept that changes are needed to restore public confidence in the NAC?
Call to the Attorney-General.
Thank you, Mr. Speaker, and I thank the member for her question. And I note both her long-standing involvement in the establishment of the Commission and also the important work she does as part of parliamentary oversight. The honourable member continues to do that in a principled and consistent manner, and my response will reflect that. Mr. Speaker, the Inspector of the National Anti-Corruption Commission has announced that she will investigate complaints about the NAC Commissioner's involvement in defence-related referrals and the Commissioner's ongoing role with the Inspector-General of the Australian Defence Force. Mr. Speaker, as the House will know, the Inspector is independent of the Australian Government and from the Commission. And it's also important to note that the Inspector is not subject to anyone's direction when performing her functions. The member also raises issues regarding the NAC's work and some of its findings. Mr. Speaker, this government was elected on a platform of legislating an independent anti-corruption commission with strong oversight. That oversight is working as intended. And we honoured, as I said, that commitment, and it will interest the House to know the following. Since it commenced operations, the Commission has received over 6,000 referrals. It is currently conducting 30 preliminary inquiries and 35 corruption investigations. Since the 1st of July 2023, there have been 11 convictions resulting from Commission investigations, and there are a further 4 matters currently before the courts. The Commission publishes regular updates about its work on its website, and I encourage all members to avail themselves of that information at nac.gov.au. As I said, I appreciate the honourable member's ongoing involvement in this area, but it does reflect also a number of important pieces of work that this government has delivered on integrity. But I do say in all sincerity to the member, there is much more to do. There is much more to do in a lot of these areas. Legislating a powerful, independent and transparent NAC was an important role. Introducing a new fraud and corruption control framework, imposing stronger anti-corruption obligations on all Commonwealth agencies is another of them. Making sure that we have a Royal Commission into the robo-debt scheme and implement those findings, but also ensuring that in other portfolios we strengthen our anti-money laundering regime through the passage of the Anti-Money Laundering and Counter-Terrorism Financing Amendment. Mr Speaker, what this points to is the important work not only of the Commission but also of oversight, but I take on board the honourable member's comments that they have come from a sincere place, that there is much more work to do, and we support the NAC in undertaking that work.
Give the call to the honourable member for Melbourne.
Thank you, Speaker. My question is to the Treasurer. How is Albanese Labor government cutting taxes for working people at the same time as improving the budget? What risks are posed by our approaches?
Give the call to the Treasurer.
Thanks, Speaker. I know from engaging with the member for Melbourne on a whole range of issues what a wonderful advocate she is for the people of that great city, Mr Speaker. Really the biggest difference at the last election, Mr Speaker, was on economic policy, because we had a plan to cut taxes, to help with the cost of living, repair the budget and invest in the future. And those opposite had a policy for higher income taxes and bigger deficits and more debt. And that's what their election document made clear when the member for Fairfax and his nuclear reactors got together with the economic incompetence of the member for Hume, and together they nuked the opposition's economic credibility, Mr Speaker. And that's one of the reasons why sensible Liberals like Malcolm Turnbull have said that those opposite have run off into la-la land. This is why Peter Costello, Mr Speaker, Peter Costello told Troy Bramston that, I'm quoting, at the last election they got themselves into a position where they are proposing to increase income taxes, run bigger deficits with no real plan to...
Sorry. I don't... Order. The members on my right, just the member for Wannon and a few others, if you can just... I couldn't hear a word the Treasurer was saying. Mention a name and there was a reaction, but order. Let's just return to the question and then get through the answer. Order.
Thank you,
continuation.
Thank you, Mr Speaker. So the feedback from Malcolm Turnbull, the feedback from Peter Costello, and also the feedback, Mr Speaker, from some of the member for Hume's colleagues who said to Sam Maiden that he was, quote, an absolute disaster in that role. Or another one who told Karen Barlow that everything he touches turns to custard. He was a disaster as Energy Minister. He was a disaster as Shadow Treasurer. The definition of insanity would be to put someone with a disastrous track record into the top job hoping things would be different.
I'm going to hear from the member for Page, who's on his feet. No, just I'll deal with this matter. This came about on Monday, and I can advise the House on advice from the Leader of the Opposition by her staff in relation to the Leader of the Nationals and the Deputy Leader of the Nationals by their appointment. They are members of the Executive. No, order. Order. Yes, of the shadow executive. Yes, the Leader of the House is entitled to ask that question because that was never explained to the House. To be fair, normally in normal practice, someone will advise the House of those arrangements. That didn't happen, so I'm entitled to address order. I'm entitled to address the House, and the Leader's entitled to raise that question. Just to deal with this matter, and then we'll get to the point of order. Don't worry, we'll get there. So just pause for a moment. If you take your seat, we'll deal with this matter about the front bench, and then we'll hear from the Leader of the House.
As you referred to, it's page 111 of practice that makes clear that only members of the opposition executive can speak from the dispatch box. The public comments from the Leader of the Opposition on the 8th of February are that the shadow ministers do not return until the 1st of March.
Well, I said we'll deal with this, then you can respond. No, it's... They don't. And order. I said I would hear from the Leader of the House, and he was entitled to do that. Then we will come to you, Manager, and you will have your point of order.
And the Manager of Opposition is right. This is a matter for the Opposition, which is why I'm quoting the Leader of the Opposition. And the Leader of the Opposition said that the Leader and Deputy Leader of the Nationals will attend meetings of the leadership group, but said this is only to ensure joint representation and accountability in decision-making during this interim period. It does not make them shadow ministers and does not make them members of the Opposition executive.
Yes. And the standing orders, look, the leader of the House is correct, because this was not addressed on Monday, and to be fair to the House, it is the responsibility of the Opposition and the government to update the House. That didn't occur. But under the standing orders, it is also under the Speaker's purview to resolve these matters, and I chose to do that under advice from the Leader of the Opposition, who advised me that by the nature of those positions and within consultation, they are able to be members of the executive, or to sit there. To assist the House moving forward, if there are, in future, if there are changes, it would be helpful to the House if someone can advise the House of that, so it doesn't place the Speaker into that position, so this matter doesn't have to be resolved in such a way. So we're clear on that matter. We now move to order. Members on my right, we're not going to have that. Now, we'll deal with the point of order by the Deputy Leader of the Nationals.
Thank you, Speaker. Speaker, the point of order is on relevance. The Treasurer was asked a question about government policy. He spent a minute and a half basically reflecting and insulting members of...
Yeah. The question contained what risks are there to approaches. So it's bordering on abuse of the standing orders. The Treasurer, because he was asked about this. The question was, what risk are there to our approaches? So listen to the question, and that's why the Treasurer has this opening to do that under the standing orders. We've got a minute and 20 seconds to go. We're going to listen to him and conclude the answer.
Yeah. Thank you, Mr Speaker. The point that I'm making is this side of the House is cutting income taxes and getting the budget in better shape, and the member for Hume took to the last election a policy to jack up income taxes and to make deficits bigger and debt worse, Mr Speaker. And that's why those opposite are balking at him now, Mr Speaker, because in every portfolio that he's held, he's failed badly and he's failed upwards, Mr Speaker. And the worse he performs, the more entitled he feels to a promotion, Mr Speaker, no matter what happens. At every stage of his life, he wants everything handed to him on a silver platter, Mr Speaker. And he reminds me of a famous saying, Mr Speaker. The member for Hume was born with a silver foot in his mouth, Mr Speaker. Now, just when we thought that they couldn't go any lower on the economic credibility, the member for Hume says, "Hold my Chardonnay," Mr Speaker. He is a living, breathing reminder that the Liberal Party has become the party of higher income taxes, higher deficits and higher debt, Mr Speaker. He goes months without asking questions in this place, but those opposites should ask themselves, do they really want him to do to their party this term what he did to their economic credibility last term?
Call to the Prime Minister.
Ask further questions be placed in the notice paper.
Order, if members can leave the chamber quickly and quietly, we will deal with papers from the Leader of the House.
Speaker, these documents are tabled in accordance with the list circulated to the honourable members earlier today. Full details of the documents will be recorded in the votes and proceedings.
I've received a letter from the honourable member for Goldstein proposing that a definite matter of public importance be submitted to the House for discussion, namely the government turning a blind eye to union corruption. I call upon those honourable members who approve of the proposed discussion to rise in their places, and I give the call to the honourable member for Goldstein.
Thank you, Speaker. Speaker, today is a landmark day in an exposure of union corruption in this country. We know that last year Jeffrey Watson SC was commissioned to deliver a report into the corruption of the Queensland CFMEU, not just the corruption but the violence. The report catalogued directly the scale of corruption that sits at the heart of the Queensland CFMEU, including a time following a Queensland Labor government election where CFMEU officials walked into consultations, stood over and intimidated public servants and said, "You work for us now." This is a fundamental issue of corruption that goes to the heart of the CFMEU Labor model in Queensland, and now we are seeing it directly in the context of Victoria. Yesterday, Transparency International released its latest report on corruption in Australia, and under the Albanese government, corruption has increased and our international ranking has fallen. And we are seeing explicitly why in the report that was tabled finally for public consumption, looking at CFMEU corruption in the context of the state of Victoria. And this report, which we know was provided to the CFMEU administrator on the 1st of December last year by testimony from Jeffrey Watson SC in the Wood inquiry in Queensland, we now know it has been exposed in the Nine press. There has been a deliberate attempt to redact 2 chapters of this report. And why are they seeking to redact those chapters? Because those chapters go to the heart of the CFMEU Labor cartel business plan, which has seen $15 billion $15 billion of taxpayers' money laundered through a process of Albanese government-funded projects and Victorian government projects under the Allen government, and found its way where? Into the hands of organised crime and bikie gangs. This is the most disgraceful example and abuse of public money that could ever have been proposed. In fact, had someone suggested at the start of this inquiry that that was what was going to be revealed, I suspect most of the members on this side of the chamber would say it was impossible. This is now the lived reality of the CFMEU Labor cartel of corruption and the consequences. And the tragedy is the minister still won't answer basic information in this House. Yes, it was absolutely a report that was commissioned by the CFMEU administrator. Yes, we now know that she received a copy of it on the 9th of February, only a few days ago. But what she's refusing to admit is whether she's been in contact with the CFMEU administrator, whether she asked for a copy of the report, because we wrote to the minister last year saying this report has been published, you should be requesting it, and why haven't you requested it? And if you do have it, release it. It's very clear to me that the minister knew full well that she didn't want to receive a copy because she knew how scandalous it was. And it took whistleblowers to come forward and say the report had been redacted and the information had been kept from the public square. This is now clear that the minister is engaging in see no corruption, hear no corruption, so she does not have to answer for CFMEU Labor corruption. She also can't tell us what report she received. We asked today, in question time, what version of the report she had, and on the 9th of February, whether it was the full report, a redacted report, or the report that excluded 2 chapters. She hasn't answered that. There will be further questions because we know exactly the consequences of when the minister won't reveal this information. She is running away from the consequences of CFMEU Labor corruption because she knows how directly it connects back to the heart of the Albanese government. We know it, the Australian taxpayer knows it, and now an independent report to the CFMEU Commissioner has confirmed it. But it's not just that part of the dishonesty, Deputy Speaker, that we are facing from this report. We know once it was revealed that the CFMEU had become an enabler of organised crime and bikie gangs to launder money through Victorian government big build projects. The Prime Minister and various state premiers and leaders from the Australian Labor Party said, we'll never take public money or take money from the CFMEU anymore. We don't want their tainted cash. But what we know from AEC disclosures just last week is that that has been exposed as a falsehood, because they might say they're not going to take the cash, but they seem happy to cash the CFMEU's cheque. And when you think about the $15 billion that has been laundered through these public projects into the benefit of organised crime and bikie gangs, and now some of those cartel kickbacks are going into the Labor Party's coffers, it directly compromises the foundations of this government. More than that, the licence of this government and their willingness to tackle corruption is brought directly under question. While the minister stands here and boasts at the dispatch box that there are all these people that are removed from the CFMEU who have serious allegations to answer, what she won't tell you is that they're resigning just before they're sacked, and then they're walking over to the Electrical Trade Union to propagate the business model, the CFMEU Labor business model, so that they can continue the extortion racket that is going on in public projects in this country. That's why the Labor Party wants multi-employer bargaining. Empowers the unions to be able to engage in an extortion racket of public money to drive the cartel kickbacks and send them flowing through from the unions to organised crime, and some of it is ending up in the coffers of the Australian Labor Party. We know that Labor has actively sought to undermine the flow of cash, the limitations that we want to put on the flow of cash that has gone into redundancy funds. Why? Because it provides a slush fund for the unions to wash money around as they see fit. But when it comes down to this report that was tabled by the author in the CFMEU inquiry in Queensland today, we get a shocking picture of the lived reality of union corruption that has been presided over during this period. You just need to go to the report and you can quote from it directly. But from those great, and of course we can't quote from it directly from a document table in this parliament because the Leader of the House refused to allow it to be tabled in the lead up to question time, Deputy Speaker, to make it a permanent and public document so that it can never ever be silenced or whitewashed again. But let's go to what the report says. But from the great heights of the CFMEU in Victoria, it collapsed into a squalid mess. It slid from being a union which fought hard for workers to one which started a fight just for the sake of it. It devolved from being a union which honoured the dignity of working Australians to a union which cultivated the company of underworld figures. It deteriorated from being progressive, tolerant and respectful. I would contest that, but I'll accept the author's claim. Quote, into a violent, hateful, greedy rabble. It degenerated from being a union where people were respected for their honesty and decency, again a contestable claim, to one where, quote, a decent person who spoke out against corruption was shouted down and told they were, quote, a dog, a rat or a word I will not mention in this parliament. The cause of the collapse of the CFMEU was not from within, it came from the top. Further quoting, it was shocking to see so much crime, so much corruption and such a perversion of values. The CFMEU was no longer on the right side of civil society, it was proudly on the wrong side. The union was no longer the champion of the working class. In fact, it became looking after gangsters, standover men, bikies, heroin traffickers and even killers. By the end of the investigation, I have been left with the empty feeling that the Victorian branch of the CFMEU was no longer a trade union, it was a crime syndicate. And this is how $15 billion has been fleeced from the Victorian and Australian taxpayer through big build projects that have been contributed to by the Victorian government and the Victorian taxpayer and the Australian taxpayer, and found its way into organised crime, criminal syndicates and bikie gangs. And the least the minister could do and the least the Prime Minister could do is actually answer basic questions truthfully, honestly in this parliament about what they knew, when, what they requested, and more to the point, the type of report. And every single member that opposes this motion is going to be condemned for seeking to run interference for that agenda.
And the Assistant Minister to the Prime Minister, Public Service, Employment and Workplace Relations has the call. I ask all members who are leaving the chamber to do so quietly.
Thank you, Deputy Speaker. Let's be clear. Under this government, 121 individuals have been removed from that union. Under those opposite, over 9 years, how many were removed? That's right, 0. Not a single official removed from that union while you were in office. 121 removed during Labor's time, cleaning up the mess that was left behind by those opposite. Your policy solutions did not solve any of these challenges.
Assistant Minister, I'm not taking your point of order just yet. I'm going to deal with the member for Fisher. That was a very aggressive interjection right by my ear, couldn't be missed. Don't repeat it. You were warned by the Speaker during question time. You will be leaving if it happens again. Have you got a point of order, member for Goldstein?
Deputy Speaker, I do have a point of order. The member reflected on the chair rather than members opposite.
Take a seat, please. I will deal with any points of orders. I couldn't hear it because of your colleague yelling in my ear, but I will ask all speakers to direct their comments through the chair. Thank you.
I withdraw that last comment, Chair, and thank you very much. Let's be very clear. This government has no tolerance for corruption. We have no tolerance for criminal activity in the construction sector. That is why this government took the strongest action of any government, of any persuasion, when it comes to cleaning up the CFMEU. We appointed an administrator. We support the administrator to do their work. We've had those 121 individuals removed, and we've made more progress in 18 months than they made, those opposite, in 9 years of government. And I want to make very clear, as was made clear to the Shadow Minister in question time, that the Minister received the final report and did not request a single change. We can have 10 minutes from those opposite telling us a whole range of things, but it was clear from the contribution from the Shadow Minister that, despite asking questions in question time, and I congratulate the Shadow Minister for doing very well in their tactics of getting a large number of questions, and I could see the jealousy of those behind you from that very odd place that I sit over there during question time, but you clearly were not listening to the response. But what I think we also saw just then was 10 minutes of a brand new television channel that has launched today. I watched with interest the interview with the Shadow Minister on Laura Jay's today, where he said two very interesting things. Firstly, he said, quote, "It doesn't matter who sits in the swivel chair." Well, I think that is very interesting, but he looks pretty comfortable there right now, Deputy Speaker. I did note that the member for Farrer stayed for the Shadow Minister's remarks. I noticed that the member for Hume managed to get out of here pretty quickly, but again, I'm reassured, and I'm sure great comfort for the Leader of the Opposition when the member for Goldstein says it doesn't matter who sits in the swivel chair. But that wasn't the bit of the interview that excited me, Deputy Speaker. The bit that excited me was the launch of a brand new, I assume free-to-air, station. It might be pay-per-view, I don't know, you'd have to ask. But the member opposite said it has on Channel Tim. And Laura Jay says, quote, "Channel Tim, I like it." Well, I've just seen 10 minutes of Channel Tim, and I don't know if I really like what I saw, and I think we'll leave it to the public to review. But we know the sorts of things that we'll get on Channel Tim. You can be guaranteed that Channel Tim will have a lot of self-promotion. We've seen that on Politics Now, where very openly on Boxing Day, a day for giving gifts, and there was a gift from the member for Goldstein where he said, quote, about his possible desire to seek higher office, to possibly get into the leadership role, quote, "I think there's a scenario where that can happen, but I think events will have to turn in my favour," he told the podcast. But he's been out there every couple of months. There's a new thing. You go back a month earlier, you look at the great industrial relations policy. I'll tell you, the only industrial relations policy that's actually been released by those opposite was their commitment to not have Parliament sit on Melbourne Cup Day. We had the member for Goldstein say that he guaranteed, quote, "I make this commitment. This will never happen under a Wilson government." A singular policy, wanting to make sure that he and his colleagues get a day off on Melbourne Cup Day. But while he wants to give himself—
Is this a point of order from the member for Fisher?
Point of order is in relation to relevance. This has absolutely nothing to do with the matter of—
You can just take a seat, please. Assistant Minister has a call.
There's other— maybe I've been unfair on the member for Goldstein that he only has one policy, which is to give himself a day off for the Melbourne Cup. He has another policy that just a few weeks after the election last year dived in with Ronald Meisen at the AFR and suggested, with this headline, quote, "Liberals IR man Tim Wilson wants school kids taking up side hustles." So we've got bring back child labour and give the politicians a day off for the Melbourne Cup. That's what we've got from, quote, someone who's described by a mutual friend of ours, former member for Mackellar, Jason Flinsky, as possibly the next Liberal leader. And it's amazing, if you go back all the time to May last year, the foresight that Mr Flinsky had about what was going to happen in the Liberal Party. He wrote this: "Gather round all who dare as the Liberal Party indulges in its triennial version of the Hunger Games." Well, indeed, they've gone longer than the book series did. But Jason also said one thing that was— so Mr Flinsky said one thing that I think we would agree across the chambers. I think I can agree on this side, can agree on that side. And it was this quote, and I'm just quoting to be clear before someone gets up with an interjection.
I will remind that quotations are no
I'll adjust. It refers to a member by name, but I'll adjust to be compliant with the standing orders. "The member for Goldstein is not the Messiah." That was the quote, and I think that's the one thing we can all agree on. But if the member for Goldstein is to achieve his goal of becoming higher office, as he himself expresses, then he will have to do so as part of this new coalition of chaos that has been formed between the Liberal Party, the National Party and One Nation. We know they voted together when it came to opposing cutting student debt. We know they voted happily with One Nation when it came to opposing 3-day guarantee for childcare. We know that they voted together with One Nation to oppose closing loopholes and, indeed, to oppose free TAFE. And the other thing that no one opposite wants to talk about is that this government has a record of delivering for working people. This government has delivered when it comes to wages. When it comes to it, I remember when they opposed a single dollar increase in the minimum wage. Refused, went to an election saying don't give people a $1 increase. Instead, now, under this government, we've seen those on the minimum wage get a wage increase per hour of $4.62. And those opposite are now interjecting again, opposing even a $1 increase, let alone a $4.62 per hour. Now, for those opposite might not care about those on the minimum wage, but I care, and people on this side of the House care, that those on the minimum wage are now earning, as a result of the efforts of the Albanese Labor government, now earning an additional $9,120 a year. Similar, when we talk about what's happened when it comes to penalty rates, again, those opposite contested that we should not do anything to protect penalty rates. We had a different view. We saw the benefits of making sure that we protected the penalty rates of working people. And 2.6 million Australians have benefited because of our efforts to protect penalty rates. Further, for those who work in early childhood education, again, those opposite opposed these measures, but we thought it was necessary to support the early childhood workforce. As a result of the wage supports that we have put in place, now fully delivered, some 15,000 additional people have gone into the sector, removing the shortages that have been hurting parents, hurting families and denying children the education and care they deserved. I'll finish with some facts that I know those opposite don't like. Under this government, a record number of Australians in work. Under this government, Australia's unemployment rate is just 4.1%. We have incredibly high participation at 66.7%. In December alone, another 66,000 Australians in work. Did we see any celebration of that from the Shadow Minister? No, he must have been too busy on Tim TV. Now, we will always look for ways to support working Australians to earn more and keep more of what they earn, and I think Australians have already seen enough of the clown show opposite, and have definitely seen enough of Channel Tim.
Give the call to the member for Fisher.
Thank you, Madam Deputy Speaker. And what we've just heard is 10 minutes of unadulterated, unobscured, just constant attack on the Shadow Minister, who has raised a matter of very significant importance, talking about alleged corruption in the building industry. Now, Madam Deputy Speaker, you have heard me speak about corruption in the building industry for 10 long years. I have spoken about this uphill and down dale. And whenever I spoke about it, those opposite, nothing to see here, no, all white noise, nothing, there's no problem with the CFMEU. They kept taking their money, their donations from the CFMEU, and it wasn't until, I think it was last year, that Channel 9 did an expose which put the issue beyond doubt. And then we saw the member for Watson and the Prime Minister say, we had no idea about the extent of this problem, or that there was in fact a problem at all. It reminds me of the old Suncorp, the Queenslanders on my side will get this, the old Suncorp ad. Charter boat? What charter boat? Nothing to see here. Well, Jeffrey Watson has belled the cat. Jeffrey Watson has belled the cat and identified that there is likely somewhere between $15 and $30 billion worth of corrupt payments that have been made within the building industry. Now, Madam Deputy Speaker, you know as well as I know, and many people in this chamber would know, that I used to work as a carpenter in the building industry in Victoria. My first day on the building industry in Victoria, I experienced the bullying and corruption of the CFMEU predecessor, the Builders Labourers Federation. As an 18-year-old kid, I experienced it. And that's part of the reason why I'm sitting on this side of the House today. Because Norm Gallagher was a rookie at the end of the day. But what we have seen time and time and time again, and businesses have come to see me consistently over the last 10 years and talk to me about the standover tactics of the CFMEU, the fact that they can't get a start on a job unless they agree to pay kickbacks to the CFMEU. Now, when I start talking about this, those on the other side of the House go very quiet, because I'm not talking out of a textbook. I'm talking out of experience, 35, now close to 40 years' experience in the building industry, both as a chippy, a builder and then a construction barrister. The CFMEU has overseen the greatest corruption in this country, in Victoria and in Queensland, and that's terrible in itself. But you know what? Do you know what makes it even worse? You guys, the Labor Party have taken millions of dollars in donations from the CFMEU. And the Prime Minister last year said, we're going to stop taking donations from the CFMEU. But they didn't. And not only did they not, you would think that with this sort of an expose, the Labor Party would say, you know what, we'll do the right thing and we'll donate that money to charity, or we'll donate that money to Mates for Mates or some charitable organisation. But no, that money has stayed in the Labor Party coffers. And I say, shame on you. Shame on the Labor Party, because that money is blood money. And I don't use that term loosely, because the CFMEU have overseen physical harm on building sites, threats, and particularly against women working on building sites, and even public servants. Even public servants. I was in here every day talking about it, and the Labor Party did nothing. Nothing. The Labor Party continued to take the money from the CFMEU. You continue to take the donations. Nothing to see here.
I'd just remind the level of interjections is really unhelpful on both sides. Can I please give the call, and I would like to hear the member for Sturt without interjections. You have the call.
Thank you, Deputy Speaker. The suggestion today is that the government is turning a blind eye to union corruption. That claim, made with a lot of drama, does not reflect the facts. It's a tired refrain, Deputy Speaker, that Labor is beholden to trade unions, that it turns a blind eye to corruption for its own benefit. Those claims are tired, boring and unoriginal and incorrect. Trade unions have a long and important history in protecting workers' rights, improving safety and ensuring fair pay and conditions across industry, including the construction industry. That contribution, which is ongoing and which adapts to the ever-changing way in which we work, should be acknowledged. But acknowledging the positive role of unions does not mean ignoring misconduct when it occurs. And to be clear, despite the comments from the member for Goldstein, multi-employer bargaining does not facilitate misconduct or kickbacks or corruption. It's designed to allow negotiations between employers, unions and workers to boost slow wage growth, to reduce pay inequality and to collectively negotiate for improved conditions. Now, this is why, because unions matter, integrity within them matters. Any corruption or lack of integrity within any union, or indeed any trade organisation, needs to be stamped out. Otherwise, the benefits enjoyed by Australian workers will be at risk. And Labor is the party of the Australian worker, of working families, and the party that will take all necessary steps to protect Australian workers, jobs and wages and conditions. The construction industry is central to Australia's future, from delivering housing to building the infrastructure our economy depends on. To attract and retain workers, that industry must be safe, lawful and free from corruption, intimidation or criminal influence. When those standards are compromised, everyone loses, workers most of all. And we cannot afford to lose workers. In South Australia, my home state, we are building, building, building. The submarine construction yard at Osborne, the new Women's and Children's Hospital, the Torrens to Darlington Road project, record housing developments, particularly in the north and inner city. So we need construction workers, and we need good conditions for those workers. So the suggestion that Labor would turn a blind eye to corruption within a trade union, where the whole point of trade unions is to support workers, is plain wrong. That is also why strong TAFE and vet systems matter in this discussion. The people training the next generation of construction workers, apprentices, educators and supervisors need to operate in an industry that they can trust. When young people enter the system through TAFE or vocational training, they should see a sector defined by professionalism, safety and respect for the rule of law. A construction industry that is free from corruption supports better training outcomes, stronger workforce participation and greater confidence amongst educations and students alike. The challenges faced within parts of the CFMEU did not arise overnight, and addressing them requires more than rhetoric alone. It requires careful, sustained reform that strengthens lawful union functioning rather than undermining unionism itself. That is why our approach has focused on intervention and support not abandonment. The scheme of administration of the CFMEU's construction division is a clear example. It is a measured step to restore confidence, accountability and proper governance within the union. In a relatively short period, significant changes were made by the administrator, including staffing changes, the introduction of a national code of conduct, clearer expectations around behaviour and inquiries into state branches. These actions are about ensuring that the union can continue to represent its members effectively, lawfully and with public trust. So, rather than turning a blind eye, the government is taking a balanced approach, acknowledging the essential role of unions while acting responsibly to address misconduct, rebuild confidence and protect workers. That is not avoidance, that is responsible leadership.
Yeah.
Member for Mallee has the call.
Thank you, Deputy Speaker. Well, today shines a light on what so many Victorians have known for a very long time, that the Labor Party has worked with the unions, been paid by the unions and particularly exposes the corruption of the CFMEU. The investigative report is horrifying, to say the least, and I want to quote from The Age, Deputy Speaker, today, who have said, "Major infrastructure projects funded by the Albanese and Allen governments hosted drug trafficking, systemic corruption and bribery, bikie gangs and the shocking sexual exploitation of women at an estimated cost to the taxpayers of $15 billion, according to a landmark report into the CFMEU corruption. The bombshell release, and I have ended the quote, the bombshell release of an unredacted version of the report, Rotting from the Top, note the heading, by barrister and CFMEU investigator Geoffrey Watson SC into the CFMEU Victorian branch, where Labor has done nothing to address union corruption or organised crime, costing taxpayers an estimated $15 billion in Victoria's big build. Now, why is that a problem? Why is that a problem for every Victorian? Why is it a problem for every Australian? Because 15 and some other suggestions are that it could be up to $30 billion has been funnelled off into crime. That is outrageous. We are in a cost of living crisis. People are struggling to put food on their tables. They're struggling to turn their air conditioners on. Many won't turn their heaters on in winter. And yet here we have the Government of Australia, the Labor Party, turning the other way, only coming out and saying, well, you know, there's a problem. Really, there's been a problem since 2015 under John Setka, as if the Labor Party knew nothing about this. This is absolutely outrageous, and every person in Australia who is suffering under the cost of living ought to be appalled, because the corruption continues to bleed into this government, and the government must give answers. The government must give answers. And so far, we have seen nothing, no answers at all. Let me just pass on to the House and put on record, Victoria's debt at this point in time is $192 billion. Net debt, 30th of June, by 30th of June 2029. It equates to at least $22,000 per capita, per man, woman and child, at current levels rising to $25,500 by 2029. If you think it's bad now, folks, let's wait. Interest rates are at $18 million a day. Are you joking? Victorians should not have to put up with this. This is a government that is out of control in Victoria. The fact that the Labor Party have stood side by side with the CFMEU for so long boils my blood, if that isn't apparent, Deputy Speaker. It ought to boil the blood of every person in Australia, because every one of us suffers under this incompetence, and worse than that, the fact that women are being exploited on these sites and nothing was done. We have a government that is constantly lecturing us and a crossbench that is constantly lecturing us about kinder, gentler ways and nicer ways of speaking to one another. How about dealing with the corruption? How about dealing with the exploitation of women? This is outrageous, and every Australian ought to be offended at the behaviour of this government.
Member for Moore.
Thank you, Deputy Speaker. I rise to address this proposition directly. This government does not turn a blind eye to corruption in unions, in corporations or anywhere else. The rule of law in this country does not depend on ministerial preference. It depends on independent regulators, independent prosecutors and independent courts. Where there is unlawful conduct, it should be investigated and prosecuted. That is the position of this government. It is clear, it is consistent, it is not selective. But I did not realise when I came into this place as a Sparky turned lawyer, I would have to become an amateur historian to remind those opposite of their collective amnesia that history actually matters. For nearly a decade, those opposite presided over systematic wage theft across multiple industries: hospitality, retail, construction and franchising. Underpayment was exposed repeatedly. Large corporations admitted to shortchanging workers by millions of dollars, and then the penalty framework remained weak, enforcement under-resourced and criminalisation resisted. That was the blind eye, not to allegations but to structural exploitation. They resisted the Federal Anti-Corruption Commission for years. They argued against it, they delayed it, and then they diluted it. This government established the National Anti-Corruption Commission. We did so because integrity cannot be factional. It must be institutional. Yeah. The opposition's argument today implies that unions operate without oversight. That is demonstrably incorrect. Registered organisations are subject to strict financial reporting obligations, officer duties, audits and disclosure requirements under federal law. Breaches attract significant penalties. In many instances, penalties imposed on unions for industrial contraventions exceed those imposed on corporations for comparable regulatory breaches. That is not an argument for impunity, it is an argument about proportionality. The question is not whether misconduct should be sanctioned, it should. The question is whether one class of lawful organisation should be subject to extraordinary penalty settings while corporate misconduct that distorts markets and harms workers is treated as a compliance matter. During the previous government, industrial relations policy was framed not as economic management but as a cultural contest. Legislation such as the so-called Ensuring Integrity Bill sought to make deregistration of unions easier than the removal of corporate directors of serious misconduct. That was not a neutral integrity measure. It was targeted regulation. This government does not defend unlawful conduct. We defend consistent application of the law. The same job, same pay legislation is, to me, one of the greatest pieces of legislation this government has passed. When I was on the tools, I was building it up on a construction site up in the hills in Perth. We were building a crushing plant. There were 4 rates of pay for different Sparkies, what that saw was people just quit, and they wonder why the productivity was low under the previous regime. And we've criminalised deliberate wage theft because honest small businesses were being undercut by competitors who avoided paying lawful entitlements. We strengthen the enforcement so that those who do the right thing are not commercially disadvantaged. That is not turning a blind eye. That is correcting imbalance. The opposition's pattern is familiar. Amplify allegations in the Labor movement while remaining comparatively subdued about misconduct in the boardrooms. Integrity should not operate on a partisan bias. If corruption is the concern, then all corruption should be pursued, without favour, without political narrative and without selective outrage. This government supports independent regulators doing their job. We do not interfere in their investigations. We do not issue instructions about targets. That is precisely what integrity requires. The Australian people expect fairness and consistency. They expect that laws apply equally. We do not accept the proposition that equates that supporting the union movement is with excusing illegality. That is a false dichotomy. Unions are lawful institutions representing millions of Australians. They are regulated, they are accountable, and when individuals breach the law, they face consequences like anyone else. The opposition is entitled to prosecute political arguments, but is not entitled to rewrite its own record.
Member for Forrest.
Thanks, Deputy Speaker. And whilst it isn't always the crime that gets you, by golly, the cover-up always does. Isn't it amazing at the first rays of sunlight here on union corruption and the stench of its ties to the Labor Party that we see the cockroaches scampering for the corners, seeking refuge in the only place they know, and that's the dark shadows of the underworld in Victoria. Deputy Speaker, it is staggering to listen to the member for Moore speak of amnesia and selective amnesia whilst completely neglecting that the very first act of this government in terms of its industrial relations agenda was to defund and abolish the Australian Building and Corruption Commission, the very independent regulator that we put as a tough cop on the beat to address union corruption, to address the cost impacts that it has on the construction of literally everything in this country, from homes all the way through to the big build infrastructure projects that are the focus of this. Is this somehow a right-wing hit job? No. Let's go back through the very history of how Geoffrey Watson SC came to investigate these matters. This wasn't initiated by the Liberal Party. This was initiated by Zack Smith, the then National Secretary of the CFMEU, responding to unthinkable allegations made public by Nine Media. His report and 2 chapters of that report addressed some $15 billion of taxpayer money, worse than sprayed up against the wall, like the rest of the waste this government oversees, but funnelled to organised crime in this country. That, if the government was serious about addressing corruption and underworld criminality in this country, would be worth investigating. But no, instead we find the Minister for Industrial Relations, the Minister assisting the Prime Minister and this other cavalcade of Labor MPs come through here blustering about, this report, what report? It was not a report to government. I don't know about those 2 chapters. They do not want to know the answers to the very real questions that Australians need answered here. In fact, worse than that, the member for Perth crowed about some 121 members of the CFMEU that have been expelled from that organisation. In the context of some $15 billion of taxpayer money allegedly directed to underworld crime in Australia, that equates to some $124 million per one individual booted out of that union. If that stacks up to pass the pub test, then I have been drinking at the wrong establishments my entire life, Deputy Speaker. In fact, I look forward to tuning in to Tim TV. I'll be one of the first subscribers, provided that we get the possum hour, because what we got there for 10 minutes from the Minister assisting the Prime Minister was nothing short of rip-roaring comedy. The CFMEU Labor cartel has cost Victorians and indeed all Australians some $15 billion in money now. And the intriguing thing is just how much of it ends up back in Labor Party coffers. But of course, this is the sort of thing that a government that's committed to scrutiny, transparency, being the most open in history, wants nothing to do with. So that's why we saw the Prime Minister and the Minister for Workplace Relations shut down governmental or parliamentary scrutiny of that, because we understand now, in the face of these revelations today, that this corruption is systemic, it is endemic, and it is industrial in its scale. The Prime Minister said that the Labor Party wouldn't accept CFMEU donations, but we know that the AEC disclosures show just how often they've been cashing the cheques of their cartel mates. Minister Rishworth should release the full, unredacted report, including the 2 dirty chapters that nobody wants to talk about, or else risk being complicit in the cover-up on an industrial scale of corruption in this country. The millions of dollars of CFMEU donations to the Labor Party surely don't buy those sorts of policy outcomes. But I understand the pressure that must be brought to bear upon the minister because, I mean, you've even got the ALP president, Mr Wayne Swan, chairing CBUS linked to the CFMEU as an industry super fund. The rivers of gold between this corruption and the Labor Party deserve sunlight to disinfect them once and for all.
Member for Barton.
Thank you, Deputy Speaker. I note that Valentine's Day is coming up in a few days' time. Feeling a lot of love on this side of the chamber for our union movement and the great work, but on that side of the chamber, hearing the member for Goldstein talk about unions, particularly with this MPI today, is appalling. Clearly, he loves to hate on unions, and I think it's really important, Deputy Speaker, that I should highlight some other things in particular into embellishment of all the things that have been said today and also in question time. Corruption in any institution, whether it's unions, whether it's businesses, whatever it is, even in government, should be called out. And I think everyone on this side of the chamber believes that. It is important to highlight that because all unions, most unions, I should say, does amazing work to represent millions of workers in this country. This side of the chamber supports many things that have been passed in this new government, but also in the last term, particularly protecting our workers. Clearly, on the other side of the chamber does not support things like Priya's bill that we passed, penalty rates, secure work, and also equal same pay. These are really important things here that the union movement have been fighting for and that we have delivered in this side of the chamber. The Labor Party was born from the union movement. Again, I don't think we need to do a history lesson on this, but it's important to make sure that people in the community of Australia understand that the union movement has done a lot of work for our Australian people. No one on this side of the House supports misconduct. No one on this side of the House believes that what's happened with CFMEU is right. And we've done things. We've heard about it in question time today. I've heard it from my colleagues here today. No one is above scrutiny. No one is above the law. But what I will not accept is this deliberate conflation of what happened with the CFMEU with other unions, and I need to call that out, Deputy Speaker. That's right. Yeah. The other thing I want to also highlight in particular prior to question time, from the AFR live blog, Watson told the Queensland Commission of Inquiry he was absolutely appalled to see some calling for Irving's resignation today. He quotes, "If anything I've said here today would suggest that it's an outcome that should think again," Watson said. "They would be mad to get rid of Mark Irving." He said, "I might have said harsh things, they're my opinion, and Irving may have had another." Quote, "I've worked for Irving for 2 years now, and I've never met a more honest or decent man. I can tell you everything he did was opposed to the corruption and was in favour of fixing the CFMEU. I think that needs to be identified here today because I did listen to the contributions from the opposite and they don't want to face the facts. I just also want to reflect also on my experience, Deputy Speaker. I heard the member for Fisher indicated his experience, didn't hear about what he did in his time as a chippy, but as a union lawyer who's worked for the ETU, I've worked for the Nurses and Midwives Association, doing amazing work to support workers who have been underpaid, who've been working in unsafe conditions. And it's important to highlight that as well. During my time at the ETU, we did a lot of work, particularly during the time of the Royal Commission, to make sure we were doing the right thing, and which we did. Now, during their time in government, nothing came out of that, just a slap on the wrist. And now with a Albanese Labor government, more has been done. And I think I need to highlight that also. I wish the opposition had taken this more seriously. If the passion for asserting that, that the unions, that the government is turning a blind eye to the union corruption, I think it's also important that they are saying nothing about the significant underpayment that's occurring in the corporate world. And they should be taking that very seriously as well. Phoenixing as well, franchising as well. We heard it today. And I wish they could take that very seriously because they have not said anything about that in particular.
Give the call to the member for Monash.
Thank you, Madam Deputy Speaker.
something is rotten in the state of Victoria and it's starting to infect Labor federally. Something is rotten in the state of Victoria when you've got such a significant undermining of public confidence over a long period of time in public institutions, in government integrity, which has become so much worse under Daniel Andrews and since his tenure. And I only need to look at how state government ministers treat this issue. If I go back to September 25 last year, Australia's worst energy minister, Lily D'Ambrosio, was asked about an IBAC survey on the perception of corruption, and she waved reporters away and said, she was extremely flippant. She said she was more interested in community perceptions, but the reality was that nearly 90% of MPs in Victoria, in the Victorian State Parliament, were worried about corruption. A bit less than that for local government councillors. And that is one example of how prolific some of these issues are. Now, we're not talking about minor infractions here. We are dealing with some pretty profound issues. $15 billion didn't just vanish. It was siphoned off while the government looked the other way. We're talking about strippers being brought into a workplace. In what other workplace in Australia or office would that be acceptable? That's what's happening in Victoria. This is not incompetence, it's willful ignorance. I've read today about a contract that was taken out on the administrator when he was appointed. This is really serious stuff. We read about this sort of thing internationally. We like to think it doesn't happen here in Australia, but it does when it comes to the CFMEU, and it's allowed to flourish under a Labor federal government that is not prepared to toughen up and deal with it. We're talking about organised crime figures buying and selling workplace agreements. And every dollar lost, and I note that at the moment we're paying something like $500,000 a minute on government debt, but every dollar lost to corruption is a hospital bed not funded, is a road not fixed, is a school not repaired. But that's the Victorian government. That's Labor in Victoria, which has infected Labor federally. It's the standard that you choose to walk past. That's the same one that you choose to accept. And it's also impacting regional communities and small businesses. And I give you the example, Madam Deputy Speaker, my electorate of Monash, there are many family-run SME building businesses. They do a terrific job. They employ young people. They give tradies a go. We've got a wonderful local workforce. But so often I speak to them about skills and labour shortages, and these corruption issues in Melbourne that relate to the CFMEU have profound and ongoing and institutional consequences for the rest of the building sector, for small businesses who are expected to abide by a very high level of compliance and regulatory standards that clearly the CFMEU are not. And so there are some really profound flow-on impacts here. The member for Goldstein has done an outstanding job in holding a light to systemic corruption. The Age, which is not exactly the bastion of conservative publishing, has been like a dog with a bone on this issue, and I commend the bravery and the persistence of reporters like Nick McKenzie, because we need to get to the bottom of this. We need to see a report that is not redacted. If you are serious about standing up to corruption, putting out that report in full without bits and pieces taken out and redacted and blacked out, that's important. It's important to get to the bottom of why bikie gangs were running building sites. We need to know what is happening from here on in with that report, with cleaning up union corruption, with CFMEU donations to the Labor Party, because Australians deserve so much better.
Member for Bradton.
Thank you, Deputy Speaker. Well, on this side, we retain full confidence in the Administrator, respected King's Counsel, Mr Mark Irving. And can I just reinforce again, as my colleague did a moment ago, that the words of Geoffrey Watson KC, hardly a partisan figure. During the inquiry, after reading reports of coalition calls for the Administrator to resign, Mr Watson paused proceedings and said, "There's something I'd like to say," he tells the inquiry. "I might have said some harsh things here today, but in my opinion, I've never met a more honest and decent man. They'd be mad to get rid of Mark Irving." The Albanese government has acted decisively to stamp out corruption, criminality and violence within the CFMEU's construction division by placing it into administration legislation supported by the Coalition. These problems are deeply embedded in the industry. They didn't arise overnight, didn't just happen like that, and they won't be fixed overnight. Let's be honest about this. The disgraceful conduct outlined in the Watson report, commissioned by Mr Irving under our legislation, flourished under the Coalition and the ABCC. After a $61 million Royal Commission, the same leadership in Queensland, New South Wales and Victoria remained in place for nearly a decade. The ABCC issued fines. Judges said that those fines were ineffective. Geoffrey Watson found they were treated as a cost of doing business, even suggested breaching the law became part of the model. How many leaders did the Coalition remove? 0. Now compare that with what this government has achieved and what we've done. In August 24, the scheme of administration removed the entire elected leadership of the construction division across 6 jurisdictions, 270 union officers and 12 paid officials. Since then, more than 100 additional staff have been removed or have resigned, and the majority in leadership roles. Over half the organisers in Victoria are new, over 90% in New South Wales are new, and more than half in Queensland are new. Every individual named in the Watson report has been removed. This is action. And I say this as someone who has spent much of their working life in the union movement. Before entering this parliament, many years ago, before I was on the other side, I was an organiser for over 20 years and later secretary of the Australian Manufacturing Workers Union in Tasmania. I represented workers in factories, workshops and heavy industry, and I stood on picket lines. I negotiated enterprise agreements. I dealt with employers, regulators and governments of all persuasions. And I know the difference between strong representation and unlawful conduct. The overwhelming majority of union members are hard-working people who want safe workplaces, fair pay and dignity at work, but they also want hard-working, honest people representing them. Corruption does not protect workers. Criminality does not advance their interest. Violence does not strengthen unions. When I was a union organiser, my job was to lift standards, to ensure compliance with the law and improve safety and wages, not undermine the law. Cleaning up the construction industry is not anti-union, it's pro-worker. It's about restoring integrity so that members can have confidence in their representation and so that law-abiding businesses are not undercut. Under this administration, individuals who were fined for assault, illegal blockades, deplorable conduct and even bribery, people who were allowed to retain their roles under the Coalition and the ABCC, have been removed. And in just 18 months, the Administrator has achieved more than the Coalition and the failed ABCC did in a decade. But reform doesn't stop here. Following referrals from this government, regulators and law enforcement now have more than 100 investigations underway right across the construction industry. We know problems are not confined to one organisation. Employees and contractors also have responsibilities. That is why we established the National Construction Industry Forum, bringing together government, business and unions. It was unanimously endorsed as a blueprint for reform. Work is underway on a joint industry charter to lift behavioural standards across the sector, including procurement practices. This is serious structural reform. The Shadow Minister's attacks on the Administrator may make for headlines, but they do absolutely nothing to clean up the industry.
And this. To the member for Reid.
Audit, I present the committee's report 514, Inquiry into the Procurement of Mandated National Support and Advocacy Services for Victims of Child Sexual Abuse, and I ask leave of the House to make a short statement in connection with the report.
Is leave granted?
Leave is granted, Speaker.
Thank you. Member for Reid.
I present Report 514 of the Joint Committee of Public Accounts and Audit. The report examines the procurement processes used by the Attorney-General's Department to deliver 2 mandated child sexual abuse-related national services. These procurements arose directly from recommendations of the 2017 Royal Commission into Institutional Responses to Child Sexual Abuse. Recommendations that went to the heart of ensuring victims, survivors and their families receive timely, accessible and appropriate support. Given the significance and sensitivities of these services, the Australian National Audit Office conducted an audit of the procurements in 2024 to 25. The ANAO found that the processes did not involve open and effective competition, were subject to substantial delays, accepted non-compliant tenders for evaluation, failed to meet ethical standards, and did not achieve value for money. In particular, the audit identified that preferred tenderers failed to comply with mandatory pricing requirements at the request for tender stage. They were nonetheless evaluated and ultimately offered contracts. The evidence received by the Joint Committee throughout this inquiry was consistent with the ANAO's findings. Of particular concern to the committee were the significant delays. Although funding for these services was allocated in the 2021 to 22 budget, the market was not approached until late 2023. A contract for the National Offending Prevention Service was eventually executed in July 2025. However, negotiations for the service intended to support non-offending family members collapsed in October 2024. At the time of reporting, there remains uncertainty as to when or how that service will now be delivered. The committee notes that the Attorney-General's Department acknowledgement that while these procurements were complex, the processes were unacceptably slow. It is particularly troubling that the Attorney-General was not appropriately briefed on these delays and was only advised of anticipated timeframes in mid-2023. The Department has accepted all of the ANAO's findings and has indicated a willingness to learn from these failures and improve their future practice. While this is welcome, the committee is not yet persuaded that the Department is positioned to deliver the full suite of services required. This includes a nationally available information and referral service for victims and survivors, which remains under evaluation and was not examined as part of the ANAO audit. Accordingly, the committee makes 2 recommendations in Report 514. 1, that the Attorney-General's Department provide an immediate update on the status of these services. 2, that the Department report again within 6 months on its implementation on the ANAO's recommendations, including concrete examples drawn from ongoing and planned procurement activities. Before concluding, I acknowledge the Chair, the member for Macnamara, Deputy Chair Senator O'Sullivan, and members of the committee for their considered and diligent contributions to this inquiry. I would also like to thank the Australian National Audit Office and the Attorney-General's Department for their cooperation, and the Committee Secretariat for its continued professionalism and support. I commend the report to the House.
And I'm going to give the member for Reid. You have a section to read now. You're seeking leave of the House.
I ask leave of the House to present executive minutes on reports of the Joint Committee of Public Accounts and Audit.
Thank you. Is leave granted? You just have to...
Leave is granted.
Thank you very much. And member for Reid.
I present executive minutes on reports 502, 505, 506 and 512 of the Joint Committee of Public Accounts and Audit.
Thank you. Call on the clerk for the next item of business.
Government business, order of the day number 4, Defence and Veterans Service Commissioner Bill 2025, resumption of debate on the second reading.
Thank you. Just before I give you the call, I'll remind the House that before debate is resumed on this bill, I remind the House that it has been agreed that a general debate be allowed covering this bill and the Defence and Veterans Service Commissioner Consequential and Transitional Preventions Bill of 2025. The question for the House is that the bill be now read a second time, and I give the call to the member for Petrie in continuation.
Thank you, Deputy Speaker. The Commission will have a dedicated and sustained focus on suicide prevention. It will ensure that agencies responsible for implementing the Royal Commission's recommendations are held to account. It will promote long-term cultural and structural change and drive the reforms necessary to reduce the rates of suicide and suicidality among serving and ex-serving ADF members. To perform this role effectively, the Commission must have independence, functions and powers necessary to meet these objectives and to maintain the trust of defence and veteran community. That is precisely what this bill delivers. The Defence and Veterans Service Commission Bill builds on the work undertaken by the Parliament in February this year, when Schedule 9 of the Veterans Entitlement, Treatment and Support Simplification and Harmonisation Act 2025 was passed and subsequently examined through a Senate inquiry. The submissions, evidence and findings of that inquiry have directly informed the development of this bill. As a result, the government has implemented several key recommendations. First, the bill establishes standalone legislation for the Defence and Veterans Service Commission, reinforcing its independence and clarity of purpose. Second, the bill ensures that the functions of the Commissioner explicitly include reference to veterans' families. There is no doubt that the families of veterans play a vital role in supporting the health and well-being of our veterans. At the same time, they face unique challenges themselves. They are often carers, advocates and first responders, yet their voices are too often overlooked. Through this legislation, the Albanese government acknowledges the significance of veterans' families and recognises the meaningful system reform must consider the experiences and needs of the families alongside those who serve. Third, the Commission's functions and powers have been reviewed, and the proposed amendments arising from the inquiry process have been adopted. This bill strengthens the independence of the Commissioner and the Commissioner's powers to ensure accountability. It also works to access the information necessary to perform oversight functions effectively. It also expands the scope of witness protection, ensuring that individuals who provide information to the inquiry by the Commissioner are appropriately protected. This is essential to fostering trust, encouraging transparency and ensuring that people feel safe to come forward. This bill also improves transparency in the work of the Commission itself. It introduces statutory deadlines for the completion of 2 inquiries into the Commonwealth's implementation of the government's response to the Royal Commission's recommendations. Those deadlines are 2 December 2027 and 2 December 2030, marking the 3rd and the 6th anniversaries of the government's response. These statutory milestones are an important accountability mechanism. They ensure that progress is measured, reported on and subject to scrutiny over time. These provisions reflect a clear understanding that system reform is not a one-off exercise. It requires sustained attention, long-term oversight and a commitment to continuous improvement. The government has listened to feedback from stakeholders and has taken action. The changes contained in this bill ensure that the Commissioner has the tools necessary to enable the Commission to drive meaningful system reform to improve suicide prevention and wellbeing outcomes for serving and ex-serving members of the Australian Defence Force. Importantly, These reforms mean that agencies will be held accountable to consider and respond to the Commissioner's recommendations. And the enduring nature of the Commission ensures that the voices of veterans and their families continue to be heard, and that systemic issues contributing to suicide and poor wellbeing outcomes are continually reviewed and addressed. These provisions ensure continuity, legal clarity and smooth transition so that there is no disruption to the important work of the Commission. Taken together, these bills strengthen independence, enhance accountability, embed long-term oversight at the heart of the Defence and Veteran Support System. They honour the findings of the Royal Commission, respond to the Parliament's scrutiny and reflect the Government's commitment to listening, learning and acting. I want to finish by acknowledging the everyday heroes who work tirelessly to support veterans. The RSLs in my electorate are working tirelessly to support our veterans. I want to especially thank Rosemary, who tirelessly volunteers at the Redcliffe RSL. It's people like Rosemary who make all the difference, providing fierce support exactly where it's needed. On our end, the Government is getting on with the job of removing roadblocks for veterans so that they can access the services they need, the services they've earned and the services they deserve.
Thank you. So the question is that this bill be now read a second time. I'm giving the call to the Minister.
Thank you, Deputy Speaker. The Royal Commission into Defence and Veteran Suicide highlighted the devastating scale and impact of veteran suicide and made clear that this is a national tragedy that desperately needed to be addressed. That is why we've worked to implement the agreed recommendations of the Royal Commission as quickly as possible. In my address to the National Press Club on the one-year anniversary of the Government's response to the final report of the Royal Commission, I provided an update that 32 recommendations from the Royal Commission would be implemented by the end of 2025, and that we expected 2/3 of the agreed recommendations to be completed by the end of this year. The Royal Commission described Recommendation 122, the establishment of an independent oversight body, as its most important recommendation. In acknowledgement of the significance and urgency of this recommendation, in February 2025, the Albanese Labor Government legislated the creation of the Defence and Veterans Service Commission, and it has been up and running since the end of September 2025. The current enactment within Part 8E of the Defence Act 1903, by way of Schedule 9 of the Veterans Entitlement, Treatment and Support Simplification and Harmonisation Act 2025, passed the Parliament in February 2025, ensuring that the Commission would be up and running by September and not be subject to the vagaries of the intervening federal election. Noting the swift passage of this legislation, Government supported a Senate inquiry into this, enabling the defence and veteran community to provide feedback on Schedule 9, the establishment of this oversight body. These bills before us today are a direct result of that engagement and demonstrate our commitment to working with the defence and veteran community because we want to get this right. The bills address the first recommendation of the Senate inquiry by establishing standalone legislation for the Commission. The bills also add a specific reference to families as part of the Commissioner's function, strengthen the Commissioner's independence and powers, improve witness protections and increase transparency. The bill requires the Commission to evaluate and assess the effectiveness of the measures and actions taken to implement the government response to the Royal Commission into Defence and Veteran Suicide, first reporting on the 2nd of December 2027. This is in addition to other inquiries that may be undertaken by the Commission, including a recently announced inquiry into the implementation of the Government's response to recommendations 9 to 13 of the Royal Commission's interim report. The timeline for the first legislated inquiry will enable a proper consideration of our work and an opportunity to genuinely evaluate if the recommendations have been implemented appropriately and are making a difference for the defence and veteran community. I note that an amendment has been foreshadowed to bring forward the date of this first legislated inquiry. I note that these bills have been referred also to another Senate inquiry, which is the appropriate place to consider the first reporting date. I want to thank all those that have contributed to this debate and for your unwavering support of our veteran community. I note that across the chamber there's been bipartisan support for our veterans, as we would expect. with references to local bases in people's communities, their family connections to the defence and veteran community. And I'd like to particularly acknowledge the member for Gorton, who referred to her relative Hugo Throssell VC, after whom there is a bridge named after in my electorate. It's important to note that, contrary to some of the assertions, though, of the opposition during this debate, that this bill may be about a commissioner, but to be clear, it is about a commissioner and a commission that was envisaged by the Royal Commission. This is not some reheating of the previous government's proposal for a commission in an attempt to avoid holding the Royal Commission into defence and veteran suicide in the first place. This is quite different. I think it is also important to remind members of the House that the genesis of the legislation that established the Defence and Veterans Service Commission via the Vets Act amendment in Schedule 9 was based on very extensive consultation, despite what those opposite have said. There was a Royal Commission for 3 years that produced a detailed set of recommendations for the establishment of this commission, and that is what was reflected in that legislation, which we ensured was passed by this Parliament in early 2025 to make sure that the Commission could be up and running by September, as the Royal Commission asked for itself. That is what this government delivered. As I said last year in Parliament and at the National Press Club, it is our nation's duty to empower and support the mental health and wellbeing of our defence and veteran community to reduce the rates of suicide and suicidality as much as possible. The Commission is an integral part of this work and will ensure ongoing scrutiny of our efforts to achieve this aim, and I commend the bill to the House.
So the question is that the bill be now read a second time. I'm going to put that question. All those of that opinion say aye. Aye. To contrary, no. Ayes have it. I've received a message from... Sorry, I'll call on the clerk first.
Second reading, a bill for an act about the Defence and Veterans Service Commissioner and for related purposes.
I've received a message from Her Excellency the Governor-General recommending, in accordance with Section 56 of the Constitution, an appropriation for the purposes of this bill. I understand it's the House's wish to consider the bill in detail now, and I understand it's wished the House to take the bill as a whole. So the question is the bill be agreed to, and I give the call to the member for Herbert, Shadow Minister.
Thank you, Deputy Speaker. I move the amendment circulated in my name. The Coalition is moving an amendment to bring forward the timing of the first implementation review by the Commissioner. As currently drafted, the first assessment of the government's implementation of the Royal Commission recommendations is not required to be completed until December 2027. That means the report may not be tabled until 2028, almost 4 years after the Royal Commission reported. That is too slow and risks weakening accountability. Veterans and families were promised urgent reform, not delayed reporting. Independent oversight only works if it's timely and visible. Our amendment would require the first implementation assessment to be completed by no later than 30 September 2026. That timing is reasonable and practical. It marks 2 years since the Royal Commission's final report and 1 year since the Commissioner commenced operation. That is more than sufficient time to assess whether early stage of reforms are being delivered and whether government commitments are translating into action. Earlier reporting ensures veterans, families, Parliament can see measurable progress, not just promises. If the government is confident in its reform program, it should welcome earlier independent assessment. This amendment strengthens transparency and reinforces accountability. It does not change the Commissioner's independence of powers. The Coalition's objective is simple. Reforms recommended by the Royal Commission must be implemented quickly and assessed openly. I believe that it's in the best interest of the Parliament to accept this amendment, and it's in the best interest of our veterans. Many veterans will be tuning in and listening and watching what this Parliament is about to do. People have been waiting a long time for the National Commissioner to be up and running, to be running. It's the policy that we brought forward back in 2020 under the then Minister for Veterans Affairs, Darren Chester, who's in this place today. I believe that we want to work collaboratively with the government to make sure that we can get this implemented as quickly as possible, but also to make sure that the public, the community, veterans and their families can see what's happening, is it working, and hold the government accountable as they should. There is no veteran should die by suicide. No veteran. No families should be burying their loved ones. No wives, husbands, mothers, fathers and sons and daughters should lose their loved one back here on home soil. We owe it to them to work quickly. We owe it to them to make sure that we're implementing policies that give them the support and learn from the mistakes that have been made. And I don't think that any government, any colour of shirt at any time can put their hand up on hand on heart and say they've done everything to support our veterans. This is the opportunity. We need to move quickly. We shouldn't be burying our most bravest, and time to act is now.
The question is that the amendment be agreed to, and I call the Minister.
Thank you, Deputy Speaker, and I thank the member for Herbert for his remarks in relation to the amendment that he has moved. And I understand the opposition's desire and his desire to move the date of the first report of the Defence and Veterans Service Commission to an earlier time. In that regard, I note that 32 recommendations have already been implemented and 2/3 will be implemented by the end of 2026. And of course, work is ongoing in relation to the remainder of the Royal Commission's recommendations. The opposition's amendment, though, would see the Defence and Veterans Service Commission reporting in the middle of all of this work. Well, in addition, the Defence and Veterans Service Commission has already started its first inquiry looking into the implementation of recommendations 9 to 13 of the Royal Commission into Defence and Veteran Suicides interim report, which was about providing better information access, not only for veterans but also in particular for the families of those veterans who have taken their own lives. I think that the opposition's amendment is best considered, however, by the inquiry that has already been established in the Senate to look into this legislation. We will all then be able to best consider this proposal that is being put forward by the opposition in the context of that inquiry. And so, for that reason, at this time and in this place, the government will oppose the opposition's amendment as moved in the House.
Put the question. The question is that the amendment be agreed to. All the opinions say aye. Aye. Contrary, no. No.
Oh, the ayes have it. We've got them.
Ayes have it.
We've got them.
Is a division required? Division is required. Please ring the bells.
I'll just lock the doors now and we'll have them. Decisions are made by those who turn up, lock the doors now.
Got out of the place. So. Might close your card.
Lock the doors. The question is the amendment be agreed to. The ayes will pass to the right of the chair and no to the left. Appoint the honourable members for Capricornia and Bowman as tellers for the ayes, and the honourable members for Bean and Werriwa as tellers for the noes. The result of the division is ayes 47, noes 86. The matter was resolved in the negative. The question now is that this bill be agreed to. I'll put the question. Those opinions say aye. Against no. I think the ayes have it. This bill has been agreed to. I'll give the call to the Minister for Veterans Affairs and the Minister for Defence Personnel.
Thank you, Speaker. I ask leave of the House to move the third reading immediately. Phil, do you want to give me
Is leave granted? The member for Herbert. Leave has been granted by the member for Herbert. I'll give the call to the Minister.
Thank you, Speaker. I move that this bill be now read a third time.
I shall put the question. Those opinion say aye. Against no. I think the ayes have it. And I call the clerk.
Third reading, a bill for an act about the Defence and Veterans Service Commissioner and for related purposes.
Call the clerk.
Government Business Order of the Day number 5, Defence and Veterans Service Commissioner, Consequential and Transitional Provisions Bill 2025, resumption of debate on the second reading.
The question is that this bill be now read a second time. I'll put the question. Those opinions say aye. Against no. I think the ayes have it. I call the clerk.
Second reading, a bill for an act to deal with consequential and transitional matters arising from the enactment of the Defence and Veterans Service Commissioner Act 2025 and for related purposes.
I have received a message from Her Excellency the Governor-General recommending, in accordance with Section 56 of the Constitution, appropriation for the purposes of this bill. Is leave granted for the third reading to be moved immediately? The member for Right.
Leave is granted.
Leave is granted by the member for Right. The Minister has the call.
Thank you, Speaker. I move that this bill be now read a third time.
I'll put the question. Those opinions say aye. Against no. I think the ayes have it, and I call the clerk.
Third reading, a bill for an act to deal with consequential and transitional matters arising from the enactment of the Defence and Veterans Service Commissioner Act 2025 and for related purposes.
I call the clerk.
Government Business Order of the Day number 6, Treasury Laws Amendment Supporting Choice in Superannuation and Other Measures Bill 2025, resumption of debate on the second reading.
The question is that this bill be read a second time, and I give the call to the Honourable the Deputy Leader of the Opposition.
Thank you very much, Mr Speaker. I rise today to speak to the Treasury Laws Amendment Supporting Choice in Superannuation and Other Measures Bill of 2025. The Coalition supports many of the measures contained in this bill, and that is why this bill should never have been stitched together the way that it has been. Labor has effectively cobbled together a grab bag of largely unrelated measures and wrapped them up around a contentious measure, a measure that it knows the Coalition will oppose, and that is a change to superannuation, which restricts choice, reduces competition and rewards union-aligned industry funds. Labor has bundled together these various measures not because it makes good policy sense, but because it suits Labor politically. Labor is attempting to force a false choice on the Parliament: either support the entire bill and accept bad changes to super, or oppose the bill and be accused of blocking unrelated and sensible measures. That is not good lawmaking. It is old-fashioned wedge politics. And some wonder why trust in the political system is eroding. This typical Labor tactic puts politics above policy. Each schedule in this bill should stand on its own merits, or at least agreed non-controversial measures should be grouped together. But that degree of respect for the Parliament is something sorely missing under this Albanese Labor government. Labor has deliberately denied Parliament that opportunity. Because the Coalition supports some of the measures in this bill, while adamantly opposing others, I move the following amendment as circulated in my name. 1. The government has cynically cobbled together unrelated measures within this bill in an attempt to play wedge politics, not deliver policy outcomes. 2. The opposition is supportive of Schedules 3, 4 and 6, which deal with tax incentives for the Rugby World Cup, a tax treaty with Portugal and an increase in the wine equalisation tax producer rebate cap. 3. The opposition wishes to see the smooth passage of Schedules 3, 4 and 6 and are willing to work with the government on these uncontroversial aspects. And 4. The opposition has serious concerns about Schedules 1 and 2 of the bill, which will ultimately restrict choice in superannuation. The bill contains 6 schedules, most of which are broadly uncontroversial. Schedules dealing with an international tax treaty, sporting event tax exemptions and support for the wine sector are measures the Coalition has supported in the past and continues to support. Schedule 3, for example, implements income tax exemptions associated with the Rugby World Cup to attract that major sporting event. This is standard practice for major international events like this and mirrors concessions provided under previous Coalition governments. Schedule 4 gives domestic effect to the Australia-Portugal tax treaty. This is a routine and sensible measure and it has our support. Schedule 5, which deals with Labor's priorities in regards to retaining, providing or removing DGR status for various organisations, requires further scrutiny, and this will be done by the Senate Economics Legislation Committee, to which this bill has been referred. Schedule 6 increases the wine equalisation tax producer rebate cap, delivering much-needed support to Australian wine producers. We support this. Deputy Speaker, the problem is Labor has cynically bundled these schedules together with a very contentious superannuation measure. In fact, that measure goes across 2 schedules, Schedule 1 and Schedule 2, and of course there's further work that is needed in the DGR-related schedule. Schedule 1 in and of itself is largely mechanical, but paired with Schedule 2 amounts to an egregious intervention into the superannuation sector. Australians now have more than $4 trillion saved for retirement and superannuation, and that figure is on track to reach $5 trillion by the end of the decade. That capital does not just fund dignified retirements, it underpins investment opportunities to help maximise returns for hard-working Australian workers. But the system will only be sustainable if people trust it. Trust that is managed solely in members' financial interests, and trust that governments will not retreat from respecting that primary objective of maximising returns for superannuation holders. Trust that governments also will not treat superannuation as a political plaything, as a piggy bank to fund the government's priorities. The Coalition understands this instinctively. Superannuation is part of a worker's pay. It is not a gift. It is not a bonus. It is money earned by and owed to Australians. Labor, on the other hand, does not understand this instinctively. Labor sees super differently. Labor increasingly treats super as a pool of capital it can direct, constrain or tax for its own political purposes. And this bill is part of that long-standing pattern. Rather than strengthening competition and empowering Australian workers, Labor is narrowing the ways Australians can engage with our own super. Rather than trusting Australians to make informed choices, Labor wants to make the choice for them. That does not strengthen the super system. It weakens it. It doesn't strengthen trust. It erodes it. We see Labor's approach to super in Schedule 2 of this bill. Schedule 2 is described by Labor as supporting choice in superannuation, an Orwellian description, if there ever has been one. A ban on advertising does not support choice. By definition, it limits choice. From the 1st of July 2026, many superannuation products will be prohibited from being advertised to employees during their onboarding into a new job, the very moment when workers are most engaged and most likely to actively consider their super. On the surface, this might appear benign, but scratch a little deeper and a familiar pattern emerges. This is not about empowering Australians. It is about steering them into choices Labor wants to make on their behalf. Labor claims this change will prevent workers being pushed into poor-performing funds. But Australia already has a world-leading performance test regime that weeds out underperforming products. As the Financial Services Council has made clear, this measure inherently benefits industry super funds at the expense of non-default, non-industry and alternative products. Union-backed industry super funds already dominate default arrangements. Retail funds and other competitors are structurally disadvantaged. Competition is increasing in Australia's super sector, and this is causing the large union-backed industry super funds significant heartache as Australians exercise their right to move their own money to a fund of their choosing. Recent reports suggest that 1 million Australians switched super providers last year, representing around $150 million of super switching every single day. Retail funds are large beneficiaries of super switching. At a time when Australians are actively re-engaging with their super, Labor is proposing to close off avenues for comparison and engagement. That is not accidental. The sector has also raised serious concerns about implementation. Payroll and onboarding providers have been clear that sequencing stapled fund information ahead of permitted advertising is not as straightforward as it may seem. Yet the regulatory detail will not be released until after this bill becomes law. Meanwhile, major platforms such as MYOB and Employment Hero have warned that systems are not ready. Once again, Labor is legislating first and thinking later. This bill forms part of a broader pattern by Labor which favours union-backed industry super funds at every opportunity and, despite its rhetoric, is weakening super, not strengthening it. You only need to consider other recent measures of Labor's which put the Labor government and their interests at the centre of the system instead of the interests of everyday Australian superannuants. Measures such as forcing mandatory cooling-off periods to advantage industry funds and tweaking the performance test to direct capital where government wants it to go. And all of this spells bad news for average Australian superannuants. Less choice, less competition, more government control, more power concentrated in union-backed industry funds aligned with Labor, more uncertainty for Australians planning their retirement. Under Labor's approach, trust is not lost in a single moment, but it is chipped away at. This bill is yet another chip. It's worth noting that all of this sits within a broader context of Labor's ongoing obsession with taxing superannuation. Labor's Super Tax 1.0 was one of the most reckless tax proposals ever put forward. Its most egregious feature was the indexation of a tax on unrealised capital gains. Taxing unrealised capital gains on non-indexed balances was economic lunacy, and morally it was wrong, especially given the impact it would have had on younger Australians in particular, the older they grow. That proposal punished aspiration and severely undermined confidence in the future of superannuation. The Treasurer was forced into retreat, and Super Tax 1.0 was no more. Very quickly, though, he started working on Super Tax 2.0. In fact, he brought it into the Parliament today. It's interesting that Labor is so interested in tax, and I think most economic commentators around the country understand why. In fact, they're just trying to paper over what is the highest spending government in the last 40 years outside of pandemic. Now, the Treasurer's own budget papers show he's injecting into the economy a volume of fiscal stimulus equivalent to Labor's stimulus during the GFC. The Treasurer needs to find a way to pay for all of this spending. Debt is to hit $1 trillion over the next few months. Australian workers are already paying an extra $4,000 in personal income taxes under this government. And so the Treasurer is looking everywhere, in each cupboard, behind each cushion on the couch, to find more money. And thus they come after people's retirement savings. They come after superannuation. And that is the context within which this bill is being debated. The Coalition rejects this approach. We believe in encouraging aspiration, not taxing it. We believe in growing the economic pie, not slicing up an increasingly shrinking economic pie. We believe in Australians. We believe superannuation money is their money, and we will not turn from that view. Thank you, Deputy Speaker.
Is the amendment second?
I second the amendment and I reserve my right to speak.
The original question was that this bill be now read a second time. To this, the honourable member for Fairfax has moved an amendment that all words after that be omitted with a view to substituting other words. The question now is that the amendment be agreed to, and I call the member for Maribyrnong.
Thank you, Deputy Speaker. Former Prime Minister and the architect of superannuation, Paul Keating, once said, "Superannuation was always about more than just a savings account. It was about the democratisation of capital, giving every worker a stake in the wealth of the nation they are building." I see the weight of that promise every time I walk down Union Road or Puckle Street, or when I'm visiting local businesses in Essendon Fields. Because when we talk about Treasury laws and schedules, what we are really talking about is what we're really talking about is that stake in the nation. We're talking about the promise that a lifetime of work in Maribyrnong and across the country, whether you're a teacher in Keilor East or a nurse in Glenroy or a retail worker in Kensington, will lead to a retirement where you aren't just surviving, you're thriving. In my time as an advocate for working people, I've spoken with parents and workers where the conversation isn't about global tax conventions, it's about the what-ifs. What if I haven't saved enough? What if my super is being eaten away by fees? The bill before us today is this government's answer. We are delivering this alongside our landmark payday super legislation. Payday super is a once-in-a-generation reform to fix a massive integrity gap. The ATO estimates $5.2 billion in super when unpaid in 21-22. That is $100 million every week that workers earned but never received. For a 34-year-old in my electorate, failing to recover these missing funds could reduce their retirement nest egg by $32,000. This bill ensures the system works for you and not the other way around. And today, we've introduced additional changes that will make super even fairer from top to bottom and more sustainable in the long term. These changes will make a significant difference to low-income workers in my electorate, boosting their super and giving them a better retirement. But let's go back to the first day of your new job. We've all been there. The nerves, the excitement and the stack of paperwork. Often digital these days, but that sits between you and your first shift. It's a moment of transition, and for many, it's a moment of vulnerability. Schedule 1 and Schedule 2 of this bill focus squarely on this moment. Currently, the onboarding process is a bit of a minefield. A worker starts a new job and in the rush to get their payroll details sorted, they inadvertently open a new superannuation account. They didn't mean to. They already had a fund that they'd been contributing to for sometimes years. But the system wasn't designed to show them that their stapled fund, the one that belongs to them, at the right time. By streamlining the choice of fund process, we are ensuring that a worker's existing fund is visible and accessible from day one. This isn't just about tidying up paperwork, it's about stopping the silent thief of duplicate fees. In my community, we have a high population of young workers and people in the gig economy who move between jobs frequently. If they open a new account every time they start a new contract, they are paying double, triple or quadruple administration fees and insurance premiums. For a young person in Moonee Ponds, losing just $100 a year to unnecessary fees can result in thousands of dollars lost by retirement. From 1 July 2026, we are fixing this. We are making sure your super follows you and so your savings stay in your pocket. Further to this, Schedule 2 introduces a ban that is long overdue. For too long, some onboarding software providers have treated a new employee's first day as an advertising opportunity. They've been paid to push specific super products, often ones that are more profitable for the provider than they are for the worker. When you're starting a new job, you should be focused on your new responsibilities and your new team. You shouldn't be pressured into a financial decision by a pop-up ad on a payroll app. This bill creates a safe zone for onboarding. It ensures that the information workers see is regulated, transparent and focused on their best interests, not on someone's commission. We are keeping the focus on My Super products, the gold standard of regulated, high-performing funds, and ensuring that if an advertisement does appear under the strict exceptions we've carved out, it is accompanied by clear, unambiguous disclosures. This is about honesty. It is about ensuring that the choice a worker makes is an informed one, not one they're pushed into. Deputy Speaker, I represent communities that are outward-looking, that we are home to people from every corner of the globe, and our local economy is increasingly connected to international markets. That is why Schedule 4, the tax convention with Portugal, is more than just a diplomatic formality. It's a bridge. This is our first ever tax treaty with Portugal, and it will be our 47th overall. For the local businesses in my community looking to innovate, this treaty and others like it removes the hurdles. By reducing withholding tax rates on dividends, interest and royalties, we are making it cheaper for Australian businesses to access Portuguese capital and technology. We are also ensuring that people who earn income in both countries aren't being taxed twice on the same dollar. It's about fairness and it's about making Australia an attractive place for the kind of investment that creates jobs in the northwestern suburbs of Melbourne that I represent. But it also has a tough on tax edge. This treaty strengthens our ability to fight tax evasion. It allows tax authorities to exchange information and assist in collecting debts. It's a clear message from this government that if you do business here, you play by our rules and you pay your fair share. Now, Deputy Speaker, I want to turn to Schedule 3, and I must admit, at first glance, it feels a little bit odd, the odd one out in a Treasury bill. We are debating the mechanics of superannuation and international tax treaties, and suddenly we find ourselves talking about scrums and lineouts. It's a bit weird to see the Rugby World Cup sitting alongside superannuation. But there is a very serious reason it is here. When we bid for major international events like the 2027 Men's and 2029 Women's Rugby World Cups, we make promises to the world. We promise that Australia is a professional, reliable and welcoming host. Part of that entry price for hosting global tournaments involves providing targeted tax exemptions for the organisers. While it might seem like a strange inclusion in this specific debate, it is about the economic livelihood of our cities. In Melbourne, sport is its own religion. We are the sporting capital of the country. We know that a major sporting event brings the benefits that ripple out far beyond the stadium. It's the extra shifts for the casual workers at our local bars. It's the bookings for our small transport companies. It's the tourism dollars that help our suburban cafes thrive. Most importantly for me, it's about legacy. I think of the young girls playing playing at local clubs in Melbourne today. When they see the world's best athletes competing here in 2029, they won't just be watching a game, they'll be seeing a future. So yes, while it's a bit of a legislative sidestep to talk about rugby in a superannuation bill, it's a necessary one to ensure we remain a top-tier destination for the major events that inspire our kids and boost our local economy. Schedule 5 deals with deductible gift recipient status, and this is where the bill truly touches the heart of my electorate. The not-for-profit sector is the backbone of our community. When the government can't be there, these organisations are there supporting the vulnerable, protecting our heritage and advocating for change. Throughout my career, I have seen the incredible power of people coming together to demand better, a better future for them and their communities. Whether it's advocating for better education, providing crisis support or championing equality, these organisations need every bit of support they can get. By granting DGR status, we are making it easier for everyday Australians to donate, knowing that their contribution is tax deductible. We are supporting the helpers. From the restoration of St Patrick's Cathedral to the advocacy of Equality Australia, we are ensuring that the diversity of our community's interests is reflected in our tax system. The removal of certain listings is also a necessary part of this process, ensuring that the system maintains its integrity and that tax concessions are only flowing to those who are actively delivering for the community. These groups are doing the heavy lifting in our civil society, and they deserve a tax system that encourages rather than hinders their growth. Finally, Schedule 6 looks at our wine industry. Now, Deputy Speaker, I'll be the first to admit that you won't find many vineyards in the middle of Maribyrnong. I've checked. I've been up and down Maribyrnong River, and I can confirm we are definitely not. We're definitely more of a suburban sprawl than a Shiraz soil. But while we aren't trading the grapes in the northwest, we are the ones that move them. Our logistics hubs and transport workers rely on a thriving wine sector. This bill increases the wet rebate cap to $400,000 to give producers breathing room. This complements our broader support, including the increase to the excise remissions scheme cap and our 2-year draft beer freeze to ease pressure on local pubs and clubs. Those opposite, when they aren't fighting with each other, spend their time claiming to be the champions of the regions. Yet they have left our wine producers struggling under outdated cap and trade doors that were slammed shut.
Shame.
They talk a big game, but it takes a Labor government to actually deliver the practical tax relief and trade partnerships that keeps family vineyards viable and our local supply chains moving. Deputy Speaker, this bill doesn't reinvent the wheel. It ensures the wheel is turning for the worker. When we came to office, we inherited huge deficits and $1 trillion worth of Liberal debt. We know Australians are under pressure, which is why we're delivering 2 more tax cuts for every single taxpayer. The fundamental divide in this place is clear. While Labor protects the worker, those opposite still treat retirement savings like a political piggy bank. After a decade of delaying the super guarantee, they now want to raid the nest eggs of young Australians for housing, forcing the next generation to choose between a roof today or poverty tomorrow. They remain the party of no, stuck in a worldview where the only way for a young person to get ahead is to rob themselves of their own future dignity. We are choosing action over obstruction. When the people of Maribyrnong go to work tomorrow, I want them to know that we are in their corner, ensuring that the system rewards their hard work. I commend the bill to the House.
The original question was that the bill be now read a second time. To this, the honourable member for Fairfax has moved an amendment that all the words after that be omitted with a view to substituting other words. The question now is that the amendment be agreed to, and I call the member for Casey. I now call the member for Goldstein.
Well, thank you, Deputy Speaker. And Deputy Speaker, I am under no illusion that I am an inadequate replacement for the member for Casey. However, in the spirit in which he has appeared in the chamber, I am honoured to nonetheless follow him. It's important to speak on this piece of legislation because the Labor Party wants this legislation to be about the issue of somehow making the case that they're being generous on the issue of superannuation. But let's be very clear about this, Deputy Speaker. This bill, as an omnibus bill, is running about 10 different agendas under the banner of thinking that it is justified because it has the word superannuation in it. Now, there is a component in this legislation where the government is saying they're supporting superannuation choice. The problem is it isn't the choice of Australians. It's the choice of the fund managers. Because today the modern Labor Party is not a party of organised workers, it is a party for organised capital, where they seek to entrench the vested interests of industry funds, and particularly the fund managers who profiteer and take from people's retirement savings so they can take that money, funnel, siphon, launder, wash, whatever word you want to use, to pass it on through kickbacks through to the Australian Labor Party and its campaign coffers, that of the trade union movement. The bigger the volume of money, the more they can just shave money off the top and use it towards ill-gotten and corrupt gains. So that is the basis in which this legislation is put before this parliament. It's a way to maximise the revenue in the funds they control. It's a way to maximise their grab, their take and their pathway to get money into the kickback cartel cycle of life, to provide the liquidity for the modern Labor Party to campaign so they can sit in office. You just need to understand, Deputy Speaker, how the cartel kickback circle of life works. You have the trade union movement that takes money from workers' wages. They then, through law, compel people to be in funds that they control. They then campaign and fund the Labor Party to sit on the Treasury benches. Once they're on the Treasury benches, they try and take as much money from Australian workers' wages and force it into funds that they control, and then use that money to launder it, to drive it through marketing mechanisms or whatever it is, so that it goes back into the campaign coffers of the Australian Labor Party to keep them entrenched. They always want to take more Australians' money because what they want to do is control Australians. And at a state level, state Labor governments propose projects. Those projects are then used to siphon money and raise the expectations of taking money from people's superannuation funds again, so that the beneficiaries can be those who are members of the unions. It's the cartel kickback circle of life. And where has it been enlivened more than the CFMEU? And we found out all about that today between what's going on in the Wood inquiry in Queensland, which has directly exposed the CFMEU Labor Party cartel of corruption. We have the problems of what's being voiced in Senate estimates today, what's been going on in, of course, the Queensland Parliament, the scrutiny today, and, of course, the non-answers that the minister has provided in the House of Representatives today, because she won't give simple bits of information like whether she requested reports from the CFMEU administrator and the allegations of corruption in the CFMEU, or a choice of willful blindness because she didn't want to see corruption, didn't want to hear corruption, because then she wouldn't be accountable for the corruption. And then, of course, she won't even reveal to this place the report that she was handed by the CFMEU administrator. The Labor Party oversees the cartel kickback corruption cycle of life, where they take Australian workers' money, they shove it in funds, those funds then finance projects where they can skive money off the side, and then they also make sure that that funding is then used to marketing expenses to ensure that Labor stays in government. Literally, the mafia could not have designed a scheme as sophisticated and sanctioned in law as has been done by the modern Labor Party. And Australians are the one who pays. And any time there is a threat to the power structures that sit behind the cartel kickback circle of life, they will fight endlessly to keep it in place. Because if they don't, they know the revenue sources they need to sit on the Treasury benches dries up. But more important than that, they will then go on and have to make justification on democratic grounds why they should be able to legislate their agenda. Labor doesn't represent organised workers anymore. It hasn't represented them for a long time. It represents the people who work for the public sector and how much they can extract from the taxpayer. And the other thing they represent is organised capital, and they try and push as much money into that system. And you see, no matter how many times the facts are put out there, they won't accept that they're taking too much of Australians' money. Think about the absurdity, Deputy Speaker, of the situation we now face. The retirement income system has three pillars. The first pillar is home ownership. The second pillar is retirement savings through a retirement savings scheme, superannuation. The third pillar is pensions, which are publicly available to those who need it. 93% of people's principal today when they die is left in their superannuation. People have more super than they need to retire with dignity, and they're passing on with nearly their total principal intact. That says to me we have our priorities wrong when young Australians cannot afford to get into the property market and increasingly have huge volumes of savings available at their disposal to get into the market earlier and cheaper. But the Labor Party never wants you to be able to, Australians, to access that money, because if they do and they start putting their own interests for their working life and retirement for home ownership first, they will become far more independent through their working life and retirement. Instead, the Labor vision has become this sick joke where young Australians can't afford to buy their first home, and they're increasingly trending towards having a mortgage at the point of retirement, where they're able over many years to garnish off people's superannuation funds as much money to feed the cartel kickback circle of life that they are beneficiaries of. It is a perversion, Deputy Speaker, of the best interests of Australians, all done under the annex of claiming virtue, but they are directly assaulting the pathway for young Australians to be able to own their own home. If you had have said to anybody before 1992, do you think it is logical to buy your home first before you focus on your retirement? Everybody would say, if you didn't think that, you need your head read. Well, what this government has done and what successive Labor governments have done is prioritise the size of somebody's 67th birthday cake over whether they can buy a home earlier, younger and cheaper. And they are paying the price. Worst, it affects women who desperately want to get ahead and be independent, particularly those who are post-divorce, young Australians, and frankly, it corrodes the very basis of the Australian aspiration and the Australian dream for home ownership. But that's fine for modern Labor, because for them, it means that they get to control your life. It means that increasingly they want superannuation funds to become the new fundy feudal lords, to buy the houses and build the houses to rent for you for life. The idea, the sick idea, and it is sick, that they would deny young Australians a pathway to be able to buy their home earlier and cheaper with their own savings. But they're quite happy for those funds where those savings are held to go and build and buy housing, to rent back to those young Australians who can't get into the property market, is a complete perversion and a deliberate act of economic social engineering to try and turn Australian society on its head. The debate around housing has always been central to the type of country that we want to be. Australia has always been a land of great promise where young Australians can go on, if they work hard, save and sacrifice, are in a position to go on and buy their first home. And this is not just some sort of economic idea, it is fundamentally central to the type of nation we are. Because when people own their own home, they're in a position to be more financially independent, they're more likely to be able to form a family and support them, and be in a position to have the foundations and pillars for retirement security. At every stage of life, if you buy your home earlier and cheaper, you will be in a stronger and better position, not just to save on rent, but to then go on and build the foundations of the success of a life, to be confident in doing things like becoming self-employed or setting up a small business. But Labor has turned around and torn that social contract up and said, we know how to run your life better. We know how to design the rules and regulations so that it benefits our mates over you. And more importantly, they're increasingly rigging the structure of the Australian economy to benefit themselves. It is the very model of corruption that we should be seeking to expose, and the unions and industry funds are there actively ensuring that it is perpetuated. And of course, every member of the Labor Party in some way is a direct beneficiary of the cartel kickback circle of life. Because if they sit on those Treasury benches, they sit on the Treasury benches because the financing of the campaign increasingly comes from Australians' retirement funds, where they are shaved off They are laundered all the way through the system under the banner of marketing expenses to the point where they end up in the campaign coffers of the Australian Labor Party. So when this government says and extols the virtues of this bill, what they are extolling is the virtues, and I can assure you it is not a virtue, but they are extolling the argument for their cartel kickback circle of life, where private funds for retirement security for millions of Australians find their way laundered into the campaign coffers of the Australian Labor Party. And any pathway that frees people up to take control of their funds through self-managed superannuation funds, they seek to shut down. You just need to look at how the Assistant Treasurer right now is making the case for why self-managed superannuation funds who aren't exposed or don't create the consequences of the compensation scheme of last resort is deliberately, maliciously targeting self-managed superannuation funds, just like they did with the retiree tax on refundable franking credits, just like they wanted to do on their proposed unrealised capital gains tax. Every avenue they have to attack self-managed superannuation funds, they will absolutely take, because they want Australians to take their money out of SMSFs and they want to put them in the industry funds that they can then control. Because when they do that, they don't just control your retirement, they control your working life, and they are trying to undermine that sense of and spirit of independence that has made this country great. And more importantly, the trade union movement, and particularly the CFMEU, particularly the corrupt CFMEU, is one of the entities that gets the biggest beneficiaries of this cartel kickback circle of life. Because when the CFMEU gets control of Australians' money, we know, and we now know from public reports that have been tabled in the Wood Inquiry. The Wood Inquiry shows it's used to sanction and perpetuate violence, harassment of women, the demonisation of people who are prepared to stand up. So absolutely we oppose this corruption, and what's scandalous is that this Labor government runs interference when we do simple things like try and table a report into CFMEU corruption in this parliament, as happened by the Leader of the House before question time. There is a time where good people, I would hope of decency, are prepared to stand up and call out the behaviour of this Labor government and the correlation of their behaviour and what they have engaged with, because sitting behind it is a fundamental compromise situation where the Labor Party is actively participating in a deeply distrustful and deeply dishonest range of conduct for which every Australian is paying. Thank you, Deputy Speaker.
The member for Moreton.
Thank you, Deputy Speaker. And Deputy Speaker, listening to the member for Goldstein talk against this motion, talk against a motion targeted at superannuation reform, reminds me of something very important, and that is that the more things change, the more they stay the same. And it reminds me of that because when I think back on the history of superannuation, my mind goes back to what happened when the first superannuation guarantee was put through this place in the early 90s. And what did those opposites say then? They said that we'd all be ruined. They said that it'd be a disaster for the economy. They said that it wouldn't work. They called it an extra tax when the proposal was for a 3% contribution from employers. And Deputy Speaker, can I say that things have not changed? And they haven't changed because what we know is that just like then, this is a coalition that doesn't back in workers and does not back in superannuation, as we see from the member for Goldstein's debate today. And Deputy Speaker, not only was that the case, he was also incredibly disingenuous in talking about housing. Because if you want to talk about housing and if you want to understand what people need when it comes to getting more young people into homes, when it comes to making sure that parents can have the confidence that their children are going to be able to secure a home and live in their own home to build for their future, we need to remember what those opposite have said and done when it comes to housing. They have said that a 5% deposit is not something they'd support. And so what we need to know from the coalition is who are the people who are not going to get a house because they don't support that policy. What we know from the coalition is that they didn't build a single social housing home. And what we know about the Coalition is that they did not have a housing minister for the majority of their last term. And so, Deputy Speaker, when the member for Goldstein stands here today and talks today, not content with the will they, won't they, on again, off again, the relentless feudal infighting that subsumes everything those opposite do, he had to squeeze in a discussion to vote against, to try and amend, to not support the reforms in superannuation that this Albanese government is putting forward today. And Deputy Speaker, I am always pleased to have the opportunity to talk about superannuation, a proud Labor initiative and a proud Labor legacy which enables Australians to fund dignified and independent retirements. And of course, that superannuation guarantee that was first enacted in this parliament in 1992 under the Keating Labor government was established because Labor took a long-term, responsible view of Australia's future, recognising that an ageing population would place a burden on the federal budget without a scheme to support everyday Australians. And the idea behind super, it's really straightforward. It is compulsory long-term savings where your employer has to kick in. 34 years on, Australia's super system stands as one of our greatest national achievements. It is the envy of the world, and it has delivered stronger, safer, and more prosperous retirements for Australians. And Deputy Speaker, when we talk about superannuation, we don't want to leave it where it is. Because when you believe in something and when you back something, you always want to make it better. And that's what this bill does. And not just this bill, but we heard from the Treasurer this morning about reforms to the Listo, changes to increase the maximum payment, changes to raise the income threshold, making sure that some of our lowest income Australians and some of our most vulnerable have the support that they need to offset and to make their lives better. It has strengthened Australia's retirement income system, provided workers with peace of mind about their future, and acted as a vital partner to the age pension. Beyond its social benefits, super has also become an economic powerhouse, fuelling national growth through major investments in infrastructure, in housing, in innovation and productive enterprises. These investments help underpin the resilience of the Australian economy and, crucially, ensure that working people share in the wealth they help create. Its establishment sits alongside other transformative public policy reform such as Medicare, the PBS and the NDIS, which are also Labor government initiatives. And it shows what this government's priorities are. It shows what Labor's priorities are: people. The Treasury Laws Amendment supporting choice in superannuation and other measures Bill 2025 before the House today strengthens the superannuation system through a series of schedules. Some employees have stapled super funds, and these are funds which are linked or stapled to an individual employee as they move jobs. The first schedule of this bill amends the Superannuation Guarantee Administration Act 1992. It will enable people with a stapled fund to more easily see their existing fund when they change employment and make an informed choice about using it. This more streamlined approach will mean less duplication of super accounts and less people's hard-earned money going into super fund fees. This amendment gives employers more flexibility to request an employee's stapled super fund details from the ATO earlier in the onboarding process. This enables more efficient implementation of payday super. And payday super is Labor's legislation which comes into effect on the 1st of July this year and requires employers to pay super at the same time they pay wages. Not quarterly, not later, but on payday. And Deputy Speaker, this is because super isn't a privilege. Super isn't a bonus. Super is not an extra. Super is wages, and they deserve to be paid when they are earned. As the CEO of the Association of Super Funds of Australia, Mary Delahunty, says the approach in the bill strikes a balance between maximising member choice, ensuring workers are presented with options, and knowing that they are in the best performing product for them, while continuing to ensure that the number of Australians with more than one super account continues to reduce. Schedule 2 amends the Corporations Act and implements a targeted ban on superannuation advertising during the employee onboarding process. This is an important time for new employees, and they should be able to consider their super options in a well-informed and non-pressured and clear way without being hit with sales pitches or feeling compelled to choose a particular product. Deputy Speaker, I spent my younger years cutting my teeth supporting and representing manufacturing workers. And the time for workers to understand their superannuation entitlements is at the beginning. It's not when you've suffered an injury. It's not when your loved one is sick. And that's what this legislation is focused on. To keep things practical, there are a few sensible exceptions. Workers will still be able to see information about their stapled fund, their employer's default fund, or any regulated MySuper product. These exceptions make sure that people still get the key details they need, but without turning the onboarding process into a marketing exercise. This amendment ensures the process is less overwhelming for workers and keeps the focus on transparency and genuine choice rather than advertising. Deputy Speaker, the remaining schedules in this bill concern a range of matters. The first fulfils an obligation to the World Rugby as part of Australia's forthcoming hosting duties in the 27, 20 and 29 Rugby World Cups, and it follows similar exemptions which were provided for the 2023 FIFA Women's World Cup and the 2020 ICC T20 World Cup. The schedule implements amendments to the Income Tax Assessment Act and the Income Tax Assessment Act of 1997 to provide an income tax and withholding tax exemptions for World Rugby and its wholly owned subsidiaries. And these measures bolster Australia's reputation as a trusted host for major international sporting events, events that generate jobs, events that promote tourism and lead to long-term social benefits such as increased participation in sport. These are events that not only drive economic growth and drive good full employment, they also bring our communities together. Schedule 4 of this bill amends the International Tax Agreements Act and concerns the 30th of November 2023 tax convention between Australia and Portugal. And this convention is the first agreement of its kind between Australia and Portugal and will promote stronger trade, investment and indeed innovation connections. It encourages investment by lowering withholding tax rates on dividends, interest and royalties. And the Convention also outlines clear rules regarding allocation of profits from cross-border activity, making processes more efficient and predictable and cutting down compliance costs. This schedule supports Labor's drive to ensure multinational companies pay their fair share of tax. It strengthens the integrity of our tax system by allowing tax authorities in both countries to share information and help each other collect tax debts. Important tools in tackling tax evasion and avoidance. Deputy Speaker, it's clear and we know in this House that Labor is the party of lower taxes for everyday Australians. But what we also want to make sure is that big business, big multinationals are paying what they owe and are paying what they should. Schedule 5 of the bill concerns measures to maintain trust and integrity in the administration of tax concessions accessed by not-for-profits that have deductible gift recipient status. And specifically, it amends the Income Tax Assessment Act of 1997 to update the list of deductible gift recipients, providing transparency and indeed clarity for donors. The reforms in Schedules 1 and 2 of this bill build on Labor's significant work to strengthen the superannuation system. This includes legislating the purpose of superannuation. That is, that the objective of superannuation is to preserve savings to deliver income for a dignified retirement alongside government support in an equitable and sustainable way. In other words, it's not a piggy bank that can be raided at the behest of others. Another Labor superannuation reform that has had a huge impact, both financial and social, is superannuation on paid parental leave. On the 1st of July 2024, Labor added an additional 2 weeks to paid parental leave, increasing the total from 20 weeks to 22. The scheme has continued to grow by a further 2 weeks each year and will peak when it reaches 26 weeks of paid leave this year. And as of July 2025, superannuation has been paid on government-funded paid parental leave. This directly targets the unfair gap created when women's income drops, on average by 55%, in the first 5 years of parenthood. And yes, I say women's income because it reflects the reality that women still shoulder the most of the unpaid caring responsibilities in this country. That could be raising children, supporting ageing parents, or caring for family members. And taking time out of paid work to do this essential care has a real and unfair financial impact on women. Deputy Speaker, earlier in this speech I mentioned payday super. And this generational reform deals with the problem of unpaid superannuation. In 21 to 22 alone, the ATO estimated that $5.2 billion in super went unpaid. That's around $100 million every single week that workers earned but never received. The payday superannuation legislation passed last year will help ensure employees are actually paid the super they're entitled to at the time they are entitled to it. And Deputy Speaker, under the legislation, employers must ensure that the super payment hits the employee's super fund within 7 days of payday. Deputy Speaker, the amendments in this bill are important because they bolster Australia's world-leading superannuation system. Together with payday super and backed by previous reforms and the Listo, they will help ensure that Australians keep more of what they earn and retire with more. Retire with dignity. While those opposite delayed the superannuation guarantee and undermined the foundations of the system, Labor is strengthening superannuation. We should all be proud of our super system, the hard-working Australians it supports, and it should be back in these changes to make sure that we're delivering for future generations.
The question now is that the amendment be agreed to. The member for New England has the call.
Well, thank you very much, Mr Deputy Speaker, and I listened to the remarks of the honourable member who's just concluded about keeping things safe, about dignity, about making sure that people can get their super and no one intrudes on it. And that all sounds like marvellous stuff, except for people who with First Guardian and Shield funds, $1.2 billion that went missing. They're still well in excess of $500 million that they're looking for. And they were just the people that the member had been talking about. These were the school teachers. I know one very well. It was my former wife. The money has gone. Gone. Just disappeared. Hundreds of thousands of dollars reflecting their life as a teacher. And just one, but there's multiples of them. About 12,000 people. And we're expecting these people to become KCs, King's Counsellors, in pursuit of their money. Now, I asked Minister Merlino, who I know has been talking to Melinda Key, and that's good. That's good. But we have got to give these people a break. Rather than have them go through. They've got to go to Africa to get to CSLR, and then CSLR, and then they've got to go back to the trustees and countersue them and find out the liabilities that reside here. These people did what they were asked to do. They put their money in a super fund. They didn't go out to do some wild stock on the London Stock Exchange, second board of the London Stock Exchange. They put their money into super and went back to their jobs. And then these people are going to have to continue working, I don't know, waiting tables for the rest of their life. They have no money. What should be happening if we really believe in supporting superannuation and other measures is ASIC should pay these people out and then they do the footwork, the legal work to recover the money. That would be a genuinely decent thing to do. But we've gone through this bureaucratic fiasco where, we're putting people in hospital under stress. Because even now, and I was following this up last year, I'm following it up again now, that there has to be some resolution to this. I am very disappointed, and I put on notice that at the first opportunity when I managed to get one question in the last 2 years, it's a reflection of how things were going for me. But the next option I will get is to, and I put the Minister on notice, to ask them, what are we doing about this? So for those who are sitting back in the rooms, possibly, so Minister Merlino, at the next opportunity, I'm going to ask you about where we are with this process.
Can I just ask the member for New England to use the correct titles of ministers?
The Assistant Treasurer, Minister Merlino. To where are we with these people on their behalf? We have to raise the tempo on this because I thought that this would somehow get to a resolution. And I commend Macquarie Bank, who's come out as one of the people who were involved with it, paid the people out. And there was one other whose name evades me. But they all need to be paid out. What we have now is a process where some might possibly get $150,000. Now, that's not going to get you very far. I'll revert back to my accountancy days. As a very rough rule of thumb, you're going to live on about 10% of what you've got in your super. So if you've got $150,000, you have to work out what you're going to be doing at $15,000 a year plus a pension. And that's a pretty meagre life. In fact, for some people, that means a life in their car if they don't own their house. We will be putting people into destitution. We had some of these funds, the people had over $1 million in it. Quite a number of them he spoke to, 300,000, 320,000, 400,000. Diligent people who've worked hard all their life, were not financial advisors, relied on other people who had licences to deal in their money to do the right thing. But these people who got their money in super, even when their accounts were frozen, when they couldn't get access to their own accounts, the money was withdrawn by First Guardian and Shield and basically disappeared, turned up as jewellery and cars and a whole range of floated overseas, completely swindled out of their money. The hope that the people have, the groups that have, and is that we will, in this chamber, continue to fight on their behalf. I've made this issue abundantly clear to my colleagues in One Nation, that this is a fundamental issue that talks directly to the hearts of people around Australia, in the western suburbs of Sydney, in regional towns, that we've got to try and do more. So I won't delay the House, but I think it's important that people know that I haven't forgotten about this. There are other things happening around this building today where there's a fascination about themselves, but we should have a fascination about the people who are really hurting. Because of a failure in the system that was none of the fault of the people who invested in their super. We have put people into destitution and gone completely against all the principles that were just enunciated by the former member's speech. Everything she said about safety, about security, about reliability, about not being able to steal from the balances, all that failed in regards to these people. So what should happen is ASIC, the government, to be quite frank, should pay all these super accounts out, reinstall the money. And then the government, which has vastly greater resources legally, should then pursue the people who created the malfeasance and those who were associated with them and those who were paid a fee, a trailer fee, an upfront fee to hawk the business into them, get the whole lot of them, line them up, get all the money back for them, and then the government can go reclaim the money that it's paid out and hit them with costs on top of it. That's fair enough. They broke the law, not the people who put their money in the super. Because if we don't do this, all the narrative and all the discussions about this issue is a total farce. It's a total farce because we haven't actually lived by the principles that we're enunciating in such things as a Treasury Laws Amendment supporting choice in superannuation and other measures bill. It's just an explanatory memorandum of piffle. So I thank you, Mr. Deputy Speaker. I call on the Minister, the Assistant Treasurer, not to confound it with the technicalities and legal principles and liabilities and this sort of amorphous regalia of legalese. Just pay the people out. Just pay them out. And then use the great resources of the Commonwealth of Australia to pursue those who committed the crime, pursue those who defrauded Australians, pursue those who have left people in destitution for the money that they stole.
The question now is that the amendment be agreed to. The member for Hunter has the call.
Thank you, Speaker. I rise to speak in support of the Treasury Laws Amendment supporting choices in superannuation and other measures Bill 2025. This is a bill that may appear complex at first glance, but at its heart it is about something very, very straightforward, Speaker. It's about making sure that the systems Australians rely on are fair, transparent and genuinely work in their best interests. It's about strengthening confidence in superannuation, protecting workers at important moments in their working lives and backing regional industries that are essential to Australia's economy and culture and future. I represent the Hunter, a proud regional community built on hard-working people. It's a region of miners, tradies, nurses, teachers, hospitality workers, small business owners, farmers, winemakers. It's a region where people understand the value of a hard day's work and expect that effort to be respected and rewarded. People in my electorate are not looking for a shortcut or special treatment. They want common sense policy. They want fair rules. And they want a government that understands that life and work in regional Australia often looks very different from life and work in the capital cities. This bill reflects that understanding, Speaker. At its heart, this legislation strengthens Australia's superannuation system. Labor created super because we believe Australians deserve dignity and security in retirement. We believe that after a lifetime of work, people should not be left uncertain or vulnerable. Since then, Labor governments have consistently acted to protect and strengthen the system so it continues to deliver on that purpose, Speaker. For too long, however, many Australians have seen their retirement savings quietly erode, not because they made poor decisions or failed to plan, but because the system allowed inefficiencies and gaps to be present. Duplicate superannuation accounts, unnecessary fees, insurance premiums that workers did not even realise they had or were paying have steadily chipped away at balances over time. This bill takes practical and sensible steps to address that problem, Speaker. Starting a new job should be an extremely positive moment in life. It should be about opportunity, stability and progression. It shouldn't be a moment where a worker's retirement savings are put at risk without them even knowing it. By making it easier for employees to see and consider their existing superannuation fund when they commence a new role, this bill helps prevent the creation of unnecessary duplicate accounts. It empowers workers to make informed choices while preserving their right to choose the fund that best suits their circumstances. It doesn't remove choice, it strengthens it. For workers in the Hunter, this is particularly important. Many people in my electorate work in industries where job mobility is common and often unavoidable. Apprentices move between work sites. Labour hire workers move between projects and coal mines. Casual workers pick up shifts across multiple employees. People in construction, coal mining, health and hospitality often change employers as projects start and finish and as new opportunities arise. Without sensible safeguards, each of those job changes can mean a new super account. Each new account can mean new fees and new insurance premiums. Over time, that erosion adds up. It reduces balances. It undermines confidence. And it creates uncertainty about retirement outcomes. Over the course of a working life, this can make a real difference. It can affect when someone can retire, how comfortably they can retire, and whether they can retire with peace of mind. These reforms help stop that from happening. They give workers clarity and control, Speaker. They ensure that what more Australians earn stays in their super accounts, working for their future rather than disappearing through inefficiencies. This bill also supports employers by providing clearer and more timely superannuation information. That matters as we move towards payday super, which will ensure workers are paid their super at the same time as their wage. Payday super is about fairness, Speaker. It is about compliance, and it is about making sure workers receive what they are entitled to and when they are entitled to it. These measures help employers prepare for that change in a practical and manageable way, reducing confusion and improving compliance across this whole system. Another important benefit of this bill is the way it strengthens consumer protections at a critical point of a worker's journey. Starting a new job could be overwhelming, Speaker, as we all know. We all started here once before. There is paperwork to complete, systems to learn, safety requirements to understand and expectations to be met. That is not time for workers to be exposed to pressure or influence when making decisions about their retirement savings. This bill ensures that when employees are providing their superannuation details during onboarding, they are protected from inappropriate advertising and undue influence. Workers should be able to engage with superannuation in a safe and informed way without being steered or nudged by marketing tactics. At the same time, the bill preserves access to relevant and important information. Employees can still see their stapled fund, they can still see their employer's default fund, they can still see regular MySuper products that meet strict standards. The focus on transparency and informed choice, not sales, Speaker. This approach reinforces trust in the superannuation system. It recognises that superannuation is not just another financial product. It represents people's financial security. Decisions about super should be made with clear, informed and confidence, not confusion or pressure. Yeah. These reforms build on the government's broader work to strengthen superannuation and make it fairer and more sustainable for all. Legislating the purpose of super, lifting the super guarantee to 12%, expanding performance testing and ensure funds deliver value, boosting support for low-income earners and paying super on paid parental leave are all part of a consistent agenda. That agenda is making sure Australians earn more and keep more of what they earn and retire with dignity in their older age.
Yeah.
But, Deputy Speaker, this bill is about more than just super alone. It reflects on a broader commitment to supporting communities and industries across Australia. It supports Australia's role as a trusted host for major international sporting events, delivering jobs, tourism and long-term social benefits. It strengthens international tax arrangements to encourage trade, investment and innovation while ensuring integrity and fairness in the tax system. It supports philanthropic and non-for-profit sectors, which plays a vital role in communities like the Hunter, where volunteers and community organisations often provide essential services and support. And crucially for my electorate, this bill delivers meaningful and practical support for the Australian wine industry. The Hunter Valley is one of Australia's oldest wine regions and one of the most distinctive. Wine has been produced in the Hunter for generations. It is part of our history and part of our identity. But the wine industry in the Hunter is not frozen in time, Speaker. It is modern, highly skilled industry that brings together agriculture, science, tourism and a fantastic group of workers. Wine production in the Hunter supports vineyard workers, winemakers, cellar door staff and logistics operators. It supports accommodation providers, restaurants, cafes, transport operators, event organisers and tour guides. It supports local tradies, local suppliers and local service businesses. It brings visitors to our townships and our villages and sustains local employment right across the Hunter region. When people visit the Hunter for wine, they don't just come for a tasting and leave. They stay overnight, they book local accommodation, they dine at our amazing local venues, they shop in our local towns, they attend concerts, weddings, festivals. That flow-on effect is essential to the health and resilience of a regional economy. The Hunter wine industry also plays an important role in exports and promoting Australia's wine reputation overseas. As we all know, and I've said in this place many, many times, the best wine in the world comes from the Hunter. Hunter wines carry the story of the region onto the international market and contribute to the Australian brand. That reputation has been built carefully over decades through quality, innovation and consistency, often by family businesses that have weathered the good seasons and the difficult ones alike. However, Hunter wine producers are facing increasing pressures. Rising costs of energy, packaging, freight and labour are squeezing the margins. Climate vulnerability is adding uncertainty to every single vintage. Global competition is intense, particularly for smaller producers, competing against large international brands with far greater scale. For many family-owned wineries, the pressures are consistent. These are businesses deeply connected to the place. They employ local people. They invest locally. They support community events, sporting clubs and charities. When they face uncertainty, the impact is felt well beyond the vineyard gate. That is why an increase to the wine equalisation tax producer rebate cap under this bill is so important. By lifting this cap from $350,000 to $400,000 per financial year from the 1st of July 2026, the government is providing targeted practical support that reflects the real cost pressures facing wine producers today, Speaker. This is not about advantage or excise. This is about stability and sustainability. For many Hunter wineries, this additional support will help fund investments in water efficiency, energy upgrades and climate resilience. It will support training and retention of skilled staff. It will help producers innovate, improve quality, diversify offerings and reach new markets. In the Hunter, this kind of support also keeps the entire local supply chain moving. Every vintage relies on regional truck drivers and freight operators, label and packaging supplies, fitters and plant mechanics maintaining plant and equipment, the local builders, lecos, when winery upgrades or are needed or expanding facilities. It supports chefs, waitstaff and cleaners at restaurants and accommodation venues that benefit from cellar door tourism. It supports event crews who run tastings, weddings, festivals that bring visitors into the region throughout the year. When a Hunter winery can invest a plan with confidence, that confidence spreads through the local economy, creating more shifts, more jobs, more apprentices getting a start, more bookings for local businesses and more families able to stay in the community they love, Speaker. Importantly, it also supports people behind the industry. In the Hunter wine is often a family affair. Parents, children, grandparents working side by side across the vineyards, the cellar door and the back offices. These businesses provide stable employment in regional towns where opportunities can be very limited. They allow young people to stay local rather than move away for work. They help keep schools open, sporting clubs strong and main streets active. Supporting wine producers through this rebate is ultimately about supporting those families and ensuring the Hunter remains a place where people can live, work and build an amazing future, Speaker. It will also help protect cellar door operators, which are central to the Hunter's tourism appeal. Keeping those cellar doors open means keeping people employed, keeping visitors coming and keeping regional towns vibrant. This measure also sends a clear signal that regional industries matter. It recognises that wine is not a niche concern or an afterthought. It is a significant contributor to regional jobs, exports and tourism. Supporting wine producers means supporting the entire regional economies. In the Hunter, wine sits along coal mining, manufacturing, agriculture and energy as key pillars for economic strength. A strong wine industry helps diversify the regional economy and makes communities more resilient to economic change and global shocks. This is exactly the kind of practical, targeted policy rural Australia needs. It understands local conditions, it builds on existing frameworks and it delivers real benefits where they are needed most, Speaker. It reflects Labor's values and fairness, security and opportunity. It reflects a commitment to making sure economic growth is shared and that no community is left behind. That's why I support this bill and I support this to the House.
The question now is that the amendment be agreed to. The member for Riverina.
Well, the amendment moved by the member for Fairfax will be supported by the Coalition, Deputy Speaker, and I'm glad that the member for Hunter has acknowledged in his contribution the truck drivers of this country and the freight industry as a whole, because at the moment the trucking transport sector is in freefall, and I really think as a matter of urgency the Labor government needs to call a summit and needs to hear those solutions to what is a calamity in our country when you have companies such as Ron Kraut's Transport, Watson's Refrigerated Group going to the wall, third generation, decades-old companies doing it tough. It's so difficult because everything, as you know, Deputy Speaker, gets delivered on a truck. Everything, our food, every good, just about at one stage of the chain process gets delivered on a truck. This bill before the House, the Treasury Laws Amendment Supporting Choice in Superannuation and Other Measures Bill 2025, contains 6 schedules, providing employers and agents with access to employee staple fund information earlier, restrictions on superannuation advertising during onboarding, Rugby World Cup tax exemptions, Australia-Portugal tax treaty, deductible gift recipient listings, and Schedule 6, which is an increase to the wine equalisation tax producer rebate cap. And at the early part of my contribution, I just want to refer to Schedule 6, which is about changes to the WET. Increases to the wine equalisation tax producer rebate cap are important because currently producers can claim refunds of excise up to $350,000 per annum. The bill will increase that refund amount to $400,000 per year. This rebate will hopefully keep small and medium wine growers afloat, and particularly in regional Australia. This is imperative. The Riverina is Australia's second largest wine producing region. Now, when I say Riverina, I'm being a little bit generous. The Murrumbidgee irrigation area, long been in the Riverina. Riverina, some could argue, would start at Naranda and go west, and takes in Griffith, Yenda, amazing wine country, and that is well represented by the member for Farrer. You look on any given tourism schedule, any given Wikipedia entry, it's considered the Riverina, and it is. But the 5 of New South Wales' 16 wine-growing regions are in the Riverina. Wine is also linked to the great immigration stories of southern New South Wales, particularly through Italian communities. And you've got the Casellas, the De Bortolis. I could go on and on. Some of those names synonymous, of course, not just throughout Australia, but worldwide. And Yellowtail and other iconic brand names have done so much to boost wine production in that outstanding wine-growing area of New South Wales. Demand for cool climate wines from the Riverina, and not just the electorate but the regional geographic area, is strong. Riesling is seeing a great resurgence domestically. And then you look at the vineyards at Cottontails Wines, Wagga Wagga, Barambula Winery. It's been operating for more than 30 years. McMullen's there, they're doing an outstanding job. These wineries add to the dynamic regional tourism offering and provide perfect venues for birthday parties, meetings and weddings. Wild Vine, they're out on the road to Ara, an outstanding wedding venue, and their vineyards are very well looked after. The Charles Sturt University, it's doing some great research, and it's home to the next generation of we hope, Australian and international winemakers, and their own wine stands out as well. In the world-renowned Tumbarumba region, we have premium cool climate wine and grapes with 19 vineyards and 3,000 tonnes of grapes crushed annually, and they're reasonable numbers for a regional winery. The Murray-Bateman wine region is home to 20 world-class boutique wineries: Clonakilla, Nick O'Leary Wines, Helm Wines, Shaw Wines, all outstanding, just to name a few. And I know the Mayor of Yass Valley Council, Jasmine Jones, is one of the great promoters of the wineries there, and she's also very worried about the fact that what she describes as an industrial junkyard with a take-up of arable farmland with 260-metre high wind towers. She's extremely worried, as she should be, because that's wine country, that's cool climate wine country, and it's tourism country, and it should not be in the rushless race to renewables taken up with those monstrosities that they call wind turbines. Now, these wines that I mentioned just a little earlier from Murray-Bateman and elsewhere around the Yass Valley appear on curated wine lists at restaurants around the world, as well as, of course, the dinner tables in the Riverina, and also sometimes in the Hunter Valley, in South Australia and elsewhere, where, of course, Margaret River, I could go on, but very good wine producing country too. But they all know the value of Riverina and southern New South Wales wines. Now, the Coalition successfully implemented the United Kingdom Australia Free Trade Agreement, which removed a 5% tariff on Riverina wines destined for the UK. Now, this was a win for our producers and the British public. And I have to say, any tariff arrangements, any free trade agreements that are signed, and I know Senator Farrell is well aware of this. He likes a good red. Been with him on a trip or two, and knows the value of making sure that our winemakers are looked after in any trade arrangements. And the member for Page, when he was, and I know he does a good deal of shadowing in that trade phase, but also as a former minister in the former coalition government, understanding the value of getting the right arrangements when it comes to free trade agreements. I could mention the member for Wannon there too, and particularly on this bill, we do support many measures in this bill. And this probably comes to the very core that it shouldn't have been bundled in this way. Those 6 schedules are, you could argue, disparate. Labor has stitched together a series of largely unrelated measures and wrapped them around contentious superannuation changes it knows we oppose. Clever, it's what Labor does, always good at politics, never really that great at politics, at policy, sorry. This approach is designed to force a false choice on the Parliament, accept the superannuation changes or be accused of blocking sensible, unrelated measures. It's wedge politics, it's not good lawmaking, but it's what, unfortunately, Labor does. And we know that Labor has a 50-seat majority, and we know that this bill will pass, and we know that it will go to the Senate, and we know that Labor will do deals with the senators who hold the balance of power, and so on we go. But when it comes to superannuation as well, and we also understand that superannuation is one of those, we all have it, we all need it, but it's something that we probably hold at arm's length. Not a lot of people understand truly the power of superannuation. But I tell you who do understand the power of superannuation. It was those Australians caught up in the First Guardian and Shield collapse. That, for some, is an absolute tragedy. Their life savings just gone in an instant. And, you know, people don't need, at that stage of their lives, to have the rug pulled out from underneath them as they have. Now, the Australian Securities Investment Commission, ASIC, has taken further steps to support thousands of Australians who invested in the Shield Master Fund and the First Guardian Master Fund after the collapse. So they should. So they should. I do worry, really do, about this whole situation. I know that the then Assistant Treasurer, the member for Shadow Assistant Treasurer, the member for Cowper, was very, very strong and extremely vocal on this. We know, because the ABC reported it as recently as the 10th of February, that the government is planning to tighten the rules around managed investment schemes and give corporate watchdog ASIC more power to demand information. So it should. So it should. It comes following the collapse of major funds, Shield Master Fund and First Guardian. Now, consultation on Treasury's proposals close on the 27th of this month. I do hope, earnestly, that the government has thrown the net out wide enough to get the proper consultation. I do hope that they've been the right people have been eyeballing those most affected by this collapse, by this corporate collapse, by this collapse of superannuation funds for so many people. 12,000 Australians, 12,000, not a small number, poured $1.1 billion in retirement savings into the two funds. Collapsed in 2024-25 amid what incoming ASIC Chair Sarah Cordes described as industrial-scale misconduct. Industrial-scale misconduct. Now, investors in First Guardian, many of whom switched from highly regulated super funds into the product, face little prospect of recovery directly from the fund, which liquidators in December saying just $1.6 million of $446 million tipped into it had been recovered, not enough to pay their fees, according to this ABC article. In order to recover money for investors, the corporate watchdog has instead launched a series of lawsuits against companies responsible for overseeing the fund. Now, at the risk of Labor just saying, well, what did you do when you were in government? But as a Parliament entirety what was done. What was done, because we should have been onto this, and ASIC should have perhaps been doing more to ensure that these companies just don't go under. Because if you're somebody near retirement, if you're somebody looking forward to putting your feet up and enjoying your twilight years and knowing that you've got so much invested in these superannuation funds and that will be what you live off for the rest of your life, and all of a sudden to have that money disappear, could place yourself in their shoes. It must be just so worrying, so bad for your health. And we feel, and I know as parliamentarians across the aisle, we feel for those people. We should and we must and we have to do better. As parliamentarians, ASIC must do better. Corporate watchdogs, we must absolutely ensure that this cannot happen again. I know it's happened before. I know we've had situations that have occurred previously, but it's not right. It's simply not right. The collapses of First Guardian and Shield schemes have, as the ABC quite correctly reported, exposed deep flaws in the regulation of Australia's $4.3 trillion superannuation sector. $4.3 trillion. It's a massive amount of money, but it's what the ordinary, average, everyday Australians who rely on that super, who relied on those two major companies, Shield and First Guardian, and now they have nothing. They face a very bleak prospect. And the scandal has also thrown into the spotlight gaps in the regulation of parts of the financial services industry, the ABC says. Both First Guardian and Shield were managed investment schemes, a type of fund first established in the late 1990s, and the story goes on and on. Now, both sides of government are accountable for this. I'll be perfectly upfront and say that. But it's now up to Labor, they're in government, to do what they can to help rectify a very sad and bad situation for those investors who, many of whom, now have nothing. They've got absolutely nothing, and they were looking on that to rely on that to live out their lives in reasonable prosperity, and they have now been left high and dry. The amendment that's been moved by the member for Fairfax, I commend that to the House. The legislation has way too much packed into it in typical Labor fashion.
The question is that the amendment be agreed to. The member for Deakin.
Thank you, Deputy Speaker. I rise in support of the Treasury Laws Amendment supporting choice in superannuation and other members' Bill 2025, and rise somewhat surprised that there seems to be expressions of controversy and outrage to the contents of this important bill, a bill that might not be the thing capturing the excitement of the media right now, but is nonetheless an important part of the business of governing. We saw in 2021 superannuation law was reformed to enable a stapled plan to be a key component. So when someone changes jobs, and we know that 2.9 million Australians every year change jobs, that if in circumstances where they're unable to nominate a new fund, that the employer would then go find their existing fund and put their money into that. It essentially was there to ensure that duplicate accounts weren't being created to the financial detriment of workers, something we saw for a very long time. This is a fairly modest addition, the Schedule 1, which extends the stapling provisions, which, by the way, were introduced by the Coalition for the very purpose of preventing duplicated funds. This extended so that employers can help facilitate this through the onboarding process by identifying the fund that belongs to the worker, not just after they've been given paperwork and returned it without filling in a choice of fund, but from the beginning of the relationship, to ensure that the workers are able to have it clearly outlined what their options are, including their existing fund should they have one. So it's there to help fulfil the intention behind the stapling reforms that were brought in 2021, and obviously support the context where payday super is introduced so as to ensure that businesses are given the flexibility they need to be able to comply with those rules. But the benefits also go to supporting businesses through having a more methodical onboarding process, because we know, as other colleagues in the House have said, that there's a lot going on during the onboarding process. And so making that as simple and straightforward as possible for businesses to be able to comply with those obligations and support employees in selecting their fund so they can get on with business is very important. But as has been mentioned, this bill brings together a set of targeted and practical reforms. It goes to superannuation, and they're fairly technical amendments, which I'll go through in more detail shortly. It goes to a particular international tax arrangement, philanthropy, and some sector-specific tax settings in wine. While the measures deal with different parts of the law, they share a common purpose, and that is really just making the systems that we rely on work better in practice. This isn't about a high-level ideological argument. This is very practical reform that is included in this bill. It's really where the law and the policy meets in real life, how they work for workers, how they work for businesses, and for the community more broadly. So in general terms, you've got Schedule 1, which is about streamlining the choice of fund process for businesses so that they can find out the account information of their workers from the get-go. Then Schedule 2 amends corporations law, which goes to the advertising of superannuation products at the time of onboarding. And as we've heard in other contributions, we know that there are super funds which are not high-quality, low-risk funds that have been signed up to the great detriment of workers. So it does limit advertising to their existing accounts or to MySuper and well-secured superannuation products, because we understand that superannuation account decisions are not at the forefront of every worker's mind at every point in time, but we've got to make sure the settings are there so the default position is one where people's money can be looked after to the greatest extent possible. Deputy Speaker, Australia's superannuation is one of Australia's quiet success stories. It has helped millions of Australians retire with dignity, it has reduced long-term pressure on the age pension, and it's turned the savings of working people into a long-term investment that supports the broader economy as well. But superannuation isn't just an abstract, it's not theoretical. It is, at the end of the day, deferred wages, money earned week by week, job by job, and set aside so that retirement is not defined by uncertainty or hardship. For workers, superannuation represents security for the future. For businesses, it's a core part of paying people properly and meeting their obligations. For the country, it is a system built on trust. This bill is about protecting that trust and strengthening a system that already does a great deal right. But as we've seen, some flaws have emerged and we need to address those, and we also need to ready the system for other reforms that have come. But the reforms in this bill are, again, fairly, I would have thought, technical and uncontroversial, but apparently controversy has been found in these times where picking a political fight is the go-to position. Alongside the Payday Super Bill, which we've already introduced and passed, this is a piece of promised legislation. It was built on a simple idea that workers should share in the prosperity that they have helped create. But over time, we've seen that workers starting a new job, experiencing that great moment of change, have found themselves under pressure. Pressure to make a whole lot of decisions in very quick succession, and one of the things that can pop up is a suggestion of changing funds. But we also know it's a stressful time for business. Getting a lot of things done right quickly, payroll, tax, super, other compliance, making sure that people are ready to get onto the job, making sure the OH&S induction's done, and all sorts of things that need to be overcome. It is a busy time. So we need to make sure, to the extent that superannuation policy kicks in, that it is helping people and not hindering. Before stapling was introduced in 2021, and again, that is essentially the requirement that if someone doesn't choose a fund, that their money, where possible, is put into an existing superannuation bank account rather than a new superannuation account, rather than creating a new one, which leads to that duplication that has cost workers for such a long time. We need to make sure that the policy intent behind that isn't undermined by recent phenomena. Because as I was saying before, 2.9 million people start a job every year. About 2.5 million of those are onboarded through an online onboarding process, and we've seen a proliferation of advertising in those onboard systems, which are often offered to business without charge, but include advertising, and that advertising is for super products that sometimes are not suitable. And the issue is, if someone, through that advertising, selects a superannuation fund, that, including one that might not be in their interest, might not be as secure as a MySuper product or another conservatively invested one, and we know that about 325,000 workers select an advertised superannuation product when they're using that onboarding software. We need to make sure that they are protected from inadvertent decisions, inadvertently creating multiple funds and also not signing up to something that is not in their interests at a time of high pressure and with a lot going on at that point of time. So this bill is really quite focused on addressing some of those challenges, because we know that each additional account means extra fees, it means extra insurance premiums. It's less money left over time, that magic of compound interest. I think it was Albert Einstein that called compound interest the eighth wonder of the world. So we need to make sure that workers are enjoying the benefits of that magic as much as possible when it comes time to retire. And we know that timing matters. Under the current rules, that information about an employee's existing superannuation account is only brought to the attention of employers after all the forms have been sent out and the process is towards its end on onboarding. So this enables that information to be obtained at the start of the onboarding process rather than having to hand out a form, then it's only when they receive the form back but it doesn't nominate a superannuation fund that they can go and find out whether an existing fund exists. It's created an administrative burden and has also meant that sometimes undesirable outcomes have happened, because the very purpose of stapling is to make sure that it is that money is not being put into new accounts all the time to the detriment of workers. But it is now being undermined by advertising we are seeing in an increasing number of online onboarding platforms. Just something that wasn't intended, and I'm not begrudging the reforms made in 2021 by the coalition government. I think many of them were very good. It was back when they were focused on governing, not on other things. But it's something that should attract support, because it really is building on something that has for a very long time been politically uncontroversial in Australia, that multiple accounts are just bad for workers. So Schedule 1 essentially enables employers, their agents, to access stapled fund details. And as I was saying before, stapled fund just means a worker's existing superannuation account earlier, and to provide that information to employees at the point when choices are actually being made by those workers. For workers, it means recognising that they already have a super fund, that it's clearly set out in front of them, and that they can choose with confidence whether to stick with their current fund, or if they really want to, then take on a new fund as well. They might want to change in entering a new industry or the like. For businesses, it means fewer errors, fewer delays, and a greater certainty that super contributions are really going to the right place from the get-go. Choice is preserved. People can still choose whatever fund they want and change over time, and if they really want to have multiple accounts, they can. But the standard form choice still needs to be given, and the choice still belongs to the employee under this regime. What it changes is the quality and timing of information in the process. As Australia moves towards paying super close to payday, this becomes even more important. Accurate fund details early mean contributions flow sooner, more reliably, and with fewer compliance headaches. This is good for workers, it's good for employers, and that is how a strong system becomes an even stronger one. Deputy Speaker, superannuation works best when decisions are made deliberately, not under pressure, persuasion or commercial influence. Starting a new job is not a shopping experience. It is not the right moment for sales tactics, particularly when the product in question will shape someone's financial future decades down the line. Evidence, as I was saying before, has shown that some online platforms have been using that moment to promote what some would consider higher risk superannuation products that most would objectively say are not to the financial benefit of signing up. And as we've heard before, getting the superannuation, getting that account right, choosing the super fund with the right risk tolerance is incredibly important. And to use those kind of tactics does undermine the trust that the system relies on. Because at the moment, if a new fund is chosen through that process, all of those stapling provisions don't apply. The employer is under no obligation and has no reason to go seek information about your other fund details. So it has eroded the purpose underpinning that 2021 set of reforms. So Schedule 2 sets a fairly clear boundary. You can only you can't advertise non-MySuper accounts where the results haven't been audited in line with processes that have been around for a while now. So it's designed to promote only simple, regulated defaults and not any of the bells and whistles or higher risk tolerance ones. So it's not anti-choice, it is just preventing the pushing of higher risk superannuation plans, knowing that that was a balance of competing possibilities. They could have completely abolished advertising, which means that those businesses would face higher costs because they'd suddenly have to pay for platforms that they're currently getting for free. But we also want to make sure the high risks and financial risks are minimised through these reforms. So these are quite balanced and proportional and very much designed with the interests of businesses as well as the interests of employees in mind. because Australians should be able to trust that when they engage in superannuation at the start of the job, the system is there to serve them, not to sell to them. Schedule 3 looks at the supporting of the Rugby World Cup, both men's and women's. I think it's the men's is in 2027, the women's Rugby World Cup in 2029. So this is a fairly standard tax measure that happens with a lot of large-scale sporting events, essentially exempting them from income tax and withholding tax over a defined period of time. Very standard procedure. We've seen it with other events and before. It's not only common Australian practice, it is international practice, but nevertheless is important to clarify that tax treatment. And speaking of the clarifying of tax treatment, this Schedule 4 also goes to an arrangement with the Portuguese Republic, or Portugal. It gives domestic legal effect to Australia's first tax treaty with Portugal. For businesses operating across borders, uncertainty is costly, and we certainly don't want to see double taxation because it can deter investment, complicate planning and increase compliance burdens. This treaty reduces those risks while preserving Australia's strong anti-avoidance framework. It follows international best practice, strengthens cooperation between tax authorities and provides clearer rules for resolving disputes. It is about certainty where certainty is needed and integrity where integrity must be protected. Schedule 5, supporting philanthropy with integrity as well. It updates the list of specifically prescribed deductible gift recipients. In layman's terms, it's those organisations which, if you donate more than $2, you can reduce the amount of that donation from your taxable income. So it is a very important means by which charitable organisations get support. Generally, there's a whole lot of categories which you need to strictly be aligned to in order to be able to be defined as a deductible gift recipient. Another way of doing it is for some charities that might not neatly fall into one of those legislative boxes to be defined in tax legislation, and that enables them to collect donations, as I was saying, with a tax deduction if that donation is above $2. So it is an important thing. I think it adds several new charities. It extends some listings because they are defined by period of time, and also removes some organisations, the common reason being that some of the money is used other than for the purpose for which that DGR status was given, but it is a regular practice, and it's very important that we do maintain up-to-date registers to ensure that good charities are being supported. We also have in Schedule 6 adjusting the existing wine rebate framework. It increases the maximum wine equalisation tax producer rebate from $350,000 to $400,000 per year from the 1st of July 26. It builds on an existing rebate system, increasing support without adding any complexity to the system. So it's a measured adjustment within a well-understood framework. Deputy Speaker, this isn't about sweeping change. This is not a radical bill. It's about making systems work better for the people who interact with them every day. It strengthens superannuation, one of Australia's great policy achievements, and improves clarity and confidence. It reinforces trust in systems, and for those reasons, I commend the bill to the House.
The question now is that the amendment be agreed to, and I call the member for Wentworth.
Deputy Speaker, I rise to speak to the Treasury Laws Amendment Bill, Supporting Choice and Superannuation 2026. While I will not oppose this bill, I want to raise concerns I have with Schedule 2 of this bill that could result in less, not more, choice in superannuation products. Reduced competition in superannuation has a hidden cost on all Australians, and we need to be alive to these risks when making what we may think on the surface seems like a no-regrets change. And other issues that we have had, for instance, in making things like the performance test, some of those changes that we have made in those areas have ended up in terms of reducing choice or reducing dynamism in the super industry, and I do think we need to be much more alive to unintended consequences, which is why I have a second reader amendment to this bill. And so I'd like to say, just take the opportunity to say I move the amendment circulated in my name. Deputy Speaker.
Sorry. Is the amendment seconded?
Amendment and reserve my right to speak.
Call the member for Wentworth.
Hang on. Deputy Speaker, this bill has 7 schedules. While I will not go through each schedule in detail, I note that on balance there are positive measures held within the bill, but I also note that it is, I think, quite inappropriate to include some of these schedules as one bill because they are not the same thing, and I think it means that it does make it difficult to support some bits rather than other parts. I'm pleased to see Schedule 6 lists 6 new deductible gift recipients, including in particular some organisations that I've worked with and in some cases even supported their DGR status, including Equality Australia, the Great Synagogue Foundation and the Parenthood Project. This represents important recognition for these organisations for the philanthropic work that they do. Similarly, I note that the Schedule 6 increases a rebate claimable by wine producers from wine equalisation tax in an effort to provide additional support to Australia's wine industry, and I support these measures. But Schedule 1 and 2 are the most consequential changes and the ones for which this bill gets its name. Schedule 1 amends the Superannuation Guarantee Administration Act to allow employers to request information about employees' stapled superannuation fund from the ATO if the employee has not selected a product during onboarding. This is an important change that will make it just a little bit easier for employers to act in the best interest of their employees by identifying their stapled superannuation product rather than creating duplicated funds when a default is not provided as part of the ongoing onboarding process. Duplication of superannuation products costs Australian workers millions each year, still with more than 4 million Australians holding more than one superannuation account. The more that we can do to minimise unnecessary and unintended duplication, it's a positive step forward. Schedule 2 puts a ban on advertising superannuation products during employee onboarding processes, subject to certain exemptions. This change has come about after a series of cases in which employers were found to be directing new hires towards underperforming financial products to which the employer had a relationship. Perhaps the most high-profile cases of this was MYOB, who was accused in 2023 of directing employees towards an underperforming high-fee fund with the option to stick with their existing fund buried in the fine print. The intent of this schedule is therefore not without cause. We know that many Australians are generally disengaged with their superannuation, perhaps even more so than usual at the point of starting a new and exciting career opportunity. When clicking through the often lengthy onboarding processes, many of us will take the path of least resistance. The tendency can and has been exploited. But I, and some in the industry, are concerned that this legislation will have unintended consequences that in fact lessen competition in the sector, not strengthen it. Advertising may have certain negative connotations in today's highly commercialised environment, but the ability to advertise is an important mechanism for new products to break into markets and to disrupt the landscape. Without the ability to advertise new products, incumbents can become easily entrenched, and without constant competitive pressures, performance and consumer outcomes can weaken. While many Australians are disengaged with super, we should not simply take this as an accepted fact. The start of a new job could be an important opportunity for Australians to re-evaluate their retirement savings options, and to the extent that we can, we should be encouraging Australians to be engaged. Actually, it is an area where I think it would be appropriate to be spending government money in terms of advertising, perhaps much more so than other government-funded advertising campaigns. And advertising more broadly has a role to play in this. Obviously, we don't want this to be used as an opportunity for employers to cross-sell conflicted products. But a blanket ban, as was originally canvassed, is not a viable option, because the obvious beneficiaries of a blanket ban are default funds. It is estimated that around 60% of Australian super fund members are invested through a default super fund option selected by their employer, often their first employer. But even if these funds were a good option at the time, there is no guarantee that performance is sustained. In 2022, ASIC reported that 9 of these default products were failing the performance test, impacting around 800,000 members, according to Morningstar. If we put a blanket ban on the advertising of products when onboarding, there is one less opportunity for consumers to assess their current fund and adjust their choices if necessary. In response to this feedback from industry, the government has made certain exemptions to a blanket ban. For example, in the Minister's second reading, he advised that advertising would be permitted if the advertised product was, first, 1, the employee's staple product as confirmed by their ATO, 2, the employer's default product, or 3, a Moai super product that meets certain requirements, including passing the annual performance test. These are sensible changes, and the legislation requires advertising of new products to be accompanied by information about current staple product to highlight the benefits or not of switching products. But as the FSC points out, the explanatory memorandum outlines that showing staple products requires collecting information from ATO Commissioner, which adds an administrative barrier to finding staple products. Currently, onboarding platforms are able to use third-party verification services to find staple products through fund information rather than the ATO. This process is often faster, but can admittedly be less reliable. The FSC is concerned that by making the ATO the single source of truth, this will result in administrative delays that mean, in effect, only default funds will be shown under these exemptions. This, I believe, is not the intention of the bill. So while I accept that this bill has good intentions, I accept that there is some scope for this bill to create unintended consequences. And I think this is the piece that I think is really important for the government to measure and keep pursuing and keep an eye on, to see if it does have these unintended consequences, then the government will have to swiftly act to change this. It will take time to implement, but this is important in assessing the effectiveness of this bill. But I would like to talk to the cumulative impact more broadly of some of the super reforms that have been put forward in this place over the past few years. Superannuation policy constantly grapples between balancing consumer protections for a relatively disengaged cohort of Australians against the important point of driving competition. I am concerned that the cumulative impact of superannuation policy, including the performance test, which the Treasurer has recently agreed to review, which I think is really important to review, not to remove the performance test, but to make sure that the performance test is to minimise the unintended consequences on reducing competition and innovation that I do believe the performance test does at the moment, has created less competitive pressures on funds to outperform and to deliver for their clients. This has a cost, albeit hidden, and I'm concerned that this legislation may add to that cost. And I do want to argue that this should worry us all. Australia has an extraordinary amount of our resources in superannuation, $4 trillion. It's absolutely remarkable. We have one of the biggest pension pots in the world, in that cumulative fund. We have some of the biggest pension funds in this small little country of ours in the world, while only having 27 odd million people. But the question really is, we need those funds to be as competitive as possible with each other if they are going to be using that $4 trillion worth of Australian assets, which is over 100% of our GDP. So this really matters what that money is doing. If that money is going to be used to, firstly, the greatest benefit of the members, and secondly, making sure that it is actually serving the country as well. And just to put it on the record, the Primus, I will never walk away from the sole object of superannuation is, frankly, to earn returns for their members. So I'm never going to sort of violate that principle. But I do recognise that with that big asset pool, in some ways, a super fund, they have an enormous impact on our economy. And that impact, through different pieces of legislation can be more or less positive, both for the members and for the funds. And I want to draw your attention to a particular example, and that's super funds' investment in innovation. So you would think, with the sort of high level of superannuation funds and pension funds available, that Australian super funds would be investing in innovation in Australia, particularly given that sort of VC funds and PE funds have been shown to significantly outperform the ASX and more traditional listed areas. However, what we have seen is that super funds have reduced their exposure to innovation, and particularly VC and PE, over recent years. We have seen that members of the industry, the VC PE sector, have told me that in the last 5 years, the major super funds have not invested in a new VC fund over that period of time. So the super funds are investing in the ones they're used to, but they're not actually investing in the new innovation in the VC and PE area. And I think this should be concerning us, because who is funding innovation? Innovation is a perfect I think these sorts of industries are perfect sort of assets for super funds, in the sense that they are long duration and need patient capital. But also have the opportunity to really, on good ones, really earn extraordinary returns. So they should be the place, but they're not currently. It's why I've been pushing, and I really respect and I appreciate the Treasurer being open to looking at Your Future, Your Super, and ASIC, and expanding the ASIC's review of RG 97 to include superannuation, to include funding for innovation. But I do think this is the stuff that we need to be aware of in some of this. We are trying to protect consumers, but if it ends up that we are just entrenching providers that do not have to really show their worth to consumers who are not subject to strong competition, then we will be doing a disservice to all the people who invest across our country in these superannuation funds. And that is the piece that I think it is really critical for the government to be monitoring as it brings in these sorts of changes. And so finally, I urge the government to deal in good faith with the Senate inquiry process and commit to waiting for this review to take place before pushing this legislation through the Senate. And I would actually say it would be great if the Senate inquiry could be done before this legislation is once again pushed through the House, because it means it is hard to vote on legislation without having the full information. But that is literally the modus operandi of this government. And I do think that, I support the intent of this bill. And I think that my feedback has been that the Assistant Treasurer has done a great job of engaging with the industry and really been incredibly consultative, and that doesn't surprise me at all, because I think that's been his approach across many different areas. But I do think there is a danger here, and I do think it's important to make sure that this bill does actually strengthen consumer outcomes and we don't lessen competition. And so we need to be very careful that this bill actually lives up to its title, which is improving choice in superannuation. Thank you.
Before we proceed any further, I jumped the gun before, so can I ask if the amendment be seconded?
Second the amendment and reserve my right to speak, Deputy
Excellent.
Speaker.
Thank you, Member for Kooyong. The original question was that this bill be now read a second time. To this, the honourable member for Fairfax moved as an amendment that all words after that be omitted with a view to substituting other words. The honourable member for Wentworth has now moved as an amendment to that amendment that all words after whilst be omitted with a view to substituting other words. The question now is that the amendment moved by the honourable member for Wentworth to the amendment moved by the honourable member for Fairfax be agreed to. Okay, and I understand that the member for Pearce would like to present a copy of their speech for incorporation into Hansard in accordance with the resolution agreed to on the 6th of November 2025.
That's correct. Thank you, Deputy Speaker.
Okay. The question now is that the amendment be agreed to, and I call the member for Casey.
Thank you, Deputy Speaker. Another Treasury Laws Amendment Bill, and we have Labor Party Government 101. Make sure that it has a very impressive sounding name. That has to be the first thing you get right. If they don't get the name right, there's actually nothing they can talk about, because the detail within the bill never lines up with what it says. We've got a bill that is about supporting choice in superannuation. Sounds impressive. Everyone loves choice, except a bill like this narrows choice, and it conveniently, Deputy Speaker, narrows choice to those super funds that are industry funds that purely by coincidence, pure coincidence, those industry funds happen to be connected to the union movement. And then the union movement happens to be connected to the ALP and the government and pulls the strings. It's all just a coincidence that this money cycles around, and the super supports the unions, and the unions bring members in and support the government, and then the government coincidentally does legislation that supports just those industry super funds. What did they say? Oh my God, what a coincidence. Was it Deidre Chambers potentially? Anyway, we know how that one plays out. We see it all the time, and it goes to the next level of a name, and they've just had to sneak in, because you actually have to be a level of honest in these things, other measures. Just added other measures, very benign, very plain other measures, could be anything. And that is exactly what this bill does. There is no links and connections at all between anything in this bill. There are 6 schedules. And we have talk about super. We're looking at wineries, which I will talk about in a moment as the member for Casey. I'm lucky to represent the best wine region in the country. Some, myself included, would argue that it is the best wine region in the world, but I don't want to be that bold, so I'll stay with the best wine region in Australia. And I know the member for Fadden agrees with me, because there is no wineries in the Gold Coast, so I've got at least one supporter there. The member for Riverina might have a disagreement with me. We'll take that up out of the chamber, but he will be very happy that he got a mention in this speech. But we go from wineries to then the Rugby World Cup tax exemptions. Not sure of the link from wineries to Rugby World Cup tax exemptions. We're then looking at deductible gift recipient listings, charities, very important work not sure the connection to superannuation, to the Rugby World Cup, or wineries, all completely different issues that could be and should be individual bills that are dealt with on their own merit. Each schedule stands alone as a bill that is worthy of debate, and that it should be discussed and voted on and passed as individual measures so we can represent our communities fairly and make sure that we support what we can and oppose what we must as well, because there are some really terrible elements to this bill, as I talked about, that circle of convenience in super at the start. But this is what Labor does. They like to put all these measures together to force us as the opposition to vote on a whole bill. You don't have a choice to separate it out. And I want to talk specifically about the wine equalisation tax and make it clear for the record and for my community that we do support the government's proposal to increase the wet tax producer rebate. However, we do not support the moves to limit comparison of super funds and reduce consumer choice. As I said, driving those funds to the ALP, to the union movement and back again. And we don't have a choice on how we vote. We have to vote collectively on this bill. So we will be opposing the bill in its full measure, but I absolutely support that. And as I said, as the member representing Australia's finest wine region, I'm proud to stand here in support of the increase of the wine equalisation tax producer rebate as such an important initiative, particularly for those smaller wineries and cellar doors that need that tax to survive. And from the 1st of July this year, the rebate cap will be increased from $350,000 to $400,000 per financial year. And I'm going to shock the minister opposite and congratulate the Albanese government on that move. When the government has good policy, which is very rare, I will support it and I'll put it on the record. So congratulations on increasing the wine equalisation tax from $350,000 to $400,000. The Yarra Valley, we're home to over 80 cellar doors, many of which are small to medium family-owned enterprises. And I know, speaking with local viticulturists, that many of these businesses have been squeezed in recent years by the bracket creep and the pressure of rising production costs, compounded with the lack of demand in wines. And by raising the cap, these wineries will be supported and encouraged to continue scaling and succeeding, allowing them to retain an additional $50,000 in cash flow to reinvest in their wineries and, so importantly, in local jobs and the local community. And we must recognise that every bottle of locally grown wine that is sold at a Yarra Valley cellar door, it supports a network of regional and rural local jobs, from the winery hands and the winemakers to the hospitality staff to the chefs and the local tour operators. I was lucky enough to work in the hospitality industry in my community. Unfortunately, that was about 20 to 25 years ago, but so many young people get their first opportunities in hospitality because of our wineries. And according to the 2025 report by Wine Australia, grape-growing, winemaking and wine-related tourism contributes $51.3 billion to the Australian economy and supports more than 200,000 jobs each year. And by strengthening the financial viability of these wineries through this rebate increase, we are securing the future of regional towns in my community and many communities across the country. This measure will help play a role to ensure that the Yarra Valley remains a vibrant, competitive and world-renowned destination for generations to come. And I'm proud to always support my communities and always support programs and incentives that will allow them to continue to grow and flourish within our community.
Hear, hear. The question now is that the amendment be agreed to, and I call the member for Gorton.
Thank you, Deputy Speaker. Deputy Speaker, I rise today to speak in support of the Supporting Choice in Superannuation and Other Measures Bill 2025, brought forward by the Assistant Treasurer and Minister for Financial Services, and I commend him for doing so. Deputy Speaker, when I was 16 years old, I worked in hospo. I was young, enthusiastic and excited to join the workforce and to work hard for my future. My boss signed me up to a dodgy traineeship. If I was a trainee, you see, he could pay me less, and he got away with it. Look, I don't know whether there was malice, whether the employers at my establishment signed up all employees or just the young, enthusiastic and naive ones. I think it was just a program that, for my employers, was just the norm. But what I felt at the time, and what I know now, is that it wasn't fair and it wasn't right.
Shame.
This story is one I've told before in this chamber, and that's because for me, it was a really formative moment. I was young. It was the moment when I realised that employees aren't always treated fairly by their bosses, that an employer doesn't always have your best interests at heart. And it's when I learned the importance of not just advocating for employees, and yes, that's important too, but it's when I learned the value of actually having the right legislation and regulations set up and being adhered to, so that these types of situations are prevented from even happening in the first place. Deputy Speaker, I'm proud to stand here today because that is exactly what this legislation does. This bill is here to streamline the process for employees to choose a super fund when they start a new job. This is legislation to ban employers from advertising super fund products to new employees during their onboarding process. But it's about so much more than that. This bill is about empowering employees to make informed choices about their super funds when they start a new job. It's about workers' rights and about creating those laws and the type of laws I could have benefited at 16 years old, which protect hard-working Australians so they can secure their own futures. Because taking advantage of employees who don't know any better by compelling employees to make choices that are not in their best interest is simply wrong. I know this, and we as Labor know this. We are the party who are grounded in advocating for and legislating to protect the rights of workers, and this bill is no exception to that. Schedule 1 to the bill amends the Superannuation Guarantee Administration Act. This is the part about streamlining the process for choosing your super fund when being onboarded as a new employee. In 2021, Your Future, Your Super was a set of reforms introduced to improve the superannuation system. It was designed for a few reasons: to empower members and make it easier to choose a well-performing product that meets your needs, to hold funds to account for underperformance, and to increase transparency and accountability for how super funds use members' savings. It also introduced stapling. A stapled super fund is an existing super account linked or stapled to an individual employee, so it follows them as they change jobs. Having stapled funds is there to reduce your account fees and avoid to new super accounts being opened every time you start a new job. This bill will build on those reforms. It'll make it easier for employees to see, consider and select their existing super fund when they start a new job. This empowers employees by helping them to avoid accidentally paying double or triple fees, which can save thousands of dollars. Schedule 2 to the bill amends the Corporations Act 2001 to impose a ban on advertising superannuation products to employees during onboarding, with certain exceptions. It's ridiculous that when starting out in a new job, employees can have advertisements for super products targeted at them. Meanwhile, information about keeping their previous super account is not readily accessible. This is a key moment when employees engage with their superannuation and should be able to do so in an informed and safe way. And a ban on advertising superannuation products to an employee, specifically at the point of employee onboarding, is really important. These changes reinforce our government's commitment to supporting Aussies to make an informed choice about their super while providing strong consumer protections. We're protecting employees from being unduly influenced to make uninformed decisions, because Aussies should be able to trust their employer and the super system we're all a part of. Look, when you sign up to a new job, you're not always going to independently know all the fine details about all the available super funds and what's best to avoid. But that information should be accessible. Employees shouldn't be getting signed up to super funds that aren't necessarily right for them because their employer has compelled them to do so. And you know what? Employees should be able to trust their employer to not push super funds on them that are not in their best interests. They should trust the system because the system should be working for them and it should be protecting them. And if the system is in fact not protecting employees, then it's our duty as parliamentarians to change that. So that's what we're doing. This bill will create those changes for employees right across the country, including in my own community in Melbourne's western suburbs. My electorate of Gordon is one of the fastest growing electorates in the country. The average age is 35 years old. We are full of diverse, young, hard-working families, families who are setting up their children's futures and planning their own retirements. A good, hard-working community like mine doesn't deserve to be taken advantage of by their employees when they start a new job. They deserve to have proper access and transparency to information about their own super. They deserve to be empowered to make informed choices about their retirement savings, as do all Australians. Yeah. This bill is important for transparency, for employee empowerment, and for strengthening our superannuation system. But it's by no means the only measure the Labor government is taking to ensure Aussies are earning more and keeping more of what they earn, right up until retirement. We've passed payday super, a once-in-a-generation reform to fix unpaid super, because workers deserve to get paid their full entitlements, and Australians deserve to retire with confidence and with financial security. The ATO estimates that $5.2 billion in super went unpaid in 2021 to 22. $5.2 billion. That's $100 million every week that workers earned and never received. And thanks to this Labor government, from the 1st of July this year, employers will be required to pay super at the same time as paying wages, instead of paying it quarterly. It means that employees will receive their super in their funds within 7 business days of payday, and that workers will receive what they're legally owed. The legislation we're debating and passing here today complements those payday super reforms. That's because by giving employers more timely and accurate information, superannuation details, we're supporting their readiness for our payday super reforms. We're legislating these changes for workers because that's what Labor does. We are the champion of workers' rights, and we always have been. Yeah. I'm proud that this is not the first time that I've stood up in this chamber and talked about workers' rights. And that's because this is not the first bill that this Labor government has introduced to build better protections for workers. Late last year, we passed Baby Priya's bill. Baby Priya's bill introduced a new principle into the Fair Work Act to protect families and employees. It means that unless employers and employees have expressly agreed otherwise, employer-funded paid parental leave cannot be cancelled if a child is stillborn or passes away. At the heart of Baby Priya's law is dignity, compassion and workers' rights. The same can be said of our changes to protect penalty and overtime rates. This was about safeguarding fundamental entitlements for around 2.6 million modern award-reliant Australian workers. And there's the legislation I haven't yet had the opportunity to talk about in the chamber because it was passed in the last term of Parliament. And I'm so glad that I have the opportunity to talk about it now. Our same job, same pay laws have seen thousands of workers receiving up to $60,000 extra in their pay packets each year. Our secure jobs, better pay laws were about modernising the bargaining system to protect better pay and conditions for workers. The right to disconnect laws has adapted Australia's workplaces to meet the needs of what a modern workplace actually looks like. Meanwhile, we've criminalised wage theft. These are all such important changes for Australian workers, changes that go alongside our reforms to the superannuation system. Having lived in the Australia I know and love, it's sometimes surprising to remind myself that, not so long ago, superannuation wasn't legislated. It's only through the work of legislated change and Labor governments that we have the workplace protections that exist today. Under the Keating government, Labor introduced compulsory super to Australia and as part of the superannuation guarantee. And even the member for Riverina acknowledged the power of super in his contribution this evening here tonight, Deputy Speaker. Back then, we introduced compulsory super, and today we're strengthening it. But this is nothing new for us. Labor emerged directly out of the union movements. It was industrial action that paved the way for the weekend. We introduced annual leave and sick leave, the Fair Work Act, unfair dismissal protections and our paid parental leave scheme, all under the Rudd-Gillard years. And we've always championed gender equality. When we're talking about super, women really matter, because it's true. Women earn less and retire with less. The national gender pay gap is sitting at 11.5%. Women are more likely to take significant breaks in their careers, putting them on the back foot when they re-enter the workforce. Women are less likely to be promoted into high-paying management roles, and women have less savings in their super when they retire. The gender super gap is about $50,000 for Australians nearing retirement, $50,000 less for women to live out on their retirement, because nurses, teachers, aged care workers and hairdressers are amongst those in casual and insecure work. Part of the issue is that those women in those fields aren't getting their fair share of super. In Victoria, there is a 24% gap between men and women's super savings across all ages. But for my electorate of Gorton, it's wider than even that. In Gorton, the gender super gap is sitting at 26%, wider than the Victorian average and on par with the national average. This gap widens significantly as women approach retirement. The median man approaching retirement in Gorton has $181,000 in super. Compare this to the median woman. She's got $114,000 in super, 37% less. This is wider than both the Victorian and Australian averages by 33%. That's why the changes that this Labor government has made to women's earnings and super is so important. We've introduced LISTO, expanded paid parental leave, and we've ensured that women are now earning super on top of their paid parental leave. The low-income superannuation tax offset is an automatic tax rebate paid into the super accounts of low-income earners to offset some or all of the tax paid on their super contributions. It's 15% of the pre-tax super contributions you or your employer pays into your super fund, up to a maximum of $500. And it's designed to ensure that low-income earners generally don't pay more tax on their super contributions than on their take-home pay. We're increasing the LISTO by $300 to $800, and we're raising the eligibility threshold from $37,000 to $45,000. This measure is so important. It was about delivering a more secure retirement for 1.3 million Australians, 60% of which are women. That's because women are among those low-income earners. LISTO is boosting the income of close to 8,000 people in my electorate, totalling $3 million across the electorate. And it's helping close the gender super gap. To close that gap, we've also made significant changes to super when it comes to parental leave. You can be sure that this Labor government is working at closing that gender pay gap and gender super gap. And this is what happens when we elect women. Women's issues become the forefront of the government's agenda. I couldn't be prouder to be part of a Labor government made up of 57% women. Because when we elect women, we legislate on women's issues. Only our government will protect Aussie's super, because this bill is just one part of the Albanese Labor government's commitment for Aussies to earn more, keep more of what they earn, and to retire with more as well. I commend this bill to the House.
The question now is that the amendment be agreed to, and I call a member for Hughes.
Thank you, Deputy Speaker. Superannuation plays such an important role in securing the financial well-being of Australians, while also making a tremendous contribution to investment in the Australian economy. Superannuation has provided modern Australians with the financial independence that would have been unimaginable to any of the generations that preceded them. It's a system that has changed lives for the better, and it's a system built by Labor. The Treasury Laws Amendment Supporting Choice in Superannuation and Other Measures Bill 2026 builds on that legacy and expands on the financial independence that the superannuation system has provided to modern Australia. The measures in this bill support Australians where they are in their lives, whether they're starting a new job, saving for retirement, running a small business, building a winery, hosting a global sporting event, investing across borders, or donating to a cause they believe in. On this side of the House, we believe Australians deserve the choice and the confidence to make economic decisions with fairness and transparency at the forefront. This is particularly felt when we look at superannuation, because superannuation is one of the great Australian reforms. It's a Labor reform. It was built by a Labor government in partnership with working people. And for more than 3 decades, it has quietly transformed retirement in this country. Labor has always been and always will be the party of superannuation because we understand what it represents. It is not just something people ignore when they're working. It represents dignity in retirement. The difference between scraping by and living with security after decades of hard work. Let's be honest about the history of superannuation here. Those opposite opposed compulsory super at its creation. They delayed increases to the super guarantee. They described it as a burden. They tried to water it down. We lifted it to 12%. They froze it. We legislated the objective of superannuation so it cannot be quietly redefined. They warned of catastrophe. We are paying super on paid parental leave so that women are not penalised in retirement for taking time out to raise children. They voted against it. So when we speak about strengthening superannuation, we do so with credibility, because this is not an afterthought for us. It is core to who we are. And this bill continues that work. When we think about the moment when someone starts a new job, it is exciting, but it can be stressful. There's paperwork, tax file numbers, bank details, emergency contacts. There are systems to log on to, there are forms to sign, and somewhere in that process is a choice about super. In that moment, superannuation is often reduced to a tick box, a choice that compounds over 10, 20 or 40 years, a choice that can mean the difference between security and stress in retirement. Under earlier reforms, stapling was introduced so that workers would remain connected to their existing super fund when they moved jobs. Because for too long, every time Australians moved jobs, they automatically ended up with a brand new super account. That was an important step. It reduced the explosion of unintended duplicate accounts that were eating away at retirement savings through multiple sets of fees and insurance premiums. But the system can work better. Right now, too often, people are asked to choose a fund without clearly seeing their existing one in front of them, or they are presented with options in a way that is not neutral. We know that we can do better to streamline the choice of fund process. Changes like the one in Schedule 1 of this bill, which allows employers or their onboarding providers to request an employee's stapled fund details from the ATO earlier in the process. That means when a worker is completing their onboarding, they can see their existing fund details clearly and make an informed choice. Not a rushed choice, not a choice made in confusion, but an informed choice with all the relevant information available. Let's be clear, choice remains. Workers can choose any eligible fund. What we are doing is ensuring that choice is based on transparency, not confusion, because superannuation is not a retail impulse purchase. It's a lifetime investment. A few percentage points in fees compounded over decades can mean tens of thousands of dollars in retirement. During a review of earlier reforms, it was discovered that some onboarding software providers were being paid to promote specific super products to new employees during the onboarding process. Sometimes products linked to the software provider itself. If we reflect on that, a worker is starting a new job, they're required to provide their details. They are navigating unfamiliar systems, and in that moment, they are showed paid promotions for superannuation products. That's not a level playing field. That's not informed consent. That is commercial influence at one of the most vulnerable points in the process. Superannuation is not a streaming service. It's not something that should be marketed to someone while they are navigating the first day of employment. So we're putting a stop to it. This bill introduces a targeted ban on superannuation advertising during onboarding. It's the end of stealth marketing at the point of employment. It's the end of commercial steering disguised as administration. Employees will see their stapled fund, and they will still see the employer default fund. Certain My Super products can be displayed if they pass the annual performance test, are advertised by an unrelated party, and are accompanied by clear disclosures. When a worker is providing their super details to an employer, that space should be free from inappropriate influence. That is what it means to govern in the public interest. Last year, this Parliament passed the payday super legislation. That reform is a once-in-a-generation change to fix unpaid super. The Australian Tax Office estimates that $5.2 billion in super went unpaid in 2021 to 2022. That is $100 million every single week that workers earned, but they never received. Let's reflect on that. Every week, $100 million of Australians' retirement savings simply not paid out. Unpaid super disproportionately affects younger workers and those in insecure work, casual employees, part-time workers, people in industries with high turnover. These are Australians who can least afford to miss out on retirement savings. In a typical ATO investigation of an unpaid super case, a worker has missed out on nearly 2 years of contributions. For an average 35-year-old, failing to recover that money could reduce their retirement savings by around $32,000 in today's money. If an employer goes bust and super is never recovered, the impact is even worse. For that same 35-year-old, their retirement balance could be more than $90,000 worse off in today's money. That's not an abstract concept. That is real money. It could be a future home deposit. It could be someone's medical costs. It could be someone's dignity in old age. From 1st of July 2026, under payday super, employers will be required to pay super at the same time as wages rather than quarterly. Super contributions must be received by the employee's fund within 7 business days of payday. That change does 2 things. It makes it easier for employees to track their super in real time, and it allows the ATO to detect missed payments earlier, before debts spiral out of control and become unrecoverable. The legislation also strengthens the super guarantee charge. Under the new framework, if an employer fails to pay super in full and on time, the charge applies for each payday missed. It includes notional earnings compensating employees for investment returns they missed out on due to late payment. It includes an administrative uplift reflecting the cost of enforcement and incentivising voluntary rectification, with reductions available for employers who come forward and have a good compliance history. It includes choice loading, an additional penalty if the employer fails to pay into the employee's chosen fund. And for those who persistently fail to pay, even after the ATO has raised the charge, penalties of up to 50% of the unpaid amount can apply. These are serious consequences because unpaid super is a serious issue. Super is workers' money, and under this government, we are making sure that it is paid on time, every time. These reforms do not stand alone. They sit alongside the expansion of the performance test from around 80 products to more than 800, driving accountability and transparency across the system. They sit alongside the financial accountability regime and stronger reporting standards. They sit alongside paying super on paid parental leave, Piece by piece, reform by reform, we are strengthening this system. And we do so because we understand something fundamental. Superannuation is deferred wages. It's not a gift from the government. It's not a bonus from employers. It belongs to the people who earned it. And it deserves to be protected as fiercely as wages in a pay packet. When you look at Schedules 1 and 2 of this bill alongside paid day super, a clear theme emerges. We are strengthening super at the point of choice and at the point of payment. We are protecting workers when they start a job, and we are protecting them when they get paid. For small businesses across communities like mine in southern Sydney, certainty and clarity now reduces headaches with compliance later. These reforms provide the right information at the right time. They are sensible, modern changes that reduce friction and help ensure our superannuation system runs smoothly for employers and employees alike. This is what responsible economic management looks like. Each reform strengthens the system. Each reform protects workers. Each reform reflects a simple belief that retirement security is not a luxury. It is a right earned through hard work. It is about understanding that fairness and growth are not opposing forces. They are mutually reinforcing. Those opposite will look at superannuation and see a cost to the system. We look at it and see dignity. They look at it and see consumer protections and see regulation. We look at them and see fairness. We look at global events and see tax. They will look at global events and see tax concessions. We look at them and see jobs, participation and national pride. This bill is another step in building an economy that rewards work, protects savings and positions Australia confidently on the global stage. Australians want to know that when they work hard, their retirement savings are protected. They want to know that the system is not quietly chipping away at their balance through unnecessary duplication. They want to know that when they start a new job, they are not being funneled into a product because someone paid for placement in an onboarding portal. They want fairness. They want transparency. They want confidence. This bill delivers that. It strengthens the moment of choice. It protects the integrity of the process. And it reinforces a reform agenda that puts workers first. Superannuation is one of the great Australian achievements. It did not happen by accident. It happened because a Labor government believed that working people deserved more than the bare minimum in retirement, and we are determined to ensure that that belief continues to shape policy, protect workers and strengthen retirement security for generations to come. I commend the bill to the House.
The question now is that the amendment be agreed to, and I call a member for Brisbane.
Thank you, Deputy Speaker. I rise in support of the Treasury Laws Amendment supporting choice and superannuation and other measures bill. Now, this bill introduces important reforms to superannuation and tax laws to implement our election commitments, streamline systems and processes and reduce compliance costs for taxpayers. So let's start with super. Labor is the party of superannuation. Why? Because Labor is the party for workers. And let's look at some history. Superannuation in Australia began as a limited benefit salary for white-collar workers, gradually expanding through the union-negotiated industrial awards until the early 1980s. Now, a major shift occurred in 1983 with the then support of the Labor government under the leadership of Bob Hawke. That government was an architect and proponent of the Prices and Income Accord, which exchanged national wage rises for a 3% superannuation contribution, laying the foundations for universal coverage. Now, the most significant reform followed in 1992 under the Keating Labor government. That recognised our ageing population and the unaffordable strain the growing age pension payments would have on the Australian economy. So as a result, the superannuation guarantee, a compulsory employer contribution, was introduced. Starting at 3%, it became a part of a three-pillar retirement income system. Now, although Keating proposed compulsory employee contributions from 1997, this element was cancelled by the Howard Liberal government. Subsequent governments built on or altered these foundations. The Howard government allowed the employer super guarantee rate to rise to 9% in 2003 and restricted super guarantee calculations to ordinary time earnings. It was the Rudd-Gillard government, a Labor government, that later legislated to increase the guarantee from 9% to 12% between 2015 and 2019. But, as history says, it was the Abbott government, a Liberal government, that deferred these increases by 6 years, pushing the commencement to 2021. Now, these deferrals and reversals are typical of the LNP, who have a track record of not supporting workers. Now, more recently, the super guarantee rate reached 10.5% in 2022, and guess who was in government then? Yes, the Albanese Labor government, and it's reached 12%, supported by reforms aimed at improving fund portability and performance. This Labor government has also legislated superannuation be applied to paid government parental leave.
Order. It being 7:30 p.m, I propose the question that the House do now adjourn, and I call a member for Flynn.
Thank you, Deputy Speaker. There are many unsung heroes in the electorate of Flynn that often leave for work in the dark and return home in the dark. These heroes work in the mining and resource, gas, heavy industry and agricultural sectors. And I call them heroes, as they are the men and women who keep the lights on, build the product Australia and the world needs, and grow the food and fibre that we eat on our plate every day. I want to dedicate my speech to these hard-working men and women because I'm sick to death of successive governments treating them like their industries are cash cows, demonetising their work and putting their futures at risk. Deputy Speaker, according to the Queensland Resources Council in 24-25, the resource sector made a contribution of $115.2 billion to the Queensland economy, supporting jobs, businesses, infrastructure and services that benefit communities across the state. In the electorate of Flynn, the resource sector in the same financial year supported over 38,000 local jobs and produced a gross regional product of $8.2 billion alone. So what does this Labor government think about this critical industry? In 2019, now Deputy Prime Minister said, and I quote, "I mean, the global market for thermal coal has collapsed at one level, and that's a good thing, because that implies that this world is acting in relation to climate change." Deputy Speaker, in the Flynn electorate there is the CSG gas industry producing approximately 25 million tonnes of liquefied natural gas, which is exported to the world through the port of Gladstone. An estimate of this export value is around $7 billion alone each year. However, you would think that all of this gas in the market that Australia would have a thriving domestic industry. Well, not in Victoria, where the Labor state government has given the provisional green light for a fuel supplier, Viva Energy, to build a floating gas import terminal. Australia has an abundance of gas, but Victoria has gone so far backwards under Labor that this new refinery will aim to receive shipments of liquefied natural gas from my home state of Queensland, as well as Western Australia, and from overseas for use in their local network. And you can't make this stuff up, Mr Deputy Speaker, when governments need to subsidise gas import facilities in a country like Australia. Deputy Speaker, Gladstone is known for being the heavy industry powerhouse, primarily due to the alumina and aluminium industries. This includes the Yarwun Alumina Foundry, QAL and the Boyne Smelter, with around 4,500 direct jobs, making up 16% of the workforce of the Gladstone region. Furthermore, NRG, which is the Gladstone Power Station, employs approximately 250 people, encompassing trainees and apprentices and a further 100 contractors on site at any time. This power station provides most of the energy to the alumina and aluminium industry in Gladstone and is vital for 24/7 power generation. What does the heavy industry future look like under this Labor government? Well, firstly, Yarwun and QAL refineries, as well as the Boyne Island smelter, are included in Labor's carbon tax hit list, also known as the safeguard mechanism. This means that they are literally taxing our manufacturers to reach their emissions targets. Yet at the same time, we've had to give handouts to the Tomago alumina facility near Newcastle to keep their doors open. The Gladstone Power Station has also signalled it could close as early as 2029. The early closure of the Gladstone Power Station will be devastating to Gladstone. It supplies approximately 80% of its power production to the alumina sector and to the Port of Gladstone and the heavy industry there. Now, here's an example of the Labor government's contempt for our agricultural industries following their crusade to close down the live sheep export trade. The Prime Minister shocked the AgriFutures Rural Women's Award Gala dinner at Parliament House when he said he'd dined earlier with the Indonesian President-elect earlier. The Prime Minister stated, "When we had dinner, beautiful Australian beef, not live export, we made sure it was dead." So put simply, the Prime Minister chose the AgriFutures Award, a night celebrating our agricultural sector, to mock and phase out the live sheep export industry. Deputy Speaker, do these people have any idea what they're talking about and how their actions have detrimental effects on rural people in regional Australia? I believe the answer is a comprehensive no. For me, I'm very proud of our traditional industries, particularly in Central Queensland, and I'm always committed to fighting for the future of Central Queensland and its people and its industries.
The question is that the House do now adjourn. I call the member for Macquarie.
Thank you, Deputy Speaker. When the Emu Plains Girl Guides told me they were fundraising for a new street library outside their guide hall, I was very happy to help make that happen. It's a work of art, built by members of the Nepean Men's Shed, painted bright yellow and even featuring planter boxes on either side. The official launch was great fun, and I love seeing young people valuing the good old-fashioned paper book as an alternative to screen time. The artworks painted on the street library draw inspiration from the local Darug people, choosing symbols which represent guiding and Emu Plains. And they include women sitting, a meeting place, teaching, a campsite and friends. Take a book, read a book, leave a book is their motto, and I'd encourage kids in the area to do just that at the Emu Plains Girl Guides Street Library on Nepean Street. Speaker, each year the Penrith Museum of Fire holds an art competition for primary-age children. In the 2025 awards, the theme was Trailblazers, marking 40 years since women were first formally allowed to join the New South Wales Fire Brigades, as it was then called, as firefighters. As Special Envoy for the Arts, I joined parents, families and children at the official awards event in January, and I admired the artwork celebrating the courage, achievements and enduring legacy of the women who stepped forward, broke barriers and helped shape the modern fire service. 2 of the awards were won by Blue Mountain students. My Mum the Firefighter by Cole Brown from Lura Public School won the highly commended award for Year 2 students. Cole's artworks depict his mum in uniform and wearing breathing apparatus, with smoke, a fire engine and a drone overhead. His very proud family were with him when he accepted his award. The People's Choice Award was won by Elsie Kuhn, who's in kindergarten at Blue Mountains Grammar, for her work Girls Can Do It. This was voted for by the public, and in her own words, girls can do anything and help each other, look after people and animals. Firefighters are brave and strong, especially girls. This is a drawing of my auntie and I saving the day. It was a beautiful work of art. The theme for this year's competition at the Museum of Fire is Dogs in Firefighting, and I am looking forward next January to seeing the shortlisted works, and I'd encourage every student in every school around the country to enter. It is open to everybody around the country, maybe around the world too, but definitely around the country. Speaker, it was a sad day at St Matthew's Anglican Church where we joined Narelle, the wife of Merv Ward from Upper Colo, and their family and friends to honour his life. Merv was 92, and I'd like to take this opportunity to recognise the service he gave to our community over many, many decades. I've known Merv and Narelle through their many community activities over the last 10 plus years, from the Hawkesbury District Agricultural Association, the Hawkesbury District National Servicemen's Association, the Upper Colo community, and through bushfires and floods. Merv's history of service began way back in 1952 when he was called up to national service. Choosing to remain in what we would now call the Army Reserve until 1960, he then served as a civil defence warden right through to the early 70s. We also honoured his service as a NASHO at last Sunday's National Servicemen's Service, which Merv and Narelle have led for many years. Narelle continued to do him proud. As well as being involved in community organisations like the Upper Colo Progress Association and the Colo Ratepayers Association, in the 60s, Merv helped form the Hawkesbury Potato Growers Cooperative, an attempt to realign the imbalance of power in the wholesale fruit and vegetable markets, something that resonates with us still today. He was part of the Bushfire Brigade service, giving his shed to firefighting appliances rather than his own tractor because there was no actual brigade. That's the kind of person he was. Merv was also a key member of the Hawkesbury District Agricultural Association, serving as a senior executive for almost 30 years. Merv was well known, well loved. He was a character and he will be missed.
The question is the House to now adjourn and give the call to the member for Groom.
Thank you very much, Speaker. I wanted to use this opportunity to address the comments Grace Tame made this week, and in doing so I want to acknowledge the Prime Minister's call for us not to politicise this, to have a very cold and calm conversation, and indeed your direction, Speaker, about how we talk on these things in this place. I think it's a really important conversation for us to have, and it's one that matters to me deeply. I spent the best part of 10 years of my life living in the Middle East, working in the Middle East. I have friends in Israel, I have friends right throughout Palestine, through Jordan, Michelle Ramadan, I think of often in these situations. And I think they'd be amazed, Speaker, at how much attention this conflict gets in Australia. And I think they would be even more amazed to see how uneducated we are when we talk about it. Speaker, I arrived in Jeddah shortly after the end of the Second Intifada. And the scars of that conflict were felt right across the region. I remember having a young Syrian girl working for me who had scars on her shoulder. She wouldn't wear the full niqab because it was important for her to show her scars, because that was part of her story of who she was. And when she came into the office, a Western office, she wasn't required to wear that. She was allowed to get away with that back in that time. And I remember just thinking, this is the bravest person I have ever met in my life. Because as soon as she stepped outside of that office, Saudi religious police would force her to cover up. But it was important to her that people understood her story and understood what the Intifada meant, what it did in her region. And that this was not some happy Che Guevara wearing rebellion. This was a bloody, horrible, violent uprising that involved, where suicide bombers really came to the fore in Palestine, rocket attacks, gunfights in the streets. There was somewhere around 5,700 Palestinian victims. Over 2/3 of those were civilians. There's about 1,000 Israeli victims. About 70% of those were civilians. And many of these died in horrible circumstances. I remember I've had one experience in my time in the Middle East of seeing the result of a suicide bombing. It was at the Al-Aqsa Mosque on the eastern side of Saudi Arabia. I was driving to Bahrain to get my monthly stamp in and out. As I came back, I drove through the aftermath of a suicide bombing in this mosque. My memory is of dust, black dust everywhere, and intense sorrow and wailing as people were walking around clearly trying to get their bearings, having just walked out of a room that was blown up. There was blood, glass, bits of people across the road. No one was celebrating. This wasn't something that you celebrate. These are horrible, horrible events. That is what the Intifada is. And I don't think Ms. Tame, I don't think she understands that. I think this is a slogan, and what why I wanted to raise this, because I had to raise this conversation with my own daughter, a 16-year-old girl, describing this because it's not taught. The Intifada is some cool word. It's the idea that there's some great struggle and we're all going to be part of it and it's great and it's happy. It's bloody horrible. And these are real people and they're butchered and murdered in horrible ways. And for someone to call for that, firstly, it clearly rises to the level of incitement to violence under the New South Wales Crime Code 1900, clearly meets that threshold. This isn't just calling for someone to steal a loaf of bread because they're hungry. This isn't calling for someone to take out an act of white-collar justice. This is a call for the most gruesome butchery of people, exactly as we saw at Bondi. And it's about time we started to call this sort of stuff out. And it is right that the Prime Minister talked to us about depoliticising this, because this should not be a political issue. No one should ever accept that that's a call to arms in Australia, and that's something that we should accept in our country. I think it is absolutely disgraceful. It should matter to us, and we should be informed on the issue.
The question is the House do now adjourn and give the call to the member for Braddon.
Thank you, Mr President. Mr Speaker. I rise today to speak about the Albanese Labor Government's unwavering commitment to giving every Australian child the best possible start in life. Because where a child is born or what their parents do for work should never determine the quality of education and care they receive in those critical early years. We know the evidence is clear. Quality early learning lays the foundation for lifelong health, learning and well-being. It supports children to thrive at school, strengthens families and builds stronger, more productive communities. That is why the Albanese Labor Government is investing in early childhood education like never before. In August last year, I was notified of Catholic Care's decision to close the only childcare centre in Latrobe in my electorate of Braddon. This was devastating news. 55 families were suddenly left worried about where they would get care. 23 dedicated staff were left facing uncertainty about their future. And for an entire community, the closure of St Patrick's Childcare Centre meant the loss of a vital local service. The centre was the only service of its kind in Latrobe. There was no alternative providers in town. Families were forced to look outside of their own community for care, often to centres already stretched with long wait lists and limited capacity. That was simply not acceptable. So I worked tirelessly alongside Latrobe Council, Lady Gowrie Tasmania and the Tasmanian Government to find a solution that put families first. And thanks to the Albanese Labor Government, we delivered exactly that. Through the Community Childcare Fund, Lady Gowrie Tasmania was awarded $334,000. Combined with $200,000 from the Tasmanian Government, this funding ensured that Latrobe had ongoing access to high-quality early learning and care. This investment delivered real and immediate relief for local families impacted by the unexpected closure. And I'm pleased to announce that the temporary facility will open this Monday, the 16th of February. This is an important milestone for Latrobe because it means children can once again access the early education opportunities they deserve close to home in their own community with the same educators that they've been used to and working with and that parents support. But this is not an isolated investment. During the 2025 election campaign, we committed up to $4 million to Malanjena Centre in Devonport to double the number of places to 150. There has been a historic investment in early education for Tasmania, one that will strengthen our regional communities, support working families and ensure more children get the very best start in life. The Albanese Government and the Tasmanian Government have reached a landmark agreement delivering $25.5 million through the $1 billion Building Early Education Fund alongside a further $5 million from the Tasmanian Government. This partnership will significantly expand not-for-profit early learning services right across our state. As part of this investment, the Albanese Labor Government will provide $4 million for a brand new early learning service at St Mary's District School in Lyons, creating 24 new places for local children, $3.5 million for a new service at Bruny Island District School, delivering 20 new places for families on the island, $3 million for Bothwell District High School, providing 20 new day-long care places for families in the Central Highlands. The two governments will also work together to deliver a new early learning service at Huon Primary School, further strengthening access to care and education in the Huon Valley. The Building Early Education Fund is designed to target areas of greatest need, particularly regional communities and outer suburbs, where access has been limited for far too long. It means more families can access quality, affordable early learning right close to home. It means less pressure on parents, and it means stronger local communities, because these investments are not just about buildings. They are about supporting parents to participate in the workplace. They are about strengthening the economic future of regional Tasmania, and they're about ensuring that every child, no matter where they live, that has access to opportunities that set them up for lifelong success. This is what Labor governments do. We invest in families, we invest in communities, and we invest in the future of our young Australians to give them the best start in life. And we know that early education provides that support for our young children and gives them a real head start in life when they go through an early education. And I'm really happy that we have supported that right across Tasmania, but particularly in the electorate of Braddon.
The question is the House to now adjourn and give the call to a member for Monash.
Mr Speaker, I am proud to represent a region that grows, makes and manufactures things from the Latrobe Valley to West Gippsland and Bass Coast, through to South Gippsland and the southernmost point of mainland Australia. Our region contributes 23% of the nation's milk output, 26% of Victoria's beef production, over 60% of Melbourne's water, and through the Latrobe Valley power stations, we are still well over 60% of Victoria's baseload electricity. People in my electorate spend long hours on their feet, from retail shops through to manufacturing businesses, and they work with their hands in farms and shop fronts, making things, producing things the rest of our country relies on. When my electorate of Monash does well, the rest of our state succeeds and our country thrives. But right now, people in my community are telling me they've never done it tougher. Families tell me it's never been harder to raise a family. Businesses tell me they've never worked longer and faced more risk and red tape for less reward. And young people tell me it's just too hard to get ahead. That dream of home ownership is getting further and further away under this federal government. I want to talk about the cost of living, because the economy is central to being able to maintain a standard of living, to maintain our competitiveness as a nation globally, and to give young people their best shot at a strong, secure and stable future. Regional communities are facing structural challenges across many fronts. Greater distances between services. And Mr Speaker, I've spoken a number of times over the last fortnight on digital connectivity and mobile black spots in my electorate, where those difficulties are getting harder and more immense and less serviceable under this government. Housing is a huge issue for many people in my electorate, from families to young people. Rental vacancies remain tight. Young people who grow up locally are finding it increasingly difficult to secure housing, let alone save for a deposit for their own home. And when supply is limited, even modern increases in demand can push prices well beyond what local wages can sustain. Energy costs are a huge burden, and we've seen under this government, member for Casey is at $275 in bill relief. $175, still waiting. Still waiting after nearly 100 times are we up to that we were promised that bill relief. Well, I can tell you, member for Casey, families in my electorate are telling me, from Druin to Warrigal to Moe, Leongatha, Wonthaggi, Phillip Island, they're telling me that they're having to make some really hard choices right now between buying food to put on the table and between being able to pay a bill on time. And I appreciate the minister's interjection, because I'll take it. under this government that he is a part of, energy bills are going up and belts are being asked to be tightened. But this government is spending $500,000 a minute in repaying debt. The rest of us are having to foot. I want to give a shout out to educational support staff who on very modest wages are doing an extraordinary job in many schools across my electorate. They are really stepping up because under this Victorian Labor government we've got overcrowded classrooms. There are many challenges that young people and students are facing, and those educational support staff are passionate about their jobs and they are committed to helping the young people that they work with. And on that note, I want to acknowledge the joint winners of South Gippsland Shire's Young Citizens of the Year, Erica Beggs and Rhiannon Rawlings, who I had the pleasure of meeting a few weeks back in Meenian. They've shown outstanding leadership, dedication and community spirit right across the South Gippsland Shire. They are both known for their volunteering spirit, their outstanding leadership. Rhiannon is at Currumborough Secondary College, and they're both doing incredibly important work. I think they're leaders of the future. I am so impressed and so proud to represent them and all young people across the Monash electorate, who I will continue to work my heart out for, because we live in the best country, the best region in the best country on earth.
The question is the House to now adjourn and give a call to the member for Menzies.
Thank you, Speaker. Recently in Menzies we held the Manningham Chinese New Year Festival at Jackson Court to welcome the Year of the Fire Horse. It was a wonderful day filled with rides, delicious food, cultural performances and possibly the best lion dance I've ever seen, as well as a fantastic fireworks celebration at night. I want to thank the Minister for Multicultural Affairs, Anne Ali, for joining me there. She received a warm welcome from members of my community. We chatted to the stall holders and we were even gifted some beautiful Chinese calligraphy. This is the first of two events we are delivering as part of our election commitment of $200,000 for local multicultural festivals. Events like this are about more than just having fun and enjoying great food, although there was plenty of that. They are about celebrating culture and building understanding and bringing people together. They are about social cohesion. They reflect the Albanese Labor government's commitment to our multicultural communities and to social cohesion. I want to thank Bi Hong Wang, Richard Shi, Tim, Sean, Charlie and everyone from the Asian Business Association of Whitehorse for their leadership, dedication and hard work in bringing this festival to life. It was also an important way of supporting our local small businesses. I want to thank the Jackson Court Traders Association for their engagement with the event. Your collaboration and generosity helped create a welcoming and vibrant atmosphere for everyone who attended. The second part of our $200,000 commitment will deliver the Box Hill Chinese New Year Festival, to be held on the 21st of February along Bank Street in Box Hill. On that day, the streets will come alive with colour as lanterns and traditional decorations transform the heart of Box Hill into a vibrant showcase of culture and community. It reflects the many communities that call our area home, including Chinese, Vietnamese, Korean and others, each sharing their traditions, stories and spirit. Some will come for the food, for Korean kimchi pancakes and Japanese takoyaki, into Chinese steamed buns and Vietnamese banh mi. Some will come for the music and traditional dances, drawn to the rhythm and sound that carry through the streets. When we gather like this, it strengthens and shapes the modern Australian story. It shows that culture is not distant, but lived, shared and experienced together. Festivals like this are more than just dates on a calendar. They demonstrate that while we come from different backgrounds and traditions, we can not only respect but celebrate our differences. That is social cohesion in action, built through inclusion and acceptance and a shared sense of belonging. These celebrations across our electorate reflect a broader strength in our community. This Saturday, I attended the United Muslim Migrant Association Mosque Open Day in Doncaster East, which provides an opportunity for the broader community to visit the mosque, learn more about Islam and engage in open and respectful dialogue. It was a welcoming event with generous hospitality and thoughtful conversations. Members of the community were invited to ask any questions that they might have, and the religious leaders were open to answering them and answered them with grace and with patience and with expertise. Members of our community came together in a genuine spirit of connection. I was accompanied by Vicky Ward, the member for Eltham, and Sonia Terpstra, the member for the North Eastern Metropolitan Region. I want to thank Ahmed and the organising team for their warm welcome and leadership in hosting the day. This has been a difficult time for the Muslim community, and Ummah's dedication to holding this event demonstrates the truth that Islam is a religion of peace, compassion, and moral integrity. In a time of increasing misinformation and polarisation, this openness and graciousness is exactly what we need to build deeper understanding and reinforce social cohesion. I want to thank again Ahmed and the organising team from Ummah for being so open to our wider community and their commitment to building understanding and building bridges and building social cohesion. Thank you.
The question is the House to now adjourn. I give the call to the honourable member. Oh, my apologies. It being 8 p.m, the House stands adjourned until 9 a.m. tomorrow.